All right, we're good to go.
The COGCC commission meeting will come back to order. This is our second day, actually third day here in Greeley. And Ms. Larson, would you conduct the roll call?
Be happy to. Commissioner Boygan.
Here.
Commissioner Eaton.
Here.
Commissioner Gibbs.
Here.
Commissioner Hahn.
Here.
Commissioner Hopkins.
Here.
Commissioner Jolan. Here. Commissioner Mesner.
Here.
Commissioner Overturf.
Here.
Commissioner Putnam.
Excused.
Mr. Chair, you have 8 out of 9 commissioners present.
Great. Thanks so much. We'll jump right into the testimonies. And first up, we have Logic, Sierra Club, Together Against Neighborhood Drilling, Broomfield Health and Safety First, the Larimer Alliance, Weld Air and Water, and the Oil and Gas Education Group. So, Sarah, you want to kick it off?
Yes, thank you.
And for the record, please introduce yourself.
Yep. My name is Sarah Laughlin, and I'm the Executive Director of the League of Oil and Gas Impacted Coloradans, and I'm here today with my colleague, Andrew Forks-Goodmanson. And we're here today on behalf of Logic, the Sierra Club, Broomfield Health and Safety First, the Oil and Gas Education Group out of Broomfield, Together Against Neighborhood Drilling, Weld Air and Water, and the Larimer Alliance. We thank the staff and commissioners for that hard work you put into the rules, and we're generally pretty excited about them. Our state, in particular, the Denver metro area and the Front Range, is among the fastest developing in the nation. Adams County, Arapahoe County, and even Weld County are at the epicenter of our population growth. And while we have our stances regarding the vast amount of new development that has been proposed for these areas, we would be remiss if we did not recognize that there is continued conflict and risk between both existing and any proposed oil and gas development and residential and community development across the state and across the Front Range. The first call I received after we launched Logic in January of 2016 was from a concerned mom in Thornton. She had noted a large pile of rusted pipes and soil discoloration across the fence line from a park they dubbed the Little Kids Park in their neighborhood. She was concerned about whether or not it was safe for the kids to continue to play in this park where there was soil discoloration and a substantial pile of pipes. So she began making phone calls. First, she called the city, who referred her to their local government designee. The local government designee told her he had no idea and referred her to the Colorado Oil and Gas Conservation Commission. She called the COGCC, who then referred her to the operator. The original operator, or the operator on file with the COGCC, hostilely let her know that the asset was being transferred and she needed to make the call to the acquiring operator. The new operator for the site referred her to the original operator, as the agreement was that the original operator was responsible for reclamation of the assets and dealing with defaults in the assets. The original operator then was hostile toward her and referred her to the testing lab, where they were conducting soil and water testing regarding the impacts that were happening there. This mom, who did not have a history in oil and gas, was told with the testing lab that there had been a historic flow line release at the site, and that they would send her the chemical testing results and the data results. She then received a packet that was several hundred pages long of chemical data sheets and information regarding what was in the soil. Now, to the average mom, they would likely stop there at, I don't really know what's going on. However, this mom realized that words like benzene and above recommended levels were kind of scary terms. And so she started back on her phone call train. And she asked the operator what was going on and what all of this meant. And the operator then referred her back to the COGCC complaint line. That if she had a problem and she really wanted an answer, she needed to complain formally to the COGCC. So she did, and the COGCC sent an individual to tell her what it meant, that there was indeed benzene and a number of other chemicals present in the soil. That historic flow line release means that they were unsure of the history or the origin of the leak and of the breakdown, and that They were unsure of the surface water contamination because they were unsure of the origination of the leak, and the time frame was unknown, but remediation measures were being taken by the operator. 2 years later, upon inquiry, this mom came to find out that benzene and several other contaminants continued to be present in the soil that was across this fence line from this well site. And the neighborhood was never informed about the possibility of exposure, the proximity of the flow line to the system to the park, or the basic safety of the park and for children playing at this park. Now, this mom was tenacious and was willing to push for more information, and was willing to push harder than most other full-time working parents would be in her neighborhood. But others also informed her that they had wondered and had no idea who to even begin to call. So I tell you the story to underscore the importance of mapping and ensuring a uniform system under which local governments and the COGCC can at the very least inform residents as to the location and risks regarding flow lines and flow line systems. I tell you this to underscore the importance of accountability and continuous monitoring for flow lines and flow line systems. And then we go to a more serious note. In May of 2017, I recall very vividly when former Governor Hickenlooper earnestly went before cameras and said never again, and required that a series of rulemakings take place that we thought would require consistent testing and sufficient mapping of flow lines, or their removal upon abandonment moving forward. In our opinion, this was an administration promise that was broken, and you have an opportunity to fix that today and tomorrow. The COGCC and local governments have a responsibility to at the very least be informed and to inform residents and developers of their proximity to flow lines, flow line systems, and flow line routes, and the risks that that entails. They cannot do that without comprehensive mapping at decent resolutions. And frankly, that mapping should be available to the public so that the public can make informed decisions. That mapping should account for shapefiles in addition to geopoints, and frankly, the public does have a right to know. The COGCC and local governments have a responsibility to protect public safety and account for the integrity of full oil and gas systems, of flow line systems. Therefore, it is incumbent on the flow line system to be regularly pressure tested and inspected for leaks using the best technology available. The results of all of that testing should be housed and searchable and publicly available. Finally, to protect public safety, it is imperative that abandoned flow lines and well infrastructure be removed. With that, I would like to turn the remainder and the more technical portions of our presentation over to Andrew Forkas-Goodmanson. Thank you.
Thank you. My name is Andrew Forkas-Goodmanson with Logic. I'd like to start the second half of this by again thanking the staff and the commission for the obvious amount of work that went into this red line and all the previous versions and all the work that's gone on behind the scenes here. And to also thank you for the work done yesterday and for the diligent line of questionings, which, as you can see, added a lot of notes to the presentation that I have for you here today. So as a quick summary of our positions, there are 4 basic things that we're asking for. 1 is comprehensive mapping. 2 is public disclosure of those maps, and I'll clarify further with saying meaningful public disclosure. The second is regular pressure testing, leak detection, and inspections. And third is identification, identification and removal of abandoned wells and flow lines once they're no longer in use. So comprehensive mapping. A lot of ink was spilled on this topic in pre-hearing statements and responses, and a lot of conversation was had yesterday. So let's dig in. The purpose of comprehensive mapping is to build a complete and accurate picture of the oil and gas industry as it exists on the ground today. Keywords there are accurate and complete. As Colorado's population expands and the oil and gas industry continues to grow, the interaction between people and oil and gas becomes more complicated. It's incumbent on the COGCC to maintain an accurate, real-time database of all of this infrastructure so that we can make informed decisions. When I say we, I mean a very broad we, from individual people buying homes to developers planning developments to communities planning, to towns and counties planning growth, and to you when you make decisions regarding oil and gas. So accuracy is important. Staff in their red line in their presentation proposed a compromise of plus or minus 25 feet for reporting location data. When I'd written this the first time, I wasn't sure what that compromise was between, and now having listened to that robust conversation, I'm a little better informed, but I'm still troubled by the fact that this creates a 50-foot swath of land where a pipeline might be. And that's a big area, especially when prepared with the resolution that staff has proposed, which I'll get to in a minute. The point of this is that the point of this rulemaking is to know where flow lines are, not to guess where they might be. The industry said that it's too hard to pinpoint these lines with any precision. That doesn't mean it isn't worth doing, and that doesn't mean that we shouldn't require them to do it. So we urge you to require as accurate of information as possible. The 18 inches of horizontal location variance allowed by the 811 system is a great start. But there's a lot of distance, literally, between that and the 25 feet that has been proposed by staff. For what it's worth, though a 50-foot swath might look small on a 1 to 6,000 resolution map, it's bigger than my backyard, which means I have a small backyard, but it also means that if I go to the COGCC and look at my house on the detailed maps that are going to be available, I'll just see a block as big as my house, which is informative in the sense that I know there might be a pipeline somewhere back there, but I don't know if it's actually in my yard or my neighbor's yard or my neighbor's yard. So this is a point that's been made in addition to what was said yesterday. We spent a lot of time talking about how do we locate these pipelines. Some pipelines, I'll concede, are going to be really hard to find, but let's start with what we know. Post 1996, all these flow lines had a tracer line. So let's require plus or minus 3 feet for these lines that we can find. If you have a metal flow line, let's find it. I feel like that's a relatively simple addition to the rule, that materials-based location should be as accurate as possible. And that if a flow line was installed post 1996 and has a tracer line, they have to provide plus or minus 3 foot or 1 meter, or whichever unit of measure we want, so that we can find these pipelines. So let's move on to public disclosure. Making this location data available to the public is the core of the SB 181 mandate. I'm heartened to hear that there's been I'm heartened to hear that much of the debate has been focused on the resolution of the map and not on the creation of a map. This is a great place to start, and I also appreciate the approach that staff has taken on this matter and the large amount of considerations that has gone into it. That being said, SB 181 didn't direct you to create a reference tool or a screening tool. It directed you to disclose flow line locations to the public. The final red line offers a resolution of 1 to 6,000, which comes out to about 1 inch on the ground, or on the map, equaling 500 feet on the ground. When paired with that fuzzy location data, this resolution becomes nothing more than a rough screening tool. And going back to the example of me searching in my backyard, I get a map where I can barely find my house with a flow line that's wider than my backyard somewhere in my general vicinity. And while that's a great start, you can do better, and SB 181 tells us to do better. So we're extremely conscious of supplanting the 811 system. I don't think anybody's going to stand at this table and say, let's get rid of 811 and lump it all into the COGCC. We're fully supportive of creating some sort of landing page or warning on the map that directs public to the 811 system if they're planning any excavation. But I urge you to not get distracted by the issue of excavation. 811 is a tool for people who are digging holes. The map that we're proposing be created at the COGCC is a tool that allows the public to make informed decisions about where they live. Different purposes and different tools for different purposes. So we're also not insensitive to the arguments made about vandalism or terrorism, though if you dig a little deeper into the sources provided by many of the industry groups, in pre-hearing statements and responses, you'll find that these concerns are being somewhat inflated. And I think it was Commissioner Putnam yesterday who pursued a very nuanced and detailed conversation on that topic. So even if you take these concerns at face value, the map proposed in the final red line does not resolve the issues that kick this whole thing off. This map will not be accurate enough to show members of the public if the flow line is in their backyard, their neighbor's backyard, or their neighbor's 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 backyard. So I urge you to bring the resolution to 1 to 1200, which makes 1 inch on the map, 100 feet on the ground, and require the most accurate information possible, preferably with no more than plus or minus 3 feet. Other groups will be offering suggestions to make this disclosure even more meaningful, and I urge you to consider them as well. Commissioner Hopkins, I believe you raised the point regarding Rule 1101E2, and that it needs to be amended to allow local governments to disclose more precise location data to individuals who come to their office. It's a great idea, and I urge you to consider it as you make this rule change. As a more general suggestion, I think it makes a lot of sense if, say, I lived in Delta County, to make me only drive to Delta instead of to Denver to make these decisions, because somebody might actually do that, but requiring somebody to come all the way to Denver to see a more detailed version of the map seems a little arduous. So then that's what I have regarding that. So regarding pressure testing, leak detection, and inspections, coming up, you're going to hear from Conservation Colorado regarding something called improved instrument monitoring methods, and we encourage you to consider that suggestion. I also support the affiliated local government position regarding the CSU study, encouraging multiple types of detection.
Excuse me, I'm sorry, your time has expired.
Oh, I'm sorry. So that's all I got. Thank you.
Okay. Thank you both for your testimony. And commissioners, any questions for this group of panelists? Yeah. Commissioner Hopkins?
Okay. Very much appreciate your testimony and suggestions. Since you mentioned the local government issue on visiting to get more detailed data and such, I don't remember exactly what I said about whether or not I thought, but I think it fits the meme of getting local government working more closely with operators and their citizens to address this issue. And I'm certainly very sympathetic. I'll go back to what Sarah said in her opening statement about the 2016 obvious runaround. I'll give you my version of the 2019 Colorado Oil and Gas Commission cooperation with local government. And we've seen that in Broomfield many, many times, where the commission has come out and responded to concerns that the city has had from its residents about odors, also about a plugged and abandoned well that had some issues. And this wasn't within a 2-year time frame. This was within a 2 to 3 day time frame. So I see a lot of change in terms of the way the new commission with the new mission is already implementing things that respond to your concerns. But I do believe there's more that can be done with regard to the legacy wells that are out there in terms of getting better information and knowing what's going on. Let me ask you, let's see. Oh, the local government as a repository. I would like to at least explore, I'm not sure if it's appropriate for this rulemaking or not, the idea that if a local government requests to be able to do that and be an information center, I think that's something to be explored. I just think it's something to be explored. I'm not suggesting that every local government will want to do this or should do it if they don't want to do it. I think I'm a big believer that local government needs to make some good decisions, but I also believe there's got to be some guardrails in place from a state perspective to do that. So anyway, that's my reaction. And I just think more work needs to be done. Second of all, I'd like to hear what you get. Well, now I'll get to accuracy, your concerns about accuracy. I'd like to hear what's reasonable and necessary that you get at plus or minus 3 feet, that you don't get at plus or minus 25 feet. Based on the maps I've seen, looks like you can get a good early warning, and you can go and get more information if you'd like to make some good decisions. But I'd like to hear your all's point of view. What's the big gains relative to the delay? Industry said that they can do it at plus or minus 20 feet by July 2020. I think I got that right. And, pardon me, close? December 2020, even more time. I wasn't trying to wait big time.
Yeah.
So they say they can do it. Now, I would like to hold them accountable to that, with that deadline. I think if you go more strictly, I think we'll get into a delay system. We can say December, now that I've learned 2020, but if they don't make it, they don't make it. So I don't want to put in something that's not realistic to achieve, because, and I think you'll have to realize if you do go to the ±3, there is a real possibility for a significant delay. And I would like to move this along as fast as possible and then improve as we go. So that's, at least, I want to hear a response to that.
Thanks, Commissioner Hopkins. This is Andrew Forkas Goodmanson. So the first part of your question was, I believe, what we get with ±3 feet.
That you don't get
That we
plus
don't
or
get
minus
plus or
25.
minus 25 feet. So on the maps that staff presented with the publicly available maps that anybody can get on the website, the resolution is such and the distances are such that the difference between the 1/10 of an inch thick line versus like 1/100th of an inch or whatever is probably not that meaningful. We are asking that you have a better map available to the public where that line would be, the difference in size between those lines would be meaningful. But the real difference is in the information that you will have available and the information that the public will have access to through the commission and through any participating local governments. When I'm looking at my property, when I go to Google Maps and I zoom right in on there, the difference between 3 feet and 20 and 50 feet is literally on the other side of another set of apartments. I mean, it's fairly significant. And the average person may never actually encounter that difference, but for the people who care, it'll be extremely meaningful. And for the people who want to make the best decision possible, it will be extremely meaningful. And we're obviously conscious of compliance. I think staff demonstrated how that compliance is going with regards to the information reporting requirements from the previous rule and how they've sought out operators and gotten this information from them and gotten the ball rolling where operators may not have responded to that request. So, I mean, there are ways of encouraging compliance. And I'll also say, no one else will say, you didn't really ask a question at the end there. I'll let Sarah finish. Or?
Yeah, I want to throw out one other piece on this is, in my own neighborhood, I live in Erie, and I live in a fairly new and continuing to develop subdivision. And frankly, the difference between 25 feet versus 3 feet, it means, I mean, we have a developer, which in my opinion, we can discuss the developer on a different platform, but you know, the difference in 25 feet, that developer's housing, their fence lines that means the difference between potentially they have flow line sitting under their post holes versus an actual 20-foot buffer between their fence lines and their their fence posts.
Okay, I appreciate that. I'm trying to think if there's another issue. I just want to close on that particular issue. Well, actually, there's one. I'll defer for after I make this short statement, not to monopolize. I do think you need a compelling case for the 3-foot versus the 25-foot and balancing the effect of delay. And I think you're going to get delay. It's going to be delayed if you do that. So just urge you to carefully evaluate the trade-offs there between time and getting what I think is a fairly reasonable staff decision. It gives you a good screening tool, and then you can work with your local government on additional clarification if you need to. That's at least where I'd like to close it. Thanks.
Any more questions? Yeah, Commissioner Overturf.
Thank you. I just wanted to follow up on that example that you just gave. So in that situation, are home builders really going to be relying solely on the information that's presented in the COGCC map? And this is a question I've asked to a number of people, and I don't feel like I fully understand how this process works today. But if a new, and maybe staff can speak to this later, but if a new development is being planned, are the developers really just going in there blind and digging wherever, or is there a process through the existing 811 system by which there is a comprehensive identification of the variety of things that might be in the ground before they start conducting that activity?
So I guess I can't speak for what the developers are considering. I guess to elaborate a little further on this example, in my neighborhood, there is a battery of 3 wellheads. Approximately 200 yards south of that is the separator and tank system. Looking at that, there's probably about 150 feet between the sidewalk and the fence line. And then the well battery to the tank battery has an interesting, setup of open space between the wells and the tank battery. And I guess the concern I would raise in that example is, and this is I think this is probably pre-mapping or pre-stringent mapping requirements. The concern I would have is there's some pretty vast assumptions by the developer or, risks taken, intentionally or not, with the proximity of the homes to the flow line system. I mean, first being that there's a definitive straight line where they're running their open space and not very much margin around where those flow lines may be or may not be. And I think that is of concern. And I think, again, where I can't speak to the risks or the presence of different things in the soil that the developer may or may not have considered, I guess at the very least, I think that those homeowners ought to be informed that within 20 feet of their fence lines sits a substantial flow line system, and they ought to at least have access to the frequency with which those flow lines and that well system is being monitored.
More questions? Seeing none. Thank you so much. Appreciate it. Okay, next group up, we have, let's see, Colorado Rising, 350 Colorado. North Range Concerned Citizens, Climate Reality, Denver. Good to see you, Representative. And
Very
nice to
much,
see you too.
Director. Nice to see you.
Yeah, whenever you're ready, we'll start.
I'm going to put the timer on as well. Good afternoon, Commissioners, COGCC staff. My name is Leslie Weiss. I'm with the group Weiss Consulting. I'm here with Joe Salazar, Executive Director of Colorado Rising. Thank you for the opportunity to speak today on behalf of a collaboration of groups involved in public health and environmental issues, including Colorado Rising, 350 Colorado, the Lookout Alliance, and North Range Concerned Citizens. I'd like to start by discussing 2 topics that have been inaccurately represented by industry: the topics of who has authority to regulate gathering lines and the matter of vested rights. But first, 2 topics will be briefly discussed in place of the expert testimony we had planned to provide by Wes Wilson, who unfortunately was not able to reschedule to this morning. The first topic is reverse setbacks required for fire safety. The Commission rules consider setbacks of proposed wells from existing residents in its objective criteria. What was missing in this flow lines rulemaking, however, as the Firestone disaster makes clear, there must be reverse setback rules that obligate new homes and structures not encroach upon existing flow lines, gathering lines, or gas storage facilities, which should not be left solely to local authorities. A minimum reverse setback formula based on the explosion radius of the line must be set by the Commission, or else an arbitrary patchwork of standards, or none at all, will result throughout cities and towns across the state. For example, Adams County recently proposed to amend its local land use regulations to allow a mere 10-foot setback between new development and existing flow lines, much smaller than the blast radius for that line, woefully insufficiently protective of public safety. At the hearing on September 5th, COGCC staff presented technical information of a possible reverse setback using a formula that considers construction and operational factors such as diameters and pressures to determine a blast radius. It is requested that the rules be further revised so that flow line and gathering line setbacks are based on the fire safety explosion radius or similar criteria established by this commission, and then uniformly applied statewide as a minimum floor. Local governments can then choose to set further distances, but not closer. This would be consistent with COGCC's obligations under 181. The second topic is the need for more robust leak detection. COGCC has proposed rules for BMPs, including audiovisual observation, FLIR, camera inspections, and pressure tests. However, these are insufficient alone because in addition, such rules obligate operator monitoring. It is necessary for the state to use technically feasible practices for more comprehensive and accurate monitoring of methane, VOCs, and benzene to ensure requisite protection of public health and safety. This is especially critical since the October 2019 CDPHC health study recently confirmed previous studies concerning the presence of benzene beyond the studied limit of 2,000 feet from oil and gas operations. Commercially available practices include flyovers using aircraft mounted equipment, which approach recently successfully identified leaking oil and gas facilities in the Colorado San Juan Basin. Another approach is to use fence line monitoring using advanced laser technology. This has been obligated by the California Air Resources Board to detect toxic emissions from oil refineries. Some references for these commercially available practices are included in our pre-hearing statements. Mandated reverse setback rules and modern monitoring techniques by the state is essential to assure the industry's toxic air emissions are not released upon Colorado residents. The BMPs you are now considering are like speed bumps used to slow and control traffic, while state-run aircraft monitoring resembles traffic cameras. An initial step of releasing an RFP to determine costs and other information about these technologies would be a relatively simple way to determine the department's more technologically modern options for monitoring. Concerning the next topic of gathering lines, the federal agency responsible for oversight of gathering lines, PHMSA, has acknowledged that 95% of gathering lines and 87 to 90% of onshore oil gathering lines are unregulated. Most of these lines are in rural areas, and some trends in these areas are that development of new housing communities are occurring closer to these lines. It is also the trend that gathering lines are being built at larger diameters to carry their fossil fuels at higher pressures than was the case in the past. And neither has the explosion radius settings been changed. Yet these gathering lines remain unregulated, and industry protests that COGCC not be allowed to regulate them. If the oil and gas industry is so safety focused, why are they so opposed to regulatory oversight of these thousands of miles of gathering lines by this agency? Defend Colorado, a dark money industry group you will hear from in a bit, selectively wrote in their pre-hearing statement that you do not have the authority to regulate these lines. This is technically accurate, but substantively wrong. While you presently do not have the authority, you need only take a few steps and could readily have it. I believe COGCC staff fully understands that already. What the commission needs is to assert the will to do so. Nowhere does the state require PUC to have exclusive authority. And since they are not in fact regulating the majority of gathering lines, it seems entirely appropriate and necessary that your agency do so. And you already regulate the financial assurance, waste treatment, and disposal matters concerning gathering lines, in addition to flow lines and other infrastructure that tie directly into these lines. 181 requires continuous monitoring at well pads. It should also include all pipelines. Commissioner Overturf yesterday reported that PUC will be discussing pipeline safety in an upcoming rulemaking. If PUC fails to take responsibility for these thousands of miles of unregulated lines, COGCC simply cannot ignore this important part of the oil and gas infrastructure. It's as if at your annual checkup, your doctor checks your ears and listens to your heart, but refuses to take your blood pressure. You can't really feel comfortable. You're cognizant of your full health status and risks. Federal law authorizes states to pass more stringent state regulations for pipelines. To go from zero to something is well within that authority. The state can simply grant legislative authority, and then you can request certification from PHMSA. Finally, on the topic of vested rights, Defend Colorado also makes veiled threats of litigation to your agency if regulations have any retrospective effect. What I have observed is a term that gets casually tossed around is the notion of vested rights. I bring this to your attention to make the commission aware of this, because as rulemaking continues and perhaps even broader, with more broader and more impactful regulations with mission change and cumulative impacts, I expect the use of this term and the threats to increase. That this claim that the government cannot pass laws that impact their operations retroactively or retrospectively is not supported by law. Industry often asserts that any activity already occurring is constitutionally protected. This simply is not true. If it was, we'd still be sitting in restaurants inhaling secondhand smoke from cigarette smokers exhaling all around us. It is settled law that if the need for regulation that impacts an industry's existing operations is rationally related to a legitimate government interest for public health and safety, that regulation may be implemented even if it interferes with a private individual or company's vested right. Oil and gas does not get a special exemption from the government's right to prioritize the public good that is enshrined in case law from Colorado's highest court. SB 181 mandates that health and safety be prioritized. Beware that Defend Colorado used a case in its pre-hearing statements that is only references vested rights as a tangential issue. Interestingly, they failed to include the more relevant case in Ray Michael DeWitt, or the estate of Michael DeWitt. This case makes clear that the application of a statute is not rendered unconstitutionally retrospective merely by the occurrence of facts upon which it operates before the adoption of a statute. And that a finding that a statute impairs a vested right, although significant, is not dispositive as to its retrospectivity. Such a finding may be balanced against the public interest in the statute. A determination that a statute implicates a vested right is not dispositive because vested rights do not accrue to thwart the reasonable exercise of police power for the public good. I will cede the rest of the time to Mr. Salazar. Thank you.
Thank you. Nice polo. It's good seeing you. All right. I want to thank the commissioners and staff for holding these rulemaking hearings pursuant to Senate Bill 19-181. Obviously, the matter of oil and gas pipelines traversing the state of Colorado are of critical importance to the health, safety, and welfare of Coloradans, along with the environment and wildlife. You've heard from a number of individuals about technical aspects of flow lines, and I won't repeat that testimony here. Instead, I want to give some historical context to this pipeline debate that may be relevant to your deliberations. In 2014, when I was a state representative, a bill came to my committee, the Judiciary Committee, numbered Senate Bill 1493. It got through the Senate with bipartisan support, but there was a controversy brewing around it. Senate Bill 1493 was an oil and gas pipeline bill, a bill to give eminent domain to private oil and gas pipeline companies. This bill was particularly frightening to citizens, Republicans, Democrats, and unaffiliated alike. And committee members started receiving a substantial amount of constituent calls against the bill. Representing the Thornton area, pipelines traversing my city and county were a real thing and are a real thing, and I was going to vote against that bill. This was not a surprise to anyone. What was a surprise was that Republican Weld County Commissioner Barbara Kirkmeyer and Republican farmers and ranchers here in the Weld County area turned to me to be their champion in the Judiciary Committee to kill that bill. Barbara Kirkmeyer testified about the fact that the oil and gas pipeline companies wanted to put a oil and gas pipeline about 8 to 10 feet outside of her front door, and she found that to be repugnant. If you don't believe me, you can listen to her testimony. Landowners also came and testified about the fact that if there were oil and gas pipelines traversing their property or near their property, that they would lose their organic status as farmers. They would lose their insurance as well. They provided that testimony as well if you want to review their testimony. Oil and gas, like they always do, painted a picture of doom and gloom, I dare say a financial apocalypse, if we all did not pass this bill. The doom and gloom argument is always the default for the industry. If you heap on more regulations onto the industry, then they're just going to have to fold up and leave, and that never does happen now, does it? What happened was that the bill was voted out 6-5. And so my role at that point, because Barbara Kirkmeyer asked me to, was to figure out a way to kill that bill before it got to the House floor. And so me, along with then Representative Mike Foote, as well as then Representative Joanne Janal, we hatched a plan to kill that bill, and it worked. And then the industry came after me personally, saying that they were going to make sure that I wasn't elected again. Just to send a message to everyone else that no one messes with the industry, and then I beat them in 2014. After that, I brought a bill to protect people through the Oil and Gas Liability Act in 2015. And it was there that I was on the House floor, and this has been played out in commercials and what have you, where I said, "What are you waiting for?" And I said this to my colleagues. What are you waiting for? Are you waiting for an accident? Are you waiting for explosions that will take people's lives? Are you waiting for explosions that would happen outside of schools? What are you waiting for? And that bill got out of the House of Representatives and into the Senate, where it promptly died. Let's fast forward one more year to the explosion in Firestone, where lives were taken. And everything that I said in 2015 said that could happen, did happen. And then there was a debate, literally a debate on the House floor because of the accident, the explosion in Firestone, where we had representatives come up and say, "We feel sorry for that one family, but we're going to protect the industry." Literally, my colleagues were discounting and negating the lives of human beings for an industry. 2016 happens, I go to Standing Rock because I'm a state representative, and the Obama administration, in collaboration with me, wanted me to go check on human rights violations as well as protect Coloradans, since I was the only state elected official there. And we said, indigenous people, me included, we said there will be accidents that will happen here, and sure enough, that has happened. It's also happened with the Keystone Access Pipeline, where hundreds of thousands of gallons of oil have caused an ecological disaster just recently.
Mr. Salzar, excuse me, your time has expired.
Please start wrapping up.
Thank you, and I was going to wrap it up. But here's the point. The point is that the public recognizes people, elected officials and appointed officials, when they don't take a vote to protect them. They remember those names of people who didn't protect them. Ironically, though, they don't remember the names of the people who vote to protect them because they're comfortable in their safety. The lessons that I've learned over the course of these many years is something I'm trying to convey to you, is that please take that vote for safety. It's not going to harm the industry. They're not going to fold. We know that. They're not going to leave. We have stuff in the ground that they want.
You need to start wrapping up now.
Yeah. But please take that vote to protect people, because that's the mandate of Senate Bill 19181. Happy to take any questions.
Any questions for these panelists? Commissioner Hahn.
Yes, Leslie, I do share your concerns with the gas gathering lines and the lack of regulation, and do plan to follow up with that, not with this rulemaking, but in the future. And hopefully as a commission, we will make some changes there.
We will be here until they get covered. I think the question is, what is the commission willing to do? I think communicating with the PUC on this upcoming rulemaking, seeing what their plan is, and then immediately start a strategy for making sure they're covered. I mean, I'll be here, but I don't have the power to make this happen other than showing up at every meeting. But I'll follow up with the PUC. There will be others that will do so, but I think the most efficient way is for this commission to collaborate with the PUC and figure out what the strategy is to make sure they're covered. Thank you.
Any more questions or comments? Okay, see none. Thank you so much.
Thank you.
Appreciate it. Next group up we have is Defend Colorado. And okay, and once you're ready, you get started. You have 3 minutes, and please introduce yourself.
Good morning. Thank you, commissioners. My name is Matt Tieslau on behalf of Defend Colorado. I'd like to thank the commission for the opportunity to speak today. Defend Colorado remains committed to common sense safety updates to the commission's flowline rules, and therefore we generally support these flowline rules. However, as set forth in our pre-hearing and response statements, we do have a few primary concerns with this rulemaking. Our first concern is procedural, and it's a general objection to the truncated nature of this rulemaking. Specifically, we object to the commission's refusal to allow motions outside of just 2 statements that are filed here, refusal to allow substantive responses to late introduced documents such as the regulatory analysis, and a refusal to allocate parties meaningful testimony time, including the ability to cross-examine witnesses or provide rebuttals. The commission has several rulemakings planned for the next year, and if the commission's goal is to promulgate the best possible rules, it must afford all parties adequate participation rights. This includes the ability to file motions, respond to analysis, and to cross-examine witnesses. Further, we feel that hearing officer Eden's denial of our motion to strike filed last week, which addressed substantive issues that were raised just for the first time in the regulatory analysis released by commission staff, is not compatible with due process. At the end of my testimony, I would like to introduce that motion into the record. Defend Colorado's second set of concerns are substantive and relate to the commission's and other parties' interpretation of the commission's mandate under Senate Bill 19-181. Several parties to this rulemaking have asked the commission to expand its flowline regulations to cover non-jurisdictional flowlines already regulated by the PUC and PHMSA. We're encouraged that the staff's final proposed flowline rules do not cover those non-jurisdictional flowlines. We continue to urge the commission to decline any further requests during this rulemaking to exceed its jurisdiction. Second, commission staff released a regulatory analysis on the eve of this rulemaking that interprets the language in Senate Bill 19-181, minimizing adverse impacts, to no longer include any consideration of cost effectiveness or technical feasibility. We believe that that interpretation is wrong because the commission is still bound by a reasonableness standard, which necessarily includes considering costs and technical feasibility. The commission should therefore reject any language suggesting that the commission can exclude costs and feasibility considerations from oil and gas regulations. Further, the notice of the rulemaking for this rulemaking didn't indicate that the commission was interpreting this newly defined term, and instead indicated that the commission was updating its flowline regulations to address public health, safety, and environmental concerns, which again, we support. But because the notice of rulemaking and the draft proposed rule did not contemplate that, it was not addressed or substantively briefed by the parties to this rulemaking, and it should be held and reserved for a later rulemaking. The commission does want to interpret that. That concludes my remarks, and I'm now available for questions. Thank you.
Thank you. Are there any questions? Okay, thanks so much.
Thank you. I do have a copy of that motion in there.
Yeah, you can give it to Ms. Larson.
Ms. Larson, isn't that already in the record?
It is. I was a little confused by that. It is in the record. It's in the commissioner's portfolio and then also in our online flowline rulemaking portfolio.
Just for clarification there, we did receive an order that that was struck. So you're saying it will be included in any administrative record for this?
So the order is in the portfolio, as is the motion.
Okay, thank you.
Okay, next up, Citizens for a Healthy Community. Welcome, and once you get situated, you have 3 minutes, and please introduce yourselves.
Good morning. My name is Natasha Leger. I'm the Executive Director for Citizens for a Healthy Community. We're an impacted citizens group based in Paonia with 1,500 community visionaries. I'm here today in general support of staff's proposed rule changes. We appreciate the Commission's resistance to calls for differing treatment and standards on the Western Slope, and appreciate the Commission's efforts in moving towards greater transparency and disclosure of flowline information as mandated by SB 181. We also support Logic's position and suggestions for improvement. The focus of my comments today is specifically on the proposed federal government exception to removal of flowlines and changes to Rule 1101E on disclosure of flowline information. The proposed exception to removal when the federal government directs abandonment in place appears to be a blanket federal government exception, which does not acknowledge the regulatory authority of state and local governments to regulate oil and gas activity on federal lands. As clarification, we suggest this be changed to the federal government directs abandonment in place with respect only to specific flow lines on federal lands and only consistent with applicable state and local government laws, regulations, and requirements. This statement would avoid a blanket federal abandonment in place determination and would address and preserve the applicability of both state and local government requirements. Moving on to disclosure of flowline information, the current proposed Rule 1101E is overly focused on the technical details of geospatial information to be provided, and should be equally or more focused on the COGCC's need to make this data available to the public in a manner that is comprehensible, easily visualized, and otherwise suited to the public's objective in conducting its own risk analysis and evaluation of health and safety concerns. For example, the address search on the online viewer doesn't work. The background layers, which provide context, are not helpful to the average person. And the significant infrastructure data available really requires a GIS professional to be able to navigate the map and pull out relevant information. While we appreciate staff's recommendation to change the map scale to 1 to 6,000 from 1 to 24,000, it still does not achieve meaningful disclosure. A relevant search function and background layers such as OpenStreetMaps that provides context such as local roads and points of interest would make that information infinitely more relevant and actionable to the non-GIS professional and make it easy for the general public to make informed public health and safety decisions. We've suggested language for section 1101E in Exhibit 1 of our witness testimony on how to accomplish this. Our witness, Paul Milhauser, is here to answer any questions.
Thank you. Are there any questions? See none. Thank you so much. Appreciate it. Okay, City of Aurora.
Good morning, Commissioners. Elizabeth Pranos on behalf of the City of Aurora. I'm happy to let everyone know that staff has resolved the concerns that the City of Aurora had, or really suggestions that the City of Aurora had. Those really had to do with the mechanism by which the COGCC would share whatever information they have on the location of flow lines, so the specific GIS information. The City of Aurora just wanted to make sure that there was a live streaming web platform that could basically transfer information from the COGCC to local governments. And staff has assured me that that is something that they are going to try and do with their IT department, and that would allow the city, as well as any other local government that wants access to the GIS information, to have that via real-time streaming platform, rather than having to upload the individual shape files, which is a more time-consuming process.
Thank you.
Thank
Any
you.
questions or anything, Elizabeth? No? Great, thank you.
If I might, is it possible to make a motion to just clarify the record with respect to a statement that was made yesterday with regards to the affiliated local government coalition pre-hearing statement and presentation yesterday?
Let me check quickly. No.
No. Okay.
Colorado Association of the Home Builders. Good to see you, and whenever you're ready, please introduce yourselves and you'll have 3 minutes.
Thank you. Cody Burke on behalf of the Colorado Association of Home Builders. With me, I have Scott Smith, who is the Government Affairs Committee Chair for the Colorado Association of Home Builders. And because of the limited time and the fact that staff already addressed most of the changes we requested in our pre-hearing statement, we wanted to focus on one issue which was discussed early yesterday between, I think, Ms. Murphy and Commissioner Hopkins, which was the ability of individuals to go down to the commission to view the more detailed maps and how we potentially could work with local governments to get that done as well. So with that, I'm going to go ahead and hand it over to Scott. And he's going to describe the process that home builders and developers undergo in this process and why it'd be helpful to be able to go down to local governments and get this more detailed information.
Thank you. And again, my name is Scott Smith. I'm the chair of the Governmental Affairs Committee for the Colorado Association of Home Builders. And just thank you for your time today and for listening to us. The land development process is very complex as it comes to working with local government. And so in this process, it's really important to know exactly where the locations of all kinds of utilities and facilities are around your development. So the very first part of it is at the higher level is in the land acquisition process, understanding where those flow lines might be and recognizing that you might have something you have to deal with in the development process. So you need to know where those are and what types of mitigations you might be able to propose to do that in the development process. Once you get that over with, then the next step is to go and work with getting your approvals and entitlements from local government. And so in this process, it's what we'd like to see, obviously, would be all those flow lines in specific easements so that you know exactly where those are so that you can plan around those easements. And then obviously from that point, you've got setbacks from that easement for all kinds of utilities that are just generally in the development process. So setbacks have to be planned in your development. After you get to that point, it's really important then to understand that you're going to have surveys and you're going to have final development plans and plats that are going to be recorded. And then it gets even to be more detailed information on exactly where those lines are. And this is particularly important when you have intersections. So it's not just being, neighboring those flow lines, but if you have utility, obviously you're going to have utility intersections for sanitary sewer, water lines, electric lines, etc. So finally, in the development process and construction process, the 811 is going to be really important to make sure as we work with our multitude of contractors to make sure we don't have any conflicts and damage equipment or create problems. So all in all, we really would like to work with local government, understand where those are, and I think that'd be the most helpful information on a parcel by parcel or unit by unit basis. Every one of them's a little bit different. So thank you very much.
Yeah, I'd just like to add at the end, we also having trouble with the microphone. We also have positions on abandonment and other issues that raise in our responsive statements that we can talk to as well, and he's available for questions. As far as tweaking the rule, 1101E1 provides that individuals can already go down to the commission and view the more detailed information at scales greater than 1 to 6,000. So we could easily tweak 1101E2 to permit local governments to do the same. And that would solve the issue with who's not in Denver and Rifle counties. Thanks.
Questions? Commissioner Boygan, then Commissioner Hahn.
Thank you, Mr. Chair. I have a couple of questions. First, one of the previous witnesses testified in favor of this commission establishing what she called reverse setbacks, which, as I understand it, would establish a setback from existing oil and gas facilities for residential and other surface development that might be stricter than what a local government might impose. Do you have a position on whether that's a good idea and on whether this commission has jurisdiction to do that?
Well, reverse setbacks are important. They're currently set on a case by case for each local government, depending on what their rules and regs are. I think that any other kind of guidance from this commission would certainly be up for consideration for local government.
If I might, so if this commission said that in guidance, let's say, that there ought to be a larger setback from existing oil and gas development than what the local government would otherwise require, and if that were binding or strongly directive to the local government, and would therefore potentially take some developable space out of your members' portfolios, you'd be okay with that?
Well, setbacks are very complex because there's obviously there'd be different setbacks for different types of facilities, flow lines versus wells versus tank batteries, et cetera. So having some sort of guidance from the commission on what's reasonable and rational that could be the local governments could entertain, I think would be a rational approach.
I'm not totally sure I'm understanding. Are you saying it still would be the province of the local governments to make the ultimate decision, not the commission?
I believe so, yes. That the commission could lay out what would be good operating procedures or commonly operated procedures that would be guidance to local government.
Okay, can I ask an additional question? I wanted to just follow up on this question of early stages of a proposed project and how you deal with the potential for, not potential, let's say actual existence of flow lines and other subsurface structures in the area that to be developed. Can you describe what the process would ordinarily be if a developer acquires land knowing that there are buried flow lines, some of which may be conducted or connected to active wells and others might not be, what the developer would do in order to address that situation, ensure that the development could proceed and plan for the continuing existence or removal of those lines? What would be the process?
Well, a proper process for due diligence would be to do your level best, identify where those lines are. Having a more specific idea of where those lines are early is always better. So the idea would be to identify what those lines are, who the operator is, and identify specifically how to work around those or to mitigate them or other procedures. So you want to know everything you can possibly know about those types of facilities on property you might be intending to acquire.
And then would it be customary to negotiate with the operator, the owners of those lines, to agree on whether the extent to which lines perhaps might be removed or relocated?
It would be perfectly appropriate to do that. And I think that would be the standard procedure, would be to actually go and have a conversation with the operator and identify what the status of the line is, and everything about it, so that you can properly plan for the development.
And just one more question. And so did I understand correctly that you think the mapping procedures that these new rules would implement would be helpful to you and your members in pursuing that strategy?
Well, to my understanding, the mapping at a high level obviously will identify, that you've got something in the vicinity. But I think it's really important to be able to work with the local government to get much more specificity on those lines, both from a horizontal and vertical location standpoint, so that you can properly plan your utility connections and things like that, particularly on intersections.
Thanks.
Commissioner Hahn.
Thank you. I would like for you to comment, give us your opinion as a home builder, your opinion of abandoning lines in place.
Well, as my experience shows, every situation is different. And I think that if you have a line that needs to be abandoned, if it, in most cases, it probably should be removed, I believe, but there are certainly many situations where abandoning in place would be a much better alternative. And those would primarily be in cases where, for example, you might have a trail easement and, some vegetation that's planted, in an easement or near a pipeline, that the removal of that could destroy the, the trail corridor. Or in other cases where you have a line where you've deftly gone around a flow line with your utilities, which would include natural gas, electric, et cetera, and that the removal of that line could really impact those surrounding structures. So I think it really needs to be on a case-by-case basis, and that, make sure that you're considering all the factors when looking at the abandonment.
Commissioner Eden.
Thank you. You mentioned that mostly you would try to have all of your utilities in an easement or corridor. And when these flow lines don't line up with your utility corridor, would you have the ability to get them to be moved, or would it be preferable for them to move into the broader utility corridor?
Kind of a chicken and an egg.
What?
It's kind of a chicken and an egg question.
Right.
I mean, generally, depending on the flow lines and your conversations with the operator, you might decide that you're going to work around the existing flow line and that you'd identify where that is. Or in some cases, you might work with the operator to relocate that line, but you're going to have to make sure that you're operating in tandem with the operator to make sure that you're doing it properly and putting it in place makes the most sense.
Commissioner Overturf.
Thank you. You described earlier in response to a question from Commissioner Boygan the general steps that you go through, but you said sort of generally that you want to identify the lines or things that are in the lands that you're looking at. I'm wondering if you can provide some additional detail about how today you find that information. Do you call 811? Do you interact with local governments? Today, in the absence of a comprehensive map, how do you actually accomplish that?
That's a good question. And I think that's going to probably be more on a case-by-case basis. But when you're looking at a piece of property, obviously, one of the biggest things is just do a visual inspection. And if you can see signs that there's going to be any kind of utility lines or flow lines, you're going to want to try to identify that early. And then, work with the landowner and understand what type of easements might be in place and where the lines might be. So you're going to try to access everything you possibly can to determine what exactly is on the property, regardless of whether there's flow lines on there or not. So it's an important part of the process to go through a due diligence, and then a lot of times you'll do what's known as an ALTA survey. And in that survey process, the surveyors go out, do visual inspection, try to identify specifically what might be on that property. And then those surveys are actually, once they're completed, have to be deposited with the local county clerk recorder for recording. So you're gonna try to make use of everything you can, identify what's on that property.
Okay. And I also appreciate that it sounds like there are conversations that are ongoing staff and other parties about how to access the more detailed information through some sort of a portal. So, but looking through your pre-filed testimony, correct me if I'm wrong, but did the home builders take a position on the issue of plus or minus 3 feet versus plus or minus 25 feet?
We, as long as our members could go down to the commission or local governments or request it from the commission and have it sent over, we felt that the actually publicly available information was fine at those levels. The issue, I think, the plus or minus 3 feet and 25 feet we're okay with otherwise, because eventually we're going to have to use 811 anyway to get out there and locate them within an inch, I believe is what the members spoke to.
So let me just make sure that I understand, because the mapping that's kind of publicly available is different than I think the potentially additional specificity that might be provided under these unique circumstances. So my question isn't about the public mapping and the access, but so what you're saying is that the identifying the exact location of the line plus or minus 25 feet is sufficient for your purposes, or is there value to you in having the additional specificity of plus or minus 3 feet?
Ideally, we'd like plus or minus about 2 inches. So it depends on the level that we're at in the process.
Recognizing that you're still going to have to call 811 to get your plus or minus
Right.
2 inches.
I believe so. That, I mean, that the specificity at the 25 feet would certainly be very helpful. I understand where those lines are. And then in the most sensitive locations, you do some potholing to know exactly where the lines are. We're using 811 to identify those.
Okay.
Did that answer your question?
Sort of, kind of.
Sort
It
of.
was squishy. There was something else I was going to ask, but I don't remember right now. So I'm good. Thank you.
Commissioner Hopkins and Commissioner Messner.
Thank you, Mr. Chairman. I was trying to figure out where is the state interest in this from a state regulatory standpoint versus where the local government is in charge. And I'm not terribly experienced with local government relations, other than I know there's a very detailed process with their local land use authority that you all go through with the local governments to work out the developments, et cetera, et cetera. I do see the state interest, obviously, with the public mapping and that data that's available. And I know that if I remember correctly, the language in the staff or in the draft currently talks about the local governments can receive the raw data, if you will, the GIS, subject to a confidentiality agreement. And they can use it, there's certain purposes they can use it for. And one of them is for planning purposes, which to me indicates the developer process and such. But I also think I remember correctly in your statement, you said you can't sign any type of confidentiality agreements to keep that kind of data. Am I remembering that properly?
Well, signing a confidentiality agreement would be very problematic because, as we discussed, once we try to identify where those lines are, the very first time that's going to be basically a public document would be in an ALTA survey. Mm-hmm. And if we identify those lines that we've received as a result of signing that confidentiality agreement, the second that ALTA survey is completed, it's become public information. And then that public information, as you go down the line of development plans and plats, those are all subject to public hearings and then are filed with the county clerk and recorder. And then beyond that, we have problems with making sure that all of the subcontractors that we're working with, whether or not, how are they going to, be able to sign off on the confidentiality agreement? How do we delegate that? And then finally, we need to disclose to our home buyers about those things too. So the confidentiality agreement would be very problematic for us from a liability standpoint.
Okay, I hear you. Seems to me that's an issue that you really do need to work through with the local government authority, because they're the one who'd be bound by the confidentiality and what they can do with you.
I'd also
and they'll be held accountable for that too. So
I'd also like to state, not only do you have the local government, you're working with your local utility providers too.
Well, I know I'm not a developer, but I know you go through a lot of process.
There's lots of entities engaged.
But let's see, where was I headed with that? Yeah, you raised the issue. Sounds to me like it's a local government developer kind of issue handled at that level. I'm not sure there's a state role beyond the mapping concerns and the ability to local government that the commission would really be able to act on if you don't have any language or you kind of talked about it, but you didn't really offer any type of state role in that particular discussion that I heard anyway.
And I think our solution to that, when with talking with different stakeholders, was the ability to go down to local governments and actually view those plans just like you could at the commission at a greater scale. So that would, the issue is that breach of the confidentiality agreement local governments are signing that are issued with COGCC, and whether they're willing to share based on the confidentiality they sign. So if we could carve out exclusion of viewing planning sufficient, maybe that is a guidance document that's issued later on that, but I think that was the issue.
Yeah, no, I appreciate that. Certainly in the near term, I think it's a good issue to work out with the local government and how that process works. And then maybe you can work through it that way.
Commissioner Messmer.
Thank you. A couple of questions. I'm going to follow up on Commissioner Overturf's question so I understand. Do you want plus or minus 25 feet, or do you want plus or minus 3 feet?
Well, ideally in the long run, the narrower the better.
So you want plus or minus 3 feet?
I mean, yeah.
Okay.
I mean, depending on the circumstances.
And that's good. I mean, I'm not trying to push you. I'm just trying to understand.
For our purposes, the tighter we can understand it, the better.
Okay. You had mentioned that, oftentimes local governments or regional governments, do require certain setbacks from all kinds of different utilities. You had mentioned, though, that you thought that the setbacks were from the easement boundaries. Is that typically the case? Is that they're from the easement boundaries or from the utility itself?
That's a very broad question that depends on the circumstances.
Right. So more useful to know specifically where the flow line or the utility is versus where the easement boundary is.
Usually a utility line would be identified specifically within an easement. So the easement
usually that's the case. That's not true with all.
True, but typically that easement boundary would be kind of the place where you generally measure some setbacks, but not all.
Okay. In the abandonment piece, and I know you didn't speak specifically, but your pre-hearing statement did. In your experience, in your opinion, if you've got if you're looking to acquire a piece of property that has a number of different abandoned flow lines within it, does that decrease the value of that property?
Well, I mean, I suppose it depends on the circumstance. Once again, that's really hard to just state.
If you knew that you had the burden to remove those in order to be able to develop that property, would that reduce?
There's no question about it.
Yeah,
you'd have
the value of that
factor
property.
that cost in.
Right. And, from the association standpoint, are you willing to take on the burden of removal of abandoned in place pipelines, on a consistent basis, or would you prefer to see the operators be the one that would be removing these in situations where it's clear that the development is going to occur in the foreseeable future?
Would that be a rhetorical question?
Right, fair enough. So the answer is yes.
Well, I mean, obviously from, the perspective of being a land developer, you want to eliminate as many of the costs as you can in order to deliver the product. So, taking on additional responsibility, you really don't want to do that. But, if you got to do what you have to do.
Sure. And then just in response to Commissioner Hopkins' questions, I do think that the state does have a significant role, in determining, where these flow lines are, and, providing information to local governments, particularly in the situation where the state is the primary permitter of these particular flow lines. So that burden is not specifically on the local government, but rather on the state of Colorado. The local government could be a depository of that information that it could be provided by the state, but unless the local government has specific regulations around more specific information than the floor of the state would provide, then the state does have a role to play there. That's just my opinion. So thank you.
Commissioner Overturf.
Thank you. I remember the other thing that I was going to ask about. So one of the concerns that the industry has raised with the higher level of specificity mapping, plus or minus 3 feet, is that there are instances where flow lines are located within utility corridors where there's just there's a lot going on within that corridor, and precisely locating the line may be more difficult. From your experience, is there a standard width of a utility corridor?
Of a utility corridor?
Right.
There's definitely standard widths for specific easements that are required by each utility.
Okay.
So if you have utility corridors, in some of those cases, you can have shared utilities within the existing easement. So that's what I would interpret to be a corridor.
And what's the standard easement width?
It totally depends on what type of utility you have in there.
And so because my property professor in law school, we spent a lot more time talking about whether or not you should be able to sell human organs than whether, like, how easements work and stuff like this. So I don't know a lot about these real property things. But so when we talk about utility corridors, is that a term of art where we know that what that means, that it's one or more, 2 or more different lines running through a particular piece of land? Or is utility corridor, when you use that phrase, are you talking about just any slice in which you would find a utility?
I would, based on your question, I'd say utility corridor would be a term of art.
Okay.
And
So
that each utility is required to have its own easement. And sometimes those easements can be shared, but, or they could be just side by side. And then for example, you could have overhead electric power lines that have to be within an easement. And then you could have a water easement, within that easement. But, that's all going to be based upon the landowner and those easement agreements, and then what's required by local government. So it gets complicated.
But utility corridor does not necessarily mean that there are multiple things going on within that corridor.
Oh, I think that, depending on the term of art, you could have certainly a series of different easements that would be, call it utility corridor.
Okay, thank you.
Yeah, Commissioner Boygan.
I'm sorry, Mr. Chair, I just have one area I'd like to follow up on a little bit. Looking back at your response to the pre-hearing statement, you spent a lot of time talking about the issue of confidentiality agreements and your ability to access whatever mapping information we come up with, and your potential need to disclose that information to third parties, including homebuyers. So would it be your view, your position, that if this data or when this data, mapping data, becomes available to whatever level, that you, number one, ought to be able to access it, whether it's at the commission or local government, but you ought to be able to find out what it says, and number two, that you ought to be able to make use of that information, including negotiating with the owners of those lines, and number three, that you ought to be able to disclose that information to all the parties that you deal with. Is that what you're asking for?
Yes, I believe so.
So if you had information about flow lines underlying your development, you would disclose that to your potential home buyers?
There are disclosure requirements, and so we want to be able to make sure that we can properly assess the situation and to make the proper disclosures.
Not exactly a yes. Are you saying you would disclose that information to your home
Absolutely,
buyers?
it's required by law. Yes.
What law?
There are disclosure laws in the process to disclose information to home buyers.
So you'd be required, in your view, to disclose to a home buyer that there's a flow line within 20 feet of that home buyer's property?
I'm not sure exactly what the disclosure requirements are, but there are disclosure requirements.
Okay, to me, that's not a yes. That's an equivocation, and I'd like to know from somebody whether there is in fact an obligation to disclose. If you're asking for this data because you want to make it available to your home buyers, then you ought to be committing to make it available to your home buyers.
I'd be happy to follow up with you on that question.
Okay, thanks.
Any more questions? Okay, Sina, thank you so much. We'll take a brief break and then we'll come back with Oil and Gas Accountability Project. Thanks. Okay, COGCC meeting will come back to order. And next up, we have the Oil and Gas Accountability Project. Come on down. And once you're situated, please introduce yourself and again, let us know who you represent.
Good morning, Commissioners. My name is Paul Zog. I'm the attorney for the Oil and Gas Accountability Project. And our time is short, so I'll get to our witness, which is Josh Joswick. He's the former La Plata County Commissioner who was involved with the coal bed methane drilling that went on in the south, still going on in the southwest part of the state. He's been a consultant for San Juan Citizens Alliance and OGAP, and has been involved on task forces and rulemakings for almost 30 years involving oil and gas. Take it away, Josh.
Good morning. Thank you for giving me this chance to talk to you. My name is Josh Joswick. I'm from Bayfield, Colorado, and I have been coming up to Denver for the better part of 30 years to participate in COGCC rulemakings. Like Howard, I have history here. And in those 30 years, I've seen the people of Colorado lose more often than they have won before this commission. I've seen the industry twist well-intentioned bills and rules to work to its advantage, and seen how that advantage has at times brought a sense of helplessness to affected people. And there's the potential for that happening in this rulemaking. And in hearings like this, it's easy for commissioners to get overwhelmed with technical details and legal interpretation that may or may not be accurate. And that is actually a tactic of some parties. Because that happens, it's easy for commissioners to get sidetracked. You can lose sight of why exactly we are here today. So to remind everyone, the reason we're here today is because of what happened in Firestone. If that had not happened, if the loss of human life had not pointed out a glaring hole in flowline regulations, we would still be operating under a Series 1100 that was all of 2.5 pages. So yes, getting it right is important, detail is important. But please do not lose sight of the intent and the context of this rulemaking, and that is to make the gas and oil patch a safer place for those who live there now and will be living in it, as there is more interface between industrial, residential, commercial, and institutional development. So when I write in my testimony about the need for the public to know where flow lines are, because knowing where something that can kill you is located is a good knowing. More accurately, it's not just a good thing to know, it is a requisite thing to know. It's a must. People have to know where things that can kill them are. It is unmistakably clear in Senate Bill 181 that it mandates full public disclosure and easy access to where things that can kill people are located. Oil and gas development in Colorado has never been dealt with from the cradle to grave, full cycle of impacts perspective. This rulemaking on how pipelines are dealt with after they are no longer in use is a good place to start that practice. Ideally, all pipelines should be removed upon abandonment, but if there are going to be exceptions to this ideal, they must be only for highly extraordinary circumstances. The operator must obtain a permit and must clearly document that abandonment in place will have no adverse impact on public health, safety, or the environment. The guiding principle by which to judge your decisions on what rules you finally decide on is not, does the rule inconvenience an operator in some way? Does compliance cost an operator more money, or is bad for business?
You
Or
need
does
to
it
wrap it
take
up.
more time or forethought for the operator? The principle is, does the proposed rule maximize public safety for the people of Colorado? Thank you.
Thanks so much. Any questions? See
You mean I drove 760-mile round trip for no questions? What's that all about? Okay, thank you very much.
that you're here.
Yeah.
Yeah, thanks a lot.
Thank you. Thank you. Okay, next we have the Western Colorado Alliance. Once you're situated, please introduce yourselves, let us know who you represent, and then you have 9 minutes altogether.
Good morning, Commissioners. My name is Matt Samuelson. Here on my right is Matt Sura, and we're here with Western Colorado Alliance, Grand Valley Citizens Alliance, and Conservation Colorado. The document that was distributed to you earlier, just a bit ago, is recommendations we've made in our pre-hearing statements and responsive statements, but they're just overlaid over the staff's November 18th staff draft, just for to be a little more clear with what the recommendations we're making. First of all, I just want to start that we agree with the statement made by Commissioner Overturf yesterday regarding wanting some complete information about flow lines in the state that have tracer wires. For off-location flow lines that have tracer wires, as required by the state since 1996, we think that the COGCC should require that horizontal positional accuracy of 1 meter and not the plus or minus 25 feet. With short time, I'm going to move fast, and I apologize for that. In regards to wildlife, we appreciate the inclusion of minimizing interference with wildlife resources in the provision pertaining to installation of flow lines. However, we're still advocating for language that better reflects Senate Bill 181, where the COGCC must protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. It's a long list, and sometimes the wildlife resources portion gets dropped. Yesterday, Julie Murphy mentioned in the statement of basis and purpose that there was provision in the SBP, and we think that's a good first step. But the language that we have offered in our response statement uses Senate Bill 181's language around avoid, minimize, and mitigate as a hook for future discussions on flow line siting requirements that has been referenced as potentially happening in the mission change rulemaking.
As stated in our response, our clients continue to support the affiliated local government's request for annual self-certification for compliance with the 1101 series rules. Moving to 1104D in our red line, There are two types of monitoring that are discussed in these rules. There is AVO, which is auditory, visual, olfactory, and then there's instrument monitoring. Methane, being both invisible and odorless, does not respond well to AVO. In fact, it's almost useless for finding gas leaks. On the other hand, instrument monitoring, specifically using a FLIR camera or forward-looking infrared cameras, is very responsive and can find those leaks. For the past several years, the Air Quality Control Commission has required operators to report on monitoring inspections and leaks found and repaired. In 2018, there was over 700,000 AVO inspections that were reported on, and they found 2,100 leaks. That's less than 1%. On the other hand, you also have 22,000 instrument monitoring inspections that found over 20,000 leaks, which is over 91%. Point being that we would like to see the requirement for semi-annual instrument monitoring in 1104D. Moving into discussions about abandonment, appreciate the work that the staff has done and all the stakeholders on this. I think it's moving in a good direction. As discussed by Deputy Director Julie Murphy, there are really three types of abandonment in place criteria that they're looking at. The first is broad exceptions. Those that abandonment in place is likely to be allowed, and in fact, there's really no review of those. It's just a notice that you're planning to abandon in place in those instances. And then second, there's a 30-day review period by the director. And then third, a more extensive review to determine whether or not, the first standard being whether or not public health, safety, welfare, and the environment is better protected by abandoning in place or removal. There are some criteria as to how the director is judging whether or not it should be removed, and that is listed in the regulations currently as just looking at best management practices and mitigation measures that are proposed. We have heard from industry loud and clear yesterday that they believe that abandonment in place is not appropriate when there is development occurring or going to occur. And so we'd like to include that into the criteria in this 1105 series, looking at future land use in the area.
I'm going to continue talking about the abandonment in place, but I'd like to focus on the revegetation component. You know, we recognize that when an operator installs a flow line, it has a significant impact on the landscape and the vegetation. And that's a conversation that we want to revisit in the mission change rulemaking when we actually talk about siting and where flow lines shouldn't be. You know, areas where it's difficult to revegetate or wildlife habitat in corridors or near rivers. However, our concern with the current staff draft version is that the revegetation exception will swallow the entire rule. Commissioner Gibb, you asked yesterday if there should be an objective standard, and we think that there should, because as it's currently written, there is no oversight from the COGCC and no standard for use of this particular exception. In particular, the language in process, you know, that could be one day or it could be several years, which means it could apply to nearly any flow line in the state. And it's just too subjective to not have any review from the agency. You know, Colorado has a standard for final reclamation of well sites and access roads, requiring the establishment of a uniform vegetative cover of at least 80% of pre-disturbance area levels. However, flow lines are not included in that 80% standard. In fact, the reclamation rule for flow line states, disturbances resulting from flow line installations shall be deemed adequately reclaimed when the disturbed area is reasonably capable of supporting the pre-disturbance land use. We just don't find that to be a standard that would justify itself not having some sort of review from the COGCC before allowing for that exception. So our recommendation is to move the revegetation exception to the proposed rule 1105D3 and to remove the clause in process. Because the proposed exception is subjective, in order for an operator to utilize it, there needs to be a higher standard of review from the director. In its current placement in the proposed rules, there's no review of the revegetation exception. And with no review and no standard, we really do think this is the exception that breaks the rule. In regards to removing the phrase "or in process," we also think that that again is too subjective. The phrase could be reconsidered during the mission change rulemaking when an actual objective revegetation standard for flow lines could be addressed during a reclamation conversation. Okay. We actually have a little bit of time. So the last point that we wanted to make is, unfortunately, Commissioner Putnam isn't here, but we appreciated his questions yesterday about air quality emissions and the impact from removal of flow lines. But it raised two thoughts. First one is that I hope we don't take too narrow of a look at air quality emission impacts from oil and gas development. Yesterday, we heard a back of the envelope calculation from a gentleman from PDC Energy who gave an estimated CO2 impact from removing 2,000 feet of flow line. But what would that carbon footprint impact be if we calculated the impacts of scraping the land, building the pad, drilling a well, fracking the well, installing the flow lines, moving the product, and then reclamation? There are numerous practices in oil and gas development that could be altered to reduce air emissions. And so we hope we take a holistic look when we have that conversation. And the second point to that is that we think that the proposed catch-all provision in 1105D4 addresses the concern about air emission impact, because that particular provision allows the operator to request abandonment for reasons other than those articulated exceptions in the rule. So, we have language that allows for operators to make that case to the director. And that is actually all that we have. Appreciate your time. Thank you very much.
Thank you, Commissioner Boygan.
Thank you, Mr. Chair. So either one of you can answer this, but on the revegetation issue, what the language of staff's draft actually says is that successful revegetation has occurred or is in process. Wouldn't you construe that to be a requirement that the operator, in submitting the Form 42 and claiming entitlement to this exception, has to make a showing that successful vegetation is in process, and don't you assume that the director will have guidance on what kind of showing has to be made in order to be entitled to this exception?
Commissioner Boygan, I think that is true. I think that there would have to be some sort of showing from that operator that successful revegetation had occurred or is taking place. I think we heard last night, though, that there's a lot of different sort of subjective ideas on what is in process. It could just be the regrading, planting taking place. There's a lot of different aspects to revegetation, and I appreciate how difficult that is. But I think that without having a little more guidance from the rules here, that it's just too wide open, and it allows for a lot of subjectivity that's not necessarily going to require review from the director in its current location in the proposed rules.
And frankly, that's the.
I don't agree, but I'll.
So the larger concern is that it currently is in just the notice provision, and we don't read the notice provision to require any review, frankly, from the director. We would like to see that move down so there is some review, so they could be asking the questions that you're concerned with and that we're concerned with, and weighing whether or not reclamation and possibly going into an existing corridor and pulling that pipeline is offset with the protections of public health, safety, and welfare that are going to be gained, particularly in those areas that are going to be moving into a residential area, going from very rural to residential.
So could I follow that up? So you don't construe this exception, 1105D2, to permit any sort of review by staff of the submittal by the operator of entitlement to these exceptions. The operator submits form and bingo, can go ahead and abandon in place because nobody can question what the operator has submitted. I don't construe it that way. I think there has to be, like many other forms submitted by the operators, a submittal in compliance with whatever directives the staff are going to issue to make an appropriate showing that there is a surface use agreement in place that allows it. Federal government directs abandonment in place. Successful revegetation has occurred or is in process, or it's co-located with other active pipelines or utilities. There has to be a showing which somebody's going to review for sufficiency. You don't agree with that?
I do agree with that. However, showing of sufficiency that indeed that it is an area that is adequately reclaimed doesn't meet our really more important objective to make sure that there is a criteria, that there is a review of that based on what is best for public health, safety, welfare, and the environment, including wildlife. There's no objective criteria that is being reviewed under those exceptions to the rule.
So then you're objecting to the whole revegetation exception, whether it's been successful or not, or whether it's in process or not. You just don't like the fact that there's a revegetation exception to removal.
We believe that there can be an exception, but it belongs in the second tier where it's a 30-day review rather than just allowing them to check the box that yes, it has reclaimed, and therefore they get carte blanche exception to the requirement to remove.
Commissioner Hopkins?
Yes, thank you, Mr. Chairman. A couple questions. One is on to make sure I understand, when you talked about the self-certification for compliance, that's basically an endorsement of what the local governments recommended with regard to responsible official providing that annual certification. Is that correct?
That's correct.
Okay. Instrument monitoring. When you talk about the LDAR and flare camera approaches and as I understand it, this is for all the surface facilities, and it wouldn't have any application to the below ground flow lines.
That's as I understand it. It doesn't work for below ground, but it would work for anything on the surface.
Yeah, that's my understanding too. I guess this is a question for staff. Are there inspection for above ground surface facilities? Are there current requirements in the COGC rules regarding inspection requirements using instrumentation and such for emissions? Now I'm doing emissions actually, which is a form of leak detection. And I just don't know the answer to that. And I should know, but I don't. Should we wait for that?
Yeah.
Okay.
We'll get back to you.
All right.
Could I just quickly respond to that? I think that the section they're focusing on is 1104D, which has to do with above ground on location flow lines. So we're only talking here about those locations that are those flow lines that are above ground and are on location.
On location, and so it's not really extended to off location flow lines.
Typically, off location flow lines are buried, as I understand it.
Yeah. Okay. Thank you. I think that is. Yeah. Thank you very much.
Commissioner Overturf.
So I have a few questions, but I'll start in that same area of the rules. So I understand the proposed edits that you have to Rule 1104D as requiring essentially a redundant form of leak detection for these specific, again, above ground on location flow lines. I wonder why you think that kind of redundancy is required only for that category of flow lines and not for other types of flow lines, recognizing, of course, that the actual instrument monitoring that you described here may not be applicable, but why are you not joining the affiliated local governments in asking for a second type of integrity management for below ground or for off location flow lines?
It's an excellent question. We are supporting that, but we didn't feel that within 9 minutes we could go through everything that we would like to see changed.
Well, then I'm glad I asked. Okay. My other question has to do with the proposal from the affiliated local governments that you've endorsed about the new Rule 1106 that would create the self-certification requirement. Help me understand what you see as the value of that requirement. If a bad actor is committed to not following the commission's rules, why will having them do a certification change anything?
Well, for one, I think that it is affiliated local government's proposal, and they may be more equipped to answer it. But
why do you like it?
Why we like it is because we do think that there is value in somebody signing on the dotted line, that there is somebody responsible to say, you know, this is in my purview, this is something that I am signing and certifying has occurred, and we are complying with that. We have a plan in place to ensure that we're complying with all 1101 rules around flow lines, and ensuring that there is one person that, you know, is going to be certifying that is helpful for ensuring that you know who to go to, who is the responsible party when something isn't done.
Are there any, I feel like the affiliated local governments may have discussed this in their materials, so forgive me if this is already in the record, but are there other examples of where this kind of self-certification is used and provides value?
I'm aware of self-certification within the Air Quality Control Commission regulations. Not that I can point to within the COGCC regulations.
Now that you say that, I recall that that was an example that was put forth in their testimony, so thank you.
Yeah. Commissioner Messner.
I know, every time. Thank you. So I appreciate the intent of, you know, analyzing the potential impacts to abandoning in place versus removal, particularly around you know, impacts to the environment and wildlife resources. I do understand that there are different considerations to the benefits or disadvantages of abandoning in place versus removal, depending on where you're at in the state and what kind of situation that you're in. And I'm still noodling on the concept that was brought forward by the associated local governments, you know, around the term resource, resource damage versus revegetation as kind of the term to consider in this particular situation. And I'm thinking about that in a way that, you know, there's certainly situations, particularly you know, on the western slope, for example, where, you know, abandoning in place, you know, is going to have significantly less resource, you know, unmitigatable or unresolvable resource damage than removing that particular flow line, particularly when we're talking about sensitive environments and wildlife resources. And so how do we, in your opinions, kind of come up with language, or how do we resolve that particular situation where we're looking at, you know, pipelines that are already in the ground, right? Flow lines that are already in the ground, you know, and there's this potential requirement to remove these pipelines, you know, in areas that, you know, really the removal would make a, you know, a significant impact to wildlife resources, migration corridors, you know, potential water bodies, you know, as well as sensitive soils. I mean, how do we resolve that in this language?
I think that it's already in the language.
Mm-hmm.
Right now, we have the ability of the director to be able to weigh what is going to be most protective of public health, safety, welfare,
Mm-hmm.
and the environment, including wildlife resources. And, you know, the example that you give of an oil and gas flow line on the western slope that may go through sensitive wildlife habitat,
Mm-hmm.
may go underneath a wetlands. You know, I don't think that there's anybody that would argue that that should be removed.
Mm-hmm.
However, I think that there are safety concerns, particularly on the Front Range, in an area that is fast. You know, I'd say all of northern Adams County is fast moving from an area that has some rural characteristics to something that's going to be quite urban.
Sure.
And in those instances, I think that the de facto has to be that you're going to be requiring removal based on health and safety issues rather than environmental issues. It's all going to be paved over, or it's going to be sodded, and it's going to be, you know, backyards or homes. So the real concern then is health and safety, and in those instances, as was already testified by industry, that is when you have to have removal, and that's really when.
And so I don't disagree with you. My question was, you know, do you feel that there are that the language allows for abandonment in place, you know, in instances where there's potential impacts around environmental and wildlife resources? I acknowledge and I understand the differences between the Western Slope and the Front Range in this particular situation. I'm just trying to understand whether you felt the language was appropriate for situations on the Western Slope.
I do, and in many instances, I would think that, again, that balancing out protecting public health, safety, and welfare in the environment is best accomplished through abandonment in place in many instances on the Western Slope.
I appreciate that. I was just trying to make sure that I understood where you guys were coming from on that. So,
Any more questions? Yeah, Commissioner Eden.
In your proposed language for the replacement or your new vegetation language in section 3, you specifically talk about that the line is in a sensitive area for wildlife or plants. And I appreciate that you included or plants in there as part of the biological resources that we're supposed to be looking at. But do we have definitions, or what would be the basis of the identification of those sensitive areas for plant? Or is that something that could be just evaluated as part of the record? Is it, I guess I'm trying to ask if that's a designation.
Commissioner Eden, it's a good question. The language that we had there with the sensitive area for wildlife and plants is replicating earlier staff draft language. And so when we were making this recommendation, we were looking not to completely turn over the cart on what staff was doing. I think with the sensitive area for wildlife, you know, we do have some of the maps that have been created in the 1200 series and some areas that we're hoping to address in future rulemakings. But we do think that it's a good question, and it would require a case-by-case scenario for some of those.
And frankly, that's why we like the language and adopted it as our own, because it does require a case-by-case evaluation, and I think that that's appropriate.
I appreciate that.
You know, given that our client's position is that right now, sensitive areas and protection of wildlife and wildlife corridors is not something that is adequately addressed currently in the rules. We would like to see a case-by-case analysis.
Thank you.
Any more questions? Is that it? Okay, thanks so much.
Thank you. Thank you.
And next up is Aaron Martinez. So, Aaron, whenever you're ready, please introduce yourself, and we have, I believe, 10 minutes left for you.
Thank you. Good morning, Commissioners. Chairman Gibbs, Director Robbins. I'm Bob Randall here on behalf of Ms. Martinez. We do trust that you've reviewed our pre-hearing filings. So Ms. Martinez is going to summarize her testimony, and then we're happy to take questions.
Thank you for allowing me to speak here today. My name is Erin Martinez, and I am a survivor of the 2017 Firestone home explosion. I would like to start my testimony today with a story of the harsh reality that can result when safety is not our first priority and inadequate regulations are in place. I ask that you sit back and listen and remember this tragic story when you are deliberating and deciding the fate of the flowline rules. My husband, Mark, and I worked incredibly hard to buy the house of our dreams. We were so happy in our new home and had just finished the last few rooms in our house, making it exactly what we wanted it to be. We lived in our new home a little over 2 years, and we never had any problems in the new house. On April 17, 2017, I got off work and picked up my son and drove home. Both of us immediately went down to the basement and worked out on the treadmill. When my son was done, he left to his room on the second level and began playing video games to unwind from his school day. My brother Joey arrived, and I was joking and talking with him in the basement, waiting for Mark to get home from work. Mark showed up, and both of them began discussing the situation and deciding their course of action. We had had hot water heater trouble over the weekend, and they decided that they were going to install an inspection tank on the new hot water heater. I had to leave to go pick up my daughter from school, so I told them goodbye, and my brother jokingly told me to grab drinks and dinner for when we were done. I never dreamed in 1,000 years that those were going to be my last words to them. I headed upstairs to leave and noticed the dogs wanting inside. I walked over to the sliding glass door and I opened it. I was immediately thrown into the air and the entire house was crumbling on top of me. I was trapped because the entire top floor had fell on top of me because the house was lifted off of its foundation when the blast occurred. I tried freeing myself from the debris, but each time I moved, the weight on top of me began to apply more pressure and I was literally being crushed. It became very clear very fast that I was trapped. My son was blown into the air as well, and he landed on the floor of what was his bedroom. He crawled through the debris to his bedroom window, making the quick decision to jump out and save his own life. When he made that decision, he would never know that it would also save my life as well. Can you imagine being an 11-year-old boy chilling in your bedroom after school, one moment, and then the next, you are fleeing your bedroom window from your house, literally collapsing around you? My son then realized that his mom, father, and uncle were not coming out. They were still trapped inside. He began screaming and running, looking around for a way back in. A group of heroic construction workers nearby saw him jump and could see his panic and hear his screaming. They immediately came to his aid, and he told them I was still trapped inside. Later, he shared with me that he knew his father and uncle were gone, but that he knew he needed to get help to me right away. They miraculously found me and began trying to free me from the debris, but each time they pulled, I became more stuck and more of the house became piled on top of me. Fire had started to spread throughout the house, and they were also trying to keep the flames away from me. Suddenly, I remember seeing a piece of equipment plow through our backyard fence, and it was a forklift that they used to lift up part of the house, allowing me to wiggle free. They pulled me out and carried me to a dirt field behind my house. Moments later, the entire house was engulfed in flames, and everything began to fall to the basement. My son came running over to me and immediately began crying and asking me if I was okay. I can remember being in a lot of pain, but I remember lying to him and telling him that I was fine. I just kept panicking and asking, where is your dad? Where's your uncle? Where's your little sister? We have to get back in there and save them. This is where my memory begins to quickly fade. My son was taken to an ambulance, and I was driven to a place to get on the flight for life because it couldn't land because of the heat of the explosion. We were both taken to Anschutz Hospital. I awoke the next day in the burn ICU, trying to piece together what had happened. I quickly learned that my son and daughter were okay, but they had not located Mark or Joey. The house was so hot that no one could go near it. They planned to try and rescue in the morning. We were all holding on to hope that they would somehow find a way to survive. However, our worst nightmare came true when they were pronounced dead the next day. I spent the next 2.5 months trying to fight to stay alive. Not only my injuries were complicating that, but I wasn't sure how to go on without my husband, my soulmate, and my brother, who was my best friend. I found out that I sustained burns on 40% of my body, had a collapsed lung, broke all of my ribs and most of my vertebrae, shattered my right clavicle, tore all the ligaments in both of my knees, and was bleeding internally. If I was going to survive, it was going to be an upward battle. I have spent the last 2.5 years of my life trying to recover from this, and I have had 29 surgeries to date, and I still have lots more to come. My poor children have had to watch all of this, losing one parent and always wondering if they're going to lose the other. No child should ever have to witness or go through what mine have had to endure. I dated my husband Mark for only a few weeks, instantly knowing he was the one for me. We were engaged in less than 6 months of dating and were a month away from celebrating our 15th anniversary when he left this world. I instead celebrated this anniversary alone, without him, in the burn ICU fighting for my life. Mark was my everything, an amazing husband and a hands-on father. My children do not get to grow up with him, and their childhood was literally taken from them in an instant. My brother was a big teddy bear, always making us laugh and willing to help anyone. He lived next door to us for almost 8 years, so he was a huge part of my children's lives. Losing one person is hard enough, but losing two at the same time is unbearable and feels like a giant hole has been pushed in your family. I am sure you are sitting there thinking, what relevance does this have here today? And to that I would say, it is important for you to understand what was taken from me, what the results of inadequate regulations can lead to. The goal here today should be what needs to happen to prevent this horrific story from becoming someone else's reality. I know the rules have changed since 2017 and that these changes make my tragedy less likely to happen, but I wouldn't be honoring the memory of Mark or Joey if I didn't try to eliminate the possibility altogether. Let's go back and trace the circumstances that led to this nightmare and look for places for improvement. In 1999, Patina plugs and abandons the flow line that was 6 feet from our house. This paperwork is then sent to the COGCC, and it goes on record that this particular line is not in use anymore and that it has been properly plugged and abandoned, posing no threat to the future homes that will be built there. It would later be discovered that the line was not properly abandoned and the rules were not followed. The line was supposed to be cut 3 feet below grade and disconnected from all sources. Obviously, the line should have been abandoned properly, and I also think someone should have verified it was disposed of properly rather than relying on the oil and gases industry word in the paperwork that they filed. I think the only way to avoid an abandoned line becoming a future conduit of gas is to remove them from the ground when the industry is finished with them. This is the only way to prevent them from causing future devastation. The rules of abandonment were in place in 1999, but they weren't followed. Who is to say if you allow exceptions to abandonment here today that this won't happen again and pose a threat to our safety? Sometime later, the well is sold to a new owner. They also do not notice that the line is improperly abandoned. The well is sold several times after that, each time nobody catching the negligence. I think we should require an inspection when wells are sold from one company to the next. Not only would this catch issues or problems with the well, but it would also create a better paper trail to keep track of where wells are as they become orphaned, plugged, and abandoned. As myself has learned, they don't always know where these things are. When Anadarko owned the well, it became shut in. Reactivation of the well occurred on January of 2017, 4 months before the home explosion. All the valves were simply turned on. No pressure testing was done, nor any inspections. The well was just turned on and simply walked away from. I think it is essential that when a shut-in well goes back online, inspection and pressure testing is done to make sure everything is operating as it should be before the well is allowed to go back online. I also think any residents and local governments around a shut-in well should be notified that a well is going back online in advance. I don't know for sure, but had we known about the dormant well going back online, we may have asked the right questions to see if it was leaking. We have a right to be given all the pieces of a puzzle when we are trying to make educated, informed decisions. This information piece leads me to my final rule, disclosure. The public has a right to know what is in the ground in and around where they choose to live. Our homes are supposed to be our safe havens. We shouldn't have to worry about them exploding from gas seeping into our basement. We should be able to make informed decisions about where we choose to live, where we go to work, and where we send our children to school. However, we can't do that without accurate, precise information. I think it is, or excuse me, existing flow lines need to be reported within 1 meter of accuracy. I think it is so negligent that industry is relying on old photos to get within 50 feet corridor of old flow lines. Operators should know where their equipment is, period. I have seen firsthand that they don't. My new house was supposed to be free of oil and gas infrastructure. This is the information that the COGCC had on file. But I would later learn that this information was not accurate and that there is a plugged and abandoned well on the property line I share with the neighbor next door. Had I been given accurate information, I would have made the decision not to buy the house. Accuracy and precision and disclosure of all oil and gas infrastructure is vital to public safety. As you deliberate on these proposed rules, I urge you to think about public safety and about what can happen when oil and gas infrastructure are left behind. Devastation and tragedy happens when an industry is not properly regulated and the necessary rules are not in place. Mark and Joey deserved better. My children deserve better, and we all deserve better. Thank you.
Thank you, Ms. Martinez, for your testimony. Any questions? Commissioner Overturf.
Thank you. So first, I just wanted to say that your engagement in this proceeding has been both thorough and substantive, and it's been an impressive way to honor your husband and your brother. So thank you for that. So I wanted to turn to the actual proposed changes to the rules that you've laid out for us. One is that your request that surface owners get a notice of abandonment. And I'm wondering if in the current staff draft, there are changes to Rule 1105 D5, and I'm wondering if those are sufficient from your perspective. So there's the new language that's been added by staff is that unless waived, the operator must provide notice to the surface owner simultaneously with submitting notice to the director pursuant to this rule. And so I wonder if that satisfies your concerns or if there's additional changes to that language that you would request.
So you're saying that when abandonment in place is decided that the surface owner is going to be let known of that?
That as part of the abandonment process, the surface owner must be notified, right?
I think it's great for them to be given the information, but I am pushing for no abandonment and removal of flow lines.
Sure. Okay. That was the only question that I had. Thank you.
Other questions? Commissioner Eden.
Thank you so much for being here and for really focusing us on the important things in this rulemaking. One of the issues that you raised is the accuracy of the information, and I think we have heard that developing additional accurate information would take more time. And so I'm interested in, whether you have thoughts or suggestions about how to bridge that gap between sort of information we could get sooner and more accurate information in more time.
I think first and foremost, the information has to be accurate. I think as the story that I just told, I was told that a plugged and abandoned well was about close to 2,000 to 3,000 feet from my home. And I found out that it's about 5 feet from my backyard. I think that you've got to make sure the information is accurate. And I feel like industry yesterday said that the lines that are past 1996, that they have tracer wires in them and that they could get that within a 3-foot accuracy. I feel like it was the lines that post-dated that is where they're having their difficulty. I think that perhaps the lines that are 1996 to the present, you know, that they could still be held to that accountability to have that available by, you know, 2020 of December. And perhaps the older lines, you know, we're going to have to find a way to get within that accuracy and perhaps more time for that. But I think that it's imperative that, you know, we are providing the public with this accurate information. And I think that for me personally, the flow line that ultimately leaked gas into the basement was 6 feet from my back door. If you have the plus or minus 25 feet or the 50 corridor scale being used, I wouldn't have known that that line was actually on my property, and I wouldn't have been given that information to make an educated decision as to whether or not I wanted to live 6 feet from a flow line. And in addition to that, you know, you brought up the point about that line being abandoned and that being shared with the surface owner. But if it's not abandoned properly, then what point does that information serve? I think that it's really important that you guys understand that, you know, we had industry up here yesterday talking about a very simplistic way in order to abandon these things in place. Number one, you disconnect it from the source. Number two, you remove the risers from both ends. And number three, you cap it. And they claim that, you know, that's done in all cases and that that's a very simplistic approach and a safer thing to do than removing them. But in my story, and they said yesterday that as long as one out of those three things are done, it will pose no, you know, it will pose no threat to those around it. However, one of those things was done in my situation. It was disconnected from the well. The other two things weren't, and look at the devastation that that caused. The NTSB report says that that line was reconnected to the well at some point during the 1999 abandonment and 2017 explosion. Somebody actually went out and reconnected an abandoned line to an active well. And in addition to that, it was shared with me a few weeks ago that they actually went out and worked on the line. They replaced parts of the line, a line that is supposed to be plugged and abandoned and is on record with the COGCC as abandoned. And so I just really urge you, as you move forward with these rules and you're going to allow abandonment in place, if it's not done right, it's going to lead to more horrific devastation and disaster. And unless somebody is actually going out and verifying that it's done, I don't agree that we should have someone in the industry that's higher up basically rubber stamp that the abandonment was done properly. I think you need a third-party affiliation going out and verifying that all those three steps are being done and seeing with their eyes that that is what is happening. And I also think that I would urge you that members from the COGCC should be present when that abandonment takes place. And I really feel that a lot of the exceptions that you've put in place in these rules really water down the intent of the rule, which is if it is going to be left in the ground, it needs to be safe. And I think that the revegetation piece that several people have brought up kind of does give a blanket for most of those things to be left in the ground. And I think that moving forward, that you need to really push for removal of these lines unless in very rare cases. And if you are going to allow them to stay in the ground, then that verification process needs to take place. Because, I mean, if my story shows you nothing, those three simplistic steps that should have been followed weren't followed. And it led to intense, disaster. And I think in addition to that, industry said yesterday that often abandoned lines are also attached to abandoned wells. In my case, it was still active. And the bottom line is, had the flow line been removed when the tank batteries were removed, I would not be here having this conversation with you. Mark and Joey are dead because a line was not properly abandoned and it was allowed to be left in the ground.
Commissioner Boygan.
Thank you, Mr. Chair. First, let me also express my appreciation for what you've done. Scant consolation to you, but the rules that have been put in place already, I believe, a year and a half ago, have contributed to protection of public health, safety, and welfare in this sector of the industry. And I think the rules that we're considering now will provide an even greater level of protection, and it's attributable to you, not only to the tragedy that you suffered, but to the efforts that you've undertaken to make sure that we all are very focused on what needs to be done. So I commend you for that, and I express my condolences for what you've had to go through. I don't have too much more to offer or to ask about than what's already been discussed, but in my view, in reading the NTSB report, there were a series of violations and poor practices and negligent behaviors that caused this horrific accident. And one of the areas that strikes me and that has bothered me all through these proceedings is that a significant part of the problem is determining when infrastructure has to be abandoned. In this case, in your case, a report was filed that the line was abandoned. The report says that the NTSB report says that in fact the line was not abandoned, that the procedures stated to be implemented had not in fact been implemented. And so someone went out later on and reconnected it. And so I believe that the changes that we're implementing in the current rule would prevent that from happening because of the increased requirement to disconnect equipment, disconnect the risers, remove the risers, cap the lines, purge, all that stuff. When that's done, in my view, you've properly abandoned. That wasn't done in the case of the line near your house, unfortunately. But in a situation where, for whatever reason, an operator should be doing it and isn't doing it and leaves the line sort of in place, maybe takes some temporary measures to put it out of service, but leaves it in a state where it could come back into service. To me, that's the situation that causes extreme danger, and results in the kind of horrific accident that your family experienced. I say all that not because I'm asking you for a solution. You've given us a number of very helpful solutions. One of them that I think we ought to be really focused on is the inspection issue, both in terms of abandonment having occurred properly and in terms of reactivating lines that are out of status. But the concern that I have is much of that depends on operator compliance, on operators following the rules. And even with all these rules, there could be situations where that doesn't happen. I think that what these rules are trying to accomplish is to prevent those situations to the maximum extent possible by closing the gaps where operators, for whatever reason, are not necessarily following the rules or filing the right forms or abandoning when they should be abandoning. And so my question is going to be for staff and for my fellow commissioners to focus on what should we be doing in these rules to make sure that those practices are properly followed, because I think that the rules as they are now constructed and are proposed to be revised would have prevented what happened to you. So that's a long way of saying that I think that you've accomplished an extraordinary amount, and you shouldn't lose sight of that. And there are undoubtedly things we can do to be even better. I'll just end by focusing on one more aspect of what you've talked about, which is the old wellhead the old plugged well was near your property. These rules won't address old plugged wells, but it's a problem, it's an issue. And it comes back to me also to the situation of wells that are out there that maybe should be plugged and have not been abandoned. All of that is for future discussion. And again, you've focused us on that in a way that undoubtedly should have been done before, but we're doing it now. So I just want to thank you.
I appreciate that. And I really believe that, you know, you touched on something that's very important to me, and that is, how are you, I mean, you're going to write all these rules, great. We're going to throw these rules out there. How are we going to guarantee that they're actually going to be followed? And I think that that is a challenge that is before all of us. And I really, really, really urge you in the things that have to do with abandonment, that we have to have some sort of verification process. There has to be somebody actually going out and verifying that these things are being abandoned. We can't take their word for it that the 3 things have been done and they've been checked off, or somebody higher up in the company is rubber stamping it and saying, yes, I stand behind the company that was done. There has got to be some sort of a verification process that happens outside of the industry, and that we need to actually be present when these things are being abandoned. If we're going to move forward, allow that, we have to have somebody there present watching that happen and making sure that it is actually done. Or I can say with complete certainty that these types of situations that I am in will continue to keep happening.
Are there any more questions? Seeing none, thank you again so much for your testimony. Thank you, Mr. Randall. Thank you. We will take an hour break. We will come back at 1 p.m. Stewart.
What are you thinking?
Okay, the COGCC meeting will come back to order. Next up, Director Robbins, the floor is yours.
Thank you, Chairman Gibbs. So wanted to talk to the commissioners about sort of next steps. We've now heard from the 510 statements, we've heard from the public, and we've heard from the stakeholders. What staff will do at this point is to provide you with, we've got a PowerPoint that we put together that is comprises what we've heard. And obviously we don't know where you think this flow line rulemaking ought to go, but we wanted to try to inform you of some of the things that we've heard from the stakeholder testimony. We've got some edits that we would propose from staff's perspective. We'll go through that, and then once we go through that, then we would allow the commission can ask questions, and at some point then you would close the public testimony and then move into deliberations. And Kyle and I did not talk about this ahead of time, but Kyle, do you want to maybe talk about process, just so that before we start talking, the commissioners can understand what the rest of the day looks like?
This is Assistant Attorney General Kyle Davenport. Commissioners, at some point in the near future, you're going to reach a point where you're ready to finalize and deliberate on these rules. At that point, you'll close the record. And I know we've been through this once before, and I briefly described it before, but I think it deserves revisiting at this point. I'd like to briefly explain the consequences of closing the record. Closing the record is effectively stating that you don't need any more further information from the parties, or really from staff, to make your decision. Until you close the record, you may ask any questions you wish of the parties and of staff. In regard to asking questions of the parties, as I said, you can ask to have any other party come up and give you an opinion or give you an answer to a question. That doesn't mean that you have to recognize or allow other parties to come up and also give you an opinion. You're in total control at this point of who speaks to you in regard to any issue. But once you close the record, you may not ask questions of the parties, and you may not ask substantive questions of the staff. The staff can help aid you in perhaps clarifying some language of a rule or pointing you to the correct place in the rules. But if, for example, you have a proposal for a rule that you'd like to get staff's opinion on, then you should do that before you close the record. I think a good way to think about closing the record is until you think you're quite close to just simply having a draft of the rules that you're ready to maybe briefly deliberate on, but you're pretty close to that. I wouldn't recommend that you close the record. Does anybody have any questions on that? Okay, thank you.
Okay, so with that, I'm going to turn it over to Ms. Murphy, who has done a remarkable job on shepherding this flow line process, and we'll provide you our staff perspective on what we've heard the last couple of days.
Thank you, Director. And Chris, I'll be working with you yet again. And also, I hope you're still on call when those wonderful specificity, accuracy, mapping questions arise. I know we've had a lot of conversation about that in the last few days, so I think we should start by jumping straight into, yes, sir.
I'm sorry.
I'm sorry.
I don't
Still
want
not allowed to
to
call on you.
interrupt your flow, but I don't want to interrupt your flow at the wrong time. Just as a, should we wait for questions till the very end of your presentation, or can we intersperse as you go through if appropriate? I just want to know what you thought.
Absolutely intersperse.
Intersperse.
Break my train of thought.
So I can break your train of thought?
Already done.
All right. Fair.
Okay, so Chris.
Commissioner Hahn.
Sorry, this will never get started. So we got these yesterday, and
Correct.
I think you've made a few changes.
Correct. Yes.
Since this
Yes.
came out yesterday. So
Yes.
you'll just guide us through the changes
I
that
will.
we need to add to this.
Yes, and I believe Hannah is printing a copy of the present
The newest
PowerPoint
version.
for you as well.
Okay.
So,
So we'll stick with this until we get.
yeah, or just, stick with me on your Zoom screen and up here. So, anyway, so Chris, if we can cue to the first slide.
Just to be clear, you revised this PowerPoint.
I have revised that PowerPoint. This is a PowerPoint anew. It follows the same structure. I want to talk about issues 1, 2, 3, 4 first in that same order to reflect the changes that staff is recommending that this commission consider in light of the testimony that staff heard yesterday, in light of the questions the commissioners asked yesterday.
If I could break Ms. Murphy's train of thought one more time. Commissioner Putnam just texted that he is on Zoom and will attend the rest of the hearing via Zoom. I think everyone knows he had an AQCC meeting this morning, but he is now with us. So.
Fantastic. And so as we jump now to the next slide, issue 1, and you'll see I've created effectively a screenshot of 1101E, the disclosure of Form 44 data. Based on the question and the dialogue, I still recommend that this commission consider a scale of 1 to 6,000. However, I think it became apparent that there is an opportunity to partner more effectively with our local governments to distribute parcel-specific information to individuals via their local governments if the local government so chooses. So we made a couple of important changes to subpart 2. One is to broaden the use for which a local government can access our data. And then to clarify that the local government can provide it to any person or on their website in the same form that our commission makes it available to the public, whether through the website or in person. We think, again, these are important changes that reflect comments from a number of different parties. And I think the piece, after giving that overview, I think the piece about the 1 to 6,000 that is important that I would like to revisit and is that the relationship to our aerial imagery on the map is not 100% precise, meaning that you can't look at our aerial imagery and see the corner of your house and see the road next to it and map that knowing it's going to be exactly that data, right? It is an illustration of approximately where a house is in relation to a road or a well. And so understanding that fundamental limitation of the map, I think, is important then as we consider what degree of information we make available on it at what scale. And so that's why one of the reasons that I think 1 to 6,000 is appropriate. Our map isn't totally perfect. And so making sure we have an illustration of the information that's available is what we are trying to accomplish here today. I think that sentence got a little bit lost. So bear with me as I take another cut at it, which is we want people to be able to look at an aerial image on our map and be able to see where flow lines are or other oil and gas infrastructure in enough detail that they could make an informed judgment about whether they need to pursue more information, whether it's from our agency, whether it's from the operator, or whether it's from 811. And we think at the scale of 1 to 6,000, the imprecision in the maps is overcome and people can get enough information to be able to follow up. So that's why we stuck with the 1 to 6,000. Seeing no questions on that. Oh, there we go. Outstanding.
Commissioner Overturf.
So I have a question for the language in subpart 2, specifically the last sentence. So my concern is with the addition of the phrase "or in person," because my understanding is that the information that will be available on our website is going to be at that 1 to 6,000 scale. But that more detailed information may be available in person at the commission's offices or through some portal that we might talk about later. The way that this reads, it makes me think that, oh no, that the local government can reproduce or publish data that we make available in person, which I don't think is your intent, right? You only want local governments to be able to publish the 1 to 6,000 scale level of data. You don't want them to be able to publish the more detailed information, correct?
I want them to be able to publish on their own local map, if they so choose, everything to a scale of 1 to 6,000. I also want them to be able to answer a citizen who comes into their office and says, I want to see the specific information about my parcel.
Right. So I wonder if, and I'd be curious if other people read it this way, but by including that "or in person," to me, that makes it sound like the local government can publish the level of detail that you would be able to see if you walked into the commission's maps, into the commission's offices and looked at our maps.
The local government could then put that out on their maps also?
Or could give it to a home builder and the home builder could do it or whatever. So I wonder if we should strike that or in person and make it clear that the only thing the local government can reproduce or publish is comparable to what's available on our publicly available website.
Yes. I think that the intent of the language is that the local government could post or publish all of those things and then also answer a citizen coming in to take a look at it. And so I think that the language needed some additional clarification on that second piece of if the local government has a map of it and somebody comes in, they can take a look at it.
Commissioner Hopkins.
Clarification or question, I guess. I think when we had this discussion, there was a desire to not just make people travel too far, hundreds of miles, to get a chance to see the more detailed information. And the suggestion was made to have the ability for them to go to their own local government office and then have that kind of information with a responsible party. The local government is going to have to make that decision to do that kind of more detailed look. I think that's what the language is trying to reflect. And just that's what I think was the genesis of this, which since I was part of that genesis, I certainly appreciate what you've all done and how you've tried to do it. Because I do think there's a role there to make things easier for folks to get to, but have that local government accountability and responsibility in that loop.
Commissioner Morgan.
I don't have any substantive problem with what you're all talking about. I agree with Commissioner Overturf that the change you made doesn't accomplish what I think your objective was, because the way you inserted in person, it authorizes the local government to publish any data that the Oil and Gas Commission has made available to somebody who comes to the Oil and Gas Commission's offices and looks at the actual forms. And I don't think that's what you were intending. I could be wrong, but I thought what you were trying to get at was to allow local governments to make available to anyone they want data down to whatever scale this commission is comfortable with. If what you're trying to do is to expand the universe of people who can view the real down to the the actual scale filed data, then this does that, but I'm not sure that's what you wanted to do. And if we're going to do that, do we care whether there's any kind of restriction on what those persons in turn can do with it? The question that came up in my mind was, okay, if the local government has the data and they make it available, say, to a developer, a subdivision developer, does that subdivision developer have then the right and the obligation to disclose it to a potential home buyer? I don't know. Do we care? Once it sort of gets to the local government level, what happens to it at that point? And to Commissioner Hopkins' point, I think the way I'm reading this now, any local government designee can ask for the information. So presumably the local government designee of the jurisdiction where the property is can have access to it if that addresses the concern. Because I think that means it'll be local for wherever the property is.
Commissioner Eden.
Commissioner Eden. Your microphone.
Let me laugh. Sorry. In the first paragraph, we say any person may view spatial data at scales less than 1 to 6,000 for an individual parcel at the commission's office. And so here we're saying that they would be, I mean, the intent is to say they would be able to view in person information about an individual parcel. It also suggests that they could print that out or publish it in some way, that view. But one way to be more clear here would be to reference those specific terms of our that we're making available in subsection 1, or something. I mean, I think the question about what people can actually do when they view their parcel at the commission office is still an open question.
So if I could suggest, just as a method of doing our business this afternoon, if you're comfortable with it, and I'll just throw this out there, Julie and I note that, and we will make an edit and bring it back to you. So what we'd like to do is get through this, definitely take questions, make sure that where we think we are landing this is where you want it or not. And then we could make changes at a break and then bring it back for further discussion. I see nodding heads. So, and I even have a thumbs up. Okay, so duly noted.
Commissioner Mester.
And this is just my opinion, but I need some help, and we've talked a little bit about this, but I need some help why an individual parcel owner can come into the COGCC offices and be able to access more detailed information than would be publicly available on the website without signing a confidentiality agreement, but yet a local government has to sign a confidentiality agreement to have the exact same information.
Commissioner Messner, I'm glad you've asked this question because it gives me an opportunity to clarify something that my drafting intent was not in complete agreement with Commissioner Eaton's question, which is our idea was that somebody could come in and view that data, not take a screenshot, not print it off, not use their camera phone to take a picture of it or to record it, but really to get more precise information if they are curious. But again, all of this is geared towards providing enough information to a member of the public to be able to ask more questions, not to provide a definitive answer. And so I think my view has been, if the only opportunity is to view the information that we're provided at a greater scale, I have less concerns that somebody would be, sketching out a map and then going in the property and starting to dig or anything else. And so to me, it was a way to balance folks' desire to have more specific information without having to go to the degree of a confidentiality agreement. But I hear your concern, and I mean, a number of parties requested that we maintain a very specific log of people who have come to the office to view a parcel and identify themselves and then what they viewed. And that may be another way to accomplish or address your concern. But we thought our general logging requirements for citizens who come into our office sufficed if somebody were to come in and take a look at a parcel.
Commissioner Hahn.
What are your general login requirements? Do you have to have a driver's license or just a name?
I think just a name. But you come in, fill out your name, sign your name, identify why you're here or why you're at the commission's office.
Commissioner Mester.
Thank you. I do think that, and I appreciate the intent, I do think that as much information as we can provide local government as freely as we can to aid local government's ability to provide the things that you're indicating here, which is emergency response, which is planning and land use development, but also to aid local governments in what inevitably I would hope to be their mission, which is the protection of public health, safety, welfare of the environment, and wildlife resources as well. So I don't have a lot of heartburn about a confidentiality agreement, but I do think readily providing that information to local government rather than basing it on a request, but just providing that, I think is a good thing.
Commissioner Hopkins?
I'm not going to go there right now. Oh, wait, sorry.
With that, we will work on revised language for 1101E. And moving now to the next slide and on to issue 2. So issue 2 is the question of specificity, and some of this dovetails upon my remarks previously. We heard, I believe, that the commission would like the best data available, but has concerns about potholing to obtain that data. And so we've tried to set the plus or minus 25 feet as a minimum baseline of accuracy, and then include a directive that the operator do the best they can to obtain better quality data, so long as they're not potholing or using invasive techniques. Again, I do want to reiterate that in talking to our field team, our environmental team, and our engineers, the plus or minus 25 feet meets the needs of our agency to carry out our environmental protection functions. And so everything that I've looked at in terms of how to define out what accuracy we need is framed first through that lens. What do we need to do our jobs? The second question is the one of what do we need to provide to the public and for what purpose? And so I think that that's where we've had a lot of conversations about plus or minus 3 feet versus plus or minus 25 feet. And so as I've thought through this issue, it's been important to me to think about what is our goal in providing this information to the public. And for me, it is, again, to ensure that the public has an illustration of the information that provides them with enough to decide whether they need to ask follow-up questions, again, of the operator, of us, or of 811. And for me, a 50-foot corridor, I think, accomplishes that goal mostly because it accommodates the needs of our agency to effectively implement and regulate oil and gas operations in Colorado. So with that, we offered, however, that we do think getting the best data possible is great, as long as you're not digging and putting worker safety in jeopardy and also creating additional environmental impacts. So if there is a tracer line that can be easily located, that's great. Let's try to get that data. And so with that, I kind of want to open this up for questions. That's some total of my comments on this one.
Questions, comments? Commissioner Eden.
Thank you, and I appreciate this effort, because I think that, as people have said, there's likely more accurate information out there for a large number of these lines than what is the this minimum that has been proposed. And for a variety of reasons, having more accurate information on the map is better. And so how we can, try to figure out how to get to that more accurate information, and it's useful because it also tells you when your endpoints are, off and things like that. There are already inaccuracies, as you note, and so, and they can compound each other. So if you start with more accurate information, the whole system is more likely to be accurate. So if we can set up a process, and I'm not sure, I'll have to think about this, but that we're getting to let's use the most accurate information or require the most accurate information now and have a way of getting to more accurate information over time, that would be helpful. And I think this, well, the way it's written, because it has the December 2020 deadline, it would include all of the existing flow lines, right?
That's correct.
At least have some GIS representation.
And I would also keep in mind that this is for a very limited, not a very limited, but a limited set of our flow lines, right? It's some off-location flow lines predating May 1st, 2018. So.
Commissioner Hopkins.
A third of all of our flow lines, or?
Just as a comment, I actually like the way you all have tiered this. I think the map is a screening tool. It's not the be-all and end-all to ultimately get to the hands-on on the flow line, which is the ultimate goal. I think the developer only said partly in jest, if I could get accuracy of 2 inches, I'd want that. And that's getting to the hands-on, the pipeline. So I can understand that. And I think maps have their use as a screening tool. And then you have the tier where you can go into the local government or the COGCC and get your parcel. That still may not be good enough. And I think that at that point, at some point, you got to have human intervention to get to, and find out what's really necessary. And I think you can get there in a logical way. And I think you've structured it in a way that leads to that type of conclusion. So I think I like the way you tried to listen to people's comments very carefully and accommodate them myself.
And I just have a follow-up to that. You know, it's mapping gives you a snapshot, of course, but if you want to get into more detail, there's way to, 811 and so forth. But big picture, do we even know like how often GIS is updated? And kind of looking over at Chris over there, are the maps sometimes old, and do they show if there's a fence that was built the day before, or like how frequently?
The aerial imagery?
Yeah.
I believe the one on our system is from 2017. And so we update them when they become available every 2 years, approximately.
So that's
another
dated. Yeah.
complication, right?
Yeah, exactly. Commissioner Messner and then Commissioner Overturf. And then, yeah.
Thank you. I wonder, we heard a number of folks testify about the fact that flow lines put in post 1996 all had tracer lines available in order to be able to more clearly delineate where they were at. And there were some suggestions that were made that we would require plus or minus 3 feet for those lines that were put in post 1996, but perhaps look at something a little broader for stuff that was pre-1996. Is there a thought why that wasn't considered in the language that you put in?
Commissioner Messner, that's a great question. And we talked with some detail with Stuart Ellsworth about that. And I think he's probably best poised to get into the details. But my summary is like you can use one of those find magical coins tools, right? Magnetometer? Sure, magnet, to locate those tracer lines, right? But the placement of the tracer line in the trench may have errors, one. And two, as you get deeper, the accuracy or the decreases. And so Stuart, if you want to take it from there, please.
We'll probably give you an idea of kind of how that would be done is basically you hire a company, whether it's a metal line or a line with a tracer, to induce a current on that tracer line or the metal pipe. And then with the wand, you see that you've seen them all in the street with a wand. They will go back and forth and locate that, and they'll then paint where that line would be located. And the accuracy is, I like to think of it as about equal to the depth of the line. So if you have a 3-foot line, you're plus or minus 3 feet. If you had a 10-foot line, your accuracy is or that error is a little bit greater. You might be closer to 10 feet either way.
You mean if it was 10 feet deep?
Deep, yes.
Yes.
So in the depth is approximately how I try to visualize that. And then basically you would follow that. Now you have a painted line orientation and alignment. And then you would follow that with a survey crew that would then survey that either by traditional survey methods, maybe a GPS type, and then you would convert that to a line that you could place on a map. And that's kind of the process.
Understood. I mean, but I'm also of the understanding, at least from testimony that I've heard today, that the typical depth for a flow line is between 3 and 4 feet.
That's an approximate, correct? Yeah, that would be the idealized.
So as we're talking about this and we're utilizing the technique that you're talking about, then really we're talking about the ability to be able to develop an accuracy of plus or minus 3 feet-ish, utilizing that technique. Is that correct?
Yeah, so if you're talking in the Front Range here where there's a lot of flat relatively flat. That's probably a good perspective. Most gas. Now your water lines are going to be deeper. So we get spin factors here that start developing. Water, now you're talking something that will freeze. So you would be
about 8 feet, right? So
well, it'd be 4.5 here in the front range,
And
6 feet,
more
6 feet
right
in the west side.
So I guess one of the things that I want to bring up is I heard testimony that indicated that in order to be able to gain the plus minus 25 feet, that they could just utilize their surveyed easements, and they just know that they're going to be in that easement. I certainly have experience where, utilities, while they're supposed to be in the easement, in reality, have not been in the easement. And so I think it's really important that we know where these assets are, and that the operators know where the assets are with the most specific data that we can get. And so I would suggest plus or minus 3 feet for anything post 1996, and then have some allowance for plus minus 25 feet for things that are pre 1996. But that's my opinion.
Commissioner Jolan.
Thanks, Commissioner Messner has covered the first question that I have, and then the second question, if I may. Invasive methods, is there a understanding of what invasive methods means?
My answer is potholing, but I should probably ask Stuart and Mark, and that is something that we could articulate and clarify in the statement of basis.
That would be great. Thank you.
Commissioner Hahn.
I also had made, thank you, Commissioner Messner. He read my notes, my exact thoughts, that if there is a tracer and we can get within 3 feet, I think we should. I agree. And for those that we cannot, then plus or minus 25.
Commissioner Overturf.
This is a, I don't know if there's anybody, and this is an old timer question. There are people that are in the room that were involved in the rulemaking that required in 1996 tracer lines to be installed. My assumption is that the reason why that requirement was included was in order to be able to better locate flow lines. If there's, I'm also looking at Commissioner Boygan, but if there was anyone who was involved in that who has knowledge about why that tracer line requirement was put into place, I would certainly be interested to hear that. If it was installed, if it was included, as I suspect, to provide for greater knowledge of where lines are located, then I think it is a very reasonable cutoff point. Another alternative that I had been kicking around that I would be curious to hear staff's response to is, I think I share the concern that's been voiced by many parties and some of my fellow commissioners about, at some point we have to figure out where these things are. And would an appropriate threshold be upon sale of the assets? Before selling your pipelines to someone else, you need to know where they are within plus or minus 3 feet in order for the other person who's buying it to know what they're buying. So I would be curious to hear if staff has any reactions to that type of an approach, recognizing that there are lots of ways to address this, as Commissioner Messner has pointed out.
My thoughts are, Commissioner Overturf, that much of the location question turns on whether invasive techniques are required or not. With invasive techniques, we have concerns about digging up property and also about worker safety digging in the vicinity of an active utility. And so I think if, to the extent that we can balance those concerns, I appreciate that could be another approach to obtaining this information for the agency.
Commissioner Hopkins.
I'd like to get the opinion of the folks who are going to do the work. They've talked about the plus or minus 25 and why and how long it would take and that kind of thing. To get to the idea of a pre-96 or pre-tracer scenario versus a non-traced scenario and having a higher accuracy for the latest with the tracer lines. I'd at least like to give the industry an opportunity to comment on that with their perspective. Does that change your ability to do something by December 2020, or the techniques that you would use that might delay it, or whatever? Just once you get the opportunity, at least weigh in.
This is Brian Murray, PDC Energy. Just a couple comments. I probably lost your question in there too. So you might have to remind me. But
I'd be happy to.
Okay.
I just want to know how, if your schedule changes,
yes,
the ability to do that with a tracer requirement for post tracer.
And one point of clarification I mentioned yesterday was error bars on top of error bars.
Mm-hmm.
So we were talking about getting to plus or minus 3 feet. That is what the new lines construct after 2018 when you hold a GPS unit right above the line to get. So what Stuart was saying, and saying what I said yesterday as well, is when you're locating the line, you're in a general area. So then when you take a GPS unit with an error in a general area with an error, depending upon the depth of the burial, the plus or minus 3 feet is no longer, in my opinion, valid. And I said if I had to be held to that standard, I would have to do invasive measures to make sure that the GPS unit is right above that line. And that's what I was saying with the potholing. Depending upon the depth of burial, you can get closer than 25 feet, absolutely. But to get to that precision, you want to have your eyes on the line with the GPS unit right above it. So I just want to make that point of clarification that doing non-invasive methods, you will not be able to get to the plus or minus 3 feet, even if there's a tracer wire or if there's a steel line. Depending upon the depth of burial, you're inducing error on top of error. So we might get closer to 10 feet, let's say, 8 feet, depending upon the depth of burial, when you stack those error bars on top of each other.
How about commenting on the time frame? If you did do that, and everybody listens and carefully says, but we want you to do it that way, how would that affect your schedule if you were required for those tracers, again, just the tracers, to get the accuracy that you need? Does that change your time frame? I mean, you talked about the difference in technology to do it, but I wasn't sure how that might affect your time frame.
I guess my question is, what is the accuracy we're getting to? If you're asking for plus or minus 3 feet, my answer to you is we need to do invasive technology because of what Stuart outlined, that there's a plus or minus associated with locating the line, depending upon the depth of burial, plus or minus with the GPS unit itself. And when there's multiple lines in a corridor, you want to make sure that you're still on that same line because sometimes there could be some crossing. To answer, so if there's a wiggle room in between, you can get there faster than if you have to go do the potholing to get to the plus or minus 3 feet. Is that answering your question? I mean,
well, yes and no. The no part is that I was interested in your time frame. It's going to be more difficult. I hear it's going to be more difficult. The accuracy issues I can appreciate, but I can't get a sense of, are we talking about another year? Are we talking about 2 years? We're talking about, we don't know.
Yeah,
Commissioner, any one of those answers would be acceptable to know.
I'll take a run at that one. Rusty Frischmuth, High Point Resources. I think what you're talking about, actually tracer really honestly doesn't come into play. Let's just talk about it in the context of, do we have an off-location flow line that we can locate?
Okay.
That would be a steel line. That'd be something with tracer. If you want us to locate it, and Stuart give a very good rundown of what that means, we got to go put boots on the ground and survey in thousands of miles of line. I believe the number I saw that we didn't have record of was on the order of 3,000. Let's assume that 2/3 of that can be located. We have to go survey 2,000 miles of line. That's going to take time. And that is not anything I think we could get done by December 1st, 2020.
And you don't have, and I'm getting the impression you probably don't have an estimate of how much longer it would take.
to be honest.
Because the size of the job is not really something you considered.
Yeah, I mean, we hadn't contemplated it, and all the discussions that in the back and forth that we've had with staff was we can do plus or minus 25 feet because in many cases we can do that without having to put boots on the ground. And I can do that without having to go survey through people's cornfields and worry about crops. And I'm not even a West Slope operator, let alone what they're going to have to go do, most of which can't be done in winter. So you're opening a significant discussion at that point.
Thank you very much for your comments.
And may I add some commentary to that too?
Sure.
What Stuart described and what Rusty just described will not get you to plus or minus 3 feet. It will get you higher than plus or minus 25 feet, but I can't tell you what that would be because it depends upon the depth and there's a lot of variables associated with it. Plus or minus 10 feet, maybe. So that is one step of non-invasive boots on the ground, like Rusty says. So that is something we more than likely could not do by December 1st, 2020. Then there's the standard of if the requirement is plus or minus 3 feet, that's a whole other level of time and effort. You know, the amount of potholing that would required would completely deplete the potholes are around Colorado. And those are used for important services for excavation. So I'm concerned because there would be a run by industry to procure all the potholing that you could ever find that a lot of other excavation requires in order to do it safely. So there would have to be a balancing act on that, and that could take quite some time.
Question, but I would really like to go back to the presentation and go through that, and then we can ask people later on for process. I worry about not getting through the presentation, but saying that, one question, Commissioner Boygan.
I feel like we've gone off the tracks on this 3 feet, 25 feet issue. I feel like it's getting us away from what we're actually trying to do. I personally feel like we know we can do 25 feet. We know that's realistic. Industry has said they can do it. It'll get us information that we think is usable and will resolve most of the issues that have been raised, maybe all of the issues that people have raised about knowing where these lines are. And to me, that's the goal. And we can argue for the next year or have study groups or operator best practice groups meeting with staff and coming up with mechanisms for seeing if we can improve some level of accuracy if it's even needed. I worry about us trying to achieve some sort of artificial level of accuracy that may or may not be reliable even. And so if we're representing to the public that we've got now accuracy down to 3 feet, and it really may not be reliable to that level, when we put it out there, are we inducing people to rely unreasonably on a standard of accuracy that doesn't exist? And I worry about trying to attain some perceived level of ultimate accuracy that really serves no useful purpose, especially considering what would have to be done to achieve it. So I feel like we've gone way off the tracks here, and we ought to go with what staff has proposed for now. And if we want to investigate it further, let's investigate it further.
Great, thank you. Let's go back to the presentation and stay put. We may call you back a little bit later.
So, Chris, if we can move to the next slide, please. This is again Julia Murphy. On issue 3, there are a couple of things. One, we have recommended some changes to the abandonment process in light of the testimony that we've heard today. But one of the things I did want to bring up is that we heard the question raised recently, or in Ms. Martinez's testimony, that how is this commission implementing its directive to inspect? How are we verifying that abandonment is occurring in accordance with our rules? And so what we have suggested is that you commissioners consider directing staff to report back to you in 12 months about what it is that we've done to get boots on the ground and in the field and verify these different things, or to audit reports. So that's one piece of it. And then with that, Chris, would you mind pulling up the red line, please? And while Chris cues that up, as a preview, given the voluminous kind of concerns we heard about actual impacts from abandonment in place, and also the calls, which in some ways feel competing, but I think we found a way to make them not competing, for increased discretion, we have merged what I called the high or the low review and the medium review into a single review under 1105D. And Chris, if you can scroll down just a little bit. Yes, and I believe Hannah has printed copies off for each of you. So if we're looking at 1105D, we struck some of the language to describe what we're trying to accomplish, which is we want the abandonment process to be the least impactful. Scrolling down a little bit more, Chris. In subpart 2, we articulated that the director may review the notice to evaluate if the proposed amendment was the least impactful and consider it. And so now if we scroll down a little bit further, okay. We've then struck in subparagraph 3, which was the medium review category, and absorbed the subparts of it into, again, this now like medium low review piece, where a Form 42 comes to the commission or the director, notifying us 30 days in advance of commencing abandonment processes. That notice must go to the surface owner, and then it also must go to the local government. The Form 42, how it functions within our system is, one, it can automatically go to the local government. So the idea would be that's how notice to the local government is accomplished. The Form 42 is truly a notice to our agency. So it allows review by the director to be discretionary based on whether a local, not entirely, but it is a discretionary form to review. It doesn't mandate someone on staff actually hitting approve once it comes in the door, but it does provide information to us that empowers us to take action if it's appropriate. And because we are providing notice to the surface owner and the local government, which is kind of like panning ahead, and Chris, if we could scroll down to subpart a little bit further, subpart 4. Oops, nope, you were right there. This is our notice piece, with the idea that the local government's perspective is very important to us, as is the surface owner's perspective on the abandonment process. It goes to them, they have 15 days to get back to us, and I think that the surface owner's preference would be an important consideration in whether the director initiated review or took action. And so Chris, if we can scroll back up, please. Right there, acknowledging the issue that Commissioner Putnam raised about emissions. One of the categories that we wanted to be considered is that the operator demonstrates and quantifies that the removal of flow lines will cause significant emissions of air pollution. I think this is an important consideration in evaluating how abandonment should occur. So again, the changes in my mind to this subpart balance the requests for increased discretion to the director, in that it's broadened the scope of what the director can review and what the determination can be. But it's also kind of absorbed 2 separate processes into a single one, which is more efficient for staff to administer.
Commissioner Overturf. Director Robbins.
Sorry, yep. And if we scroll down a little bit further, Chris, a little bit further, we have suggested the changes to 1105G are just conforming changes. I know they look big, but it's basically like we're still giving notice to local governments in 811 after abandonment is complete. But if you scroll back up, sorry, Chris, to subpart D, hearing the calls for verification of that abandonment was performed appropriately, staff is suggesting to the commission subpart D that says if the line was abandoned in place, verification is performed by a third party who observed that the abandonment requirements in 1 through 4 were met, and is a registered PE, works at the direction of a PE, or has specific training and experience abandoning lines in accordance with the requirements of this rule. I will need to clean up the PE language to make it actually match what we have in other rule parts, but didn't have time to quite get to that. And so importantly, the pieces that we want to have someone else in the field observing are that the line was evacuated, that the line was reduced to atmospheric pressure, that the risers were cut, and that the ends were capped. Those are the steps, right? that one, industry identified as critical to protecting public health, safety, welfare when a line is abandoned in place, and two, Ms. Martinez called upon us to verify is actually performed.
Commissioner Overturf.
So I very much appreciate the inclusion of this, circling back to our first conversation yesterday. I very much appreciate the inclusion of this third-party verification standard, and I think this is among the most important changes that we're considering in the course of this rulemaking. My concern, if you go back up to 1105D subpart 2, by collapsing these two standards of review, the previous language in subpart 3, which you've deleted, also required operators to include documentation supporting the applicable reason for abandonment in place. And similar language has not been added to subpart 2, which I fear could deprive the director of the information that he or she may need to make this determination. And so I wonder if staff would be amenable to including that language from subpart 3 back up into 2.
Can we actually go to 1105E, if that's okay, Commissioner Overturf and Chris? Up or down, sorry. 1105E, subpart 7. So for an off-location flow line or crude oil transfer line abandoned in place,
I see.
we are requiring that. And so the reason that documentation is submitted as part of the submittal, the Form 44 submittal at the end, I think I understand your question.
Because wouldn't you need that information at the front end in order to decide whether or not you want to give it extra scrutiny within those 30 days?
We have a form challenge there. And so there's two challenges. One is the Form 42 does not allow us to attach documentation at the current point in time. I'm sure that's solvable. The second is that the Form 44 requires manual button pushing to come into our system. So if we, I'm 100% in some really terrible weeds right now, but if we require the documentation to be submitted on the front end through the Form 44, it will require a manual button pushing and review and intake process for us. So
whatever you think is the best way to do it, I fully support.
Okay.
But I think that you should have enough information to be able to decide whether something deserves the director's additional scrutiny.
Okay.
Commissioner Hopkins.
On the verification, since you opened it up, I thought I remembered seeing in some of the original staff language at one point with regard to the verification process that the COGC would have the right or the requirement to have an inspector on site during that abandonment process to verify it to the commission's, to the COGC's expectations that it was done properly. And also I thought I may have read, and I can't find it now in the current draft, that's why I'm asking the question, that the local government, as part of the notice requirements, would also have the right to have their local government inspector observe that as well, which would give you 3 forms of different inspectors' verifications of what's going on if they want to do that. And is that still there, or am I missing, or is it gone?
Commissioner Hopkins, I believe it is still there. In 1105D, we're still requiring 30 days notice before abandonment operations commence, whether those abandonment operations apply to on-location flow lines, off-location flow lines, or crude oil transfer lines. Those notices go to the commission and also to local government. And so that to us is the information that we need to empower or to get a field inspector on site.
Okay, and so it'd be both for the COGCC and local government if they so. So you got all the levels of accountability of government.
Yes.
Observing it as well as a third party.
Yes.
Okay, thanks.
Commissioner Messner.
Thank you. I do appreciate the combining of these, and I think it has the opportunity to make it flow a little better and is a little more readable. I did have a couple of specific questions. There was a suggestion from a couple of different testimonies about language around the federal government exemption. And I do think that that's important to take into consideration, because I do think that our existing language in here de facto allows the federal government to determine whatever they want on whatever lands, including private lands, the way that I read the existing language. And so I do think the language that was suggested, which is the line is located on federal lands. If the line is on federal lands, the relevant federal agency, relevant federal agency has requested abandonment in place and has no current plans to convey the land out of federal ownership, and successful reclamation has occurred. You know, something along those lines. The point being is that we want to ensure that the relevant federal agency who has issued a permit on this federal land has requested that the line be abandoned in place, versus a blanket, anyone from the federal government can ask for this line to be in place. Does that make sense? Or
Commissioner Messner, I think it makes sense when we're thinking about BLM and BLM lands. We have a competing challenge, I would say, that the other federal government piece is that at times PHMSA requires abandonment in place, and we have lines that are subject to both our regulation and theirs. And so part of the reason this language was somewhat broader than that is to accommodate PHMSA lines as well. But I think that we can incorporate your suggestions.
Can you utilize just the term relevant federal agency then?
I think we can take a cut at certainly incorporating your concepts in a way that accomplish both objectives.
Okay, I would appreciate that, because I think that distinction, I don't think we want to give away our authority to the federal government. And then this is just my thoughts again. You know, I think that the term revegetation is a challenging term, and is challenging, you know, in different parts of the state for different reasons. And so, you know, I would suggest, and this is just my opinion, rather than, you know, having the term successful revegetation has occurred or is in the process, and removal of the flow line or crude oil transfer line would harm revegetation specifically, you know, I might suggest language like removal of the flow line would cause irreversible surface resource damage, or something along those, so that we're understanding that the vegetation is not the only thing that we're trying to pay attention to here, but we're looking at soils, we're looking at, you know, other resource damages that could occur with the removal of this particular flow line, and that would be a consideration rather than just revegetation. So that's just my thought.
Commissioner Boygan.
Thank you. Just for the record, I support the suggestion that Commissioner Messner just made. And I would, on the resource.
The revegetation standard.
Yes, it's a broader term and more inclusive. And on the issue that he raised regarding the federal government, I might suggest using language along the lines of, for those lines that are subject to the jurisdiction of the federal government, the relevant federal agency directs abandonment in place. I don't know if that addresses your concerns, but I thought it was a good point.
Commissioner Overturf.
I had a question about a change that you made to subpart 2, 1105D 2A. Your previous draft required the surface owner agreement to come from the current surface owner, but you've deleted that requirement, and I'm wondering why.
I have broadened that requirement to encompass also the previous exception that was under the former 3A, which is a surface owner agreement executed by a prior surface owner. And so instead of having two subparts that articulate similar things, I thought it would be better to have a single subpart that encompasses all surface owner agreements that the agency could consider.
Okay. I still have concerns about what happens when there's a conflict there, but maybe that's something we can talk about in the statement of basis and purpose.
Commissioner Eaton, do you still have a question?
Yes. And I guess I just, because I haven't really had a chance to go through all this, now that you've combined 1 and 2, and going back to Commissioner Overturf's question about the documentation, can you just walk me through how, for these exceptions, what documentation or information would be required of the operator and the basis for the review by the director?
As staff has drafted it and not subject to Commissioner Overturf's request that we include documentation on the front end, the idea is that the notice would come into the director with a narrative description of the abandonment process, including if it was proposed to be abandoned in place, why under the 4 or the 8, under the 8 reasons articulated in the rule. The idea was that on the subsequent Form 44 that came in after abandonment, that would include the documentation that could provide additional review, or that would actually supply the documentation. But we appreciate that Commissioner Overturf's comment that should probably come in on the front end. And so we need to build a way to be able to review that.
And the same documentation would be required for all,
pardon me?
Sorry. Some documentation of the verifying the purpose or the reason and the minimization or avoidance of impacts would be required for all of these now that are under that 1 category instead of 2. That something would be required.
I think so. I think the other thing to keep in mind is that we've articulated 8 subparts that appear to us at the staff level to have more impact if you choose to remove an abandoned in place, in terms of damaging surface habitat, in terms of being within or crossing a utility corridor. And so on some level, there is independent value in understanding that that reason is why this flow line should be abandoned in place. And there's a huge number of flow line forms that are coming in. And so making sure we have enough information to evaluate whether to request more is an important consideration. I think looking at my recollection from the statement of basis and purpose is that over the past 18 months, we've received approximately 230 flow line abandonment reports a month. And so at that pace, that is a significant workload. And so again, that's why we've tried to build out these 2 different review criteria. One where we as an agency have concluded that abandonment in place is preferable under these 8 conditions because the impacts from removal, we believe, generally are more impactful than removal. That is part of the consideration, is creating that administrative process and an understanding of those criteria. And then for reasons outside of that criteria, an operator could come in pursuant to subpart 3 and come in and make the affirmative showing that abandonment in place is less impactful than removal.
Well, can I just follow up? I think then on D, I support, there are situations where removal will have more impact on the surface, or the impacts on the surface will be more harmful than good, or outweigh the risks. But this is so broad, as we've talked about. And so I think, I'd like to see the language that Commissioner Messner gave, but we could talk about successful reclamation. That's different than successful revegetation, which is tied to at least some kind of process. Although I don't think there are reclamation requirements for flow lines. So, but trying to be more specific about the impacts that rise to that level, I think is really important here.
Commissioner Boygan.
Thank you, Mr. Chair. Just going back to the discussion I had with council in the morning on this question of submittal of the Form 42 and what kind of review is undertaken, and whether it's just simply the operator lobbing in a form that says, yep, check that box. I got vegetation out there, so I'm good. I can abandon in place. Or whether there has to be some additional required showing that the operator submits with that form. This doesn't really say, it just says the director may review. Should there be language that contemplates a more robust process, similar, I don't know, I'm thinking about the objective criteria in your toolbox, for example, of what an operator has got to show in order to satisfy the increased scrutiny requirement. You've got a whole matrix of practices and other kinds of confirmation, et cetera. So should there be some language in here that captures that concept, or are you comfortable with the notion that that's what you're going to do and we don't need to worry about it? And I would just also respond briefly to the issue that Commissioner Overturf raised about surface use agreements and potentially in conflict. We don't, as an agency, have the power to get involved in contractual disputes between operators and surface owners. So if they're in conflict, I don't think it's going to be our role to resolve that. If an operator certifies to us that they've got an agreement pursuant to whatever the director says the operator has to do to satisfy that requirement, if the operator is in a dispute or a potential dispute with a surface owner over that, we can't, it's not our place to address that. The director has to just indicate what the director wants to see to support the statement that there is a surface owner agreement in place, right?
This is Jeff Robbins. To answer the first question, Commissioner Boygan, I think that Ms. Murphy and I were trying to balance the review by the director in this subparagraph 2 as compared to the review that was in subparagraph 3, which is a more robust review. And I think that where staff landed is that this review, which is discretionary, was enough to accomplish the goal without flooding us with forms that have to be reviewed at all times. And so we felt this gave the right balance in terms of review by the director. I can see that we would, have staff that gets versed in these, noting which ones need to be flagged for potential additional review, but then for ones that look appropriate and that they are protective, then we wouldn't have to go through the review. We wouldn't have to push the button, as Ms. Murphy spoke to.
But I understand that. I think what the issue is, what's on the front end, what's coming in order for you even to make the decision whether you need to review. Presumably you're going to require some level of detail, substance on whatever exemption is claimed in order to at least create a presumption that that you qualify for that exemption. So all I'm saying is I'm assuming you're going to have some kind of guidance on that at a minimum, some kind of requirement, like you do for 2As. You're going to have to submit this and this and this.
Yeah,
and I just doesn't say it in here, but
yeah,
maybe we can assume that.
And I can envision that, as with all of the rules that we'll be doing, we'll have operator guidance, and so the guidance, I think, could sort of flesh out. If you're in, the revegetation one, then we would like to see X, Y, and Z. You can certainly insert that into the rule, or you can leave that to the director and staff for us to create the appropriate balance for each of the 8 categories. But that's how we have, just to inform the commission as a whole, we do that often with regard to how to interpret and apply our rules to operators and to stakeholders. And sometimes that guidance actually, may shift. We may not get it right the first time. So that's how I would envision this playing out. If the commission is comfortable with that, because obviously the commission can decide that it wants to tighten its, tighten the process.
Commissioner Messner?
Just a clarification for me. My suggestion was to actually strike the language in 1105D2D and actually place the language. And I think I like Howard's language better than my language, but my language was removal of flow line would cause irreversible surface resource damage. But actually to remove the vegetation as a criteria. Just to be clear as far as what my opinion was.
With that, we'll work on those edits. And Chris, if you can advance us to the next slide.
Commissioner Jolan.
I think we've had good discussion on D, and then we've also had some good discussion about what pieces of this belong in the rules and what pieces are staff's, and how do we draw that balance. I would like to draw attention to H being new language and also probably needing similar treatment. And I don't know if John Putnam is able to weigh in over Zoom, but I do feel like H opens up kind of similar questions as D, and there are other ways to mitigate air pollution, and I think we need to take that into consideration.
And Commissioner Putnam, do you hear us? Okay. Okay, you have to unmute. Yeah, I think, John, I think you have to unmute yourself, I believe.
Maybe what we can do, Commissioner, is I'm texting him and I'm not getting back. So he may have fallen off, but I've made a note to try to make sure we circle back on that point.
And if I may, it certainly could be a similar conversation to D, where it could be the staff decision about what gets it, and I'm comfortable with that. I just wanted to make sure it was on record that H is similarly, what's the word I'm looking for, open to interpretation at this point. Thank you.
Please proceed then.
Thank you, Chair. So jumping into slide 4, one of the operators brought up a concern about the language being of subpart A being inconsistent with 1. So we're making that clarification, and then consistent with that, next slide, please, Chris, a change to Rule 316C to make sure we don't confuse anybody about what the requirements are. These are mostly cleanup changes, but wanted to make sure we touched on them. Next slide. In 1102H, there was a fair amount of conversation about inspection, and first, again, we're still recommending that third-party inspection occurs for both crude oil transfer line and off-location flow lines. As was raised yesterday, the certifications that staff included only were relevant to someone who is inspecting a steel welded line. So we built in a second category of certifications that would be appropriate for non-welded steel lines. So again, I think this is an important clarification to include now that staff is recommending that all off-location flow lines and crude oil transfer lines are subject to inspection before being placed into service after construction. So with that, next slide. A couple of the last pieces, given the robust and diverse perspectives on what to do with the comprehensive drilling plan language, we're recommending that staff is recommending to withdraw its proposed changes to Rule 216, recognizing staff anticipates a robust conversation about comprehensive drilling plans in a very short amount of time. So we would recommend pausing on that. We heard a lot of the conversation yesterday about leak detection requirements and imposing those onto off-location flow lines, and recognizing that staff still has some concerns about the technology that's available. We do not recommend making changes to the leak detection requirements. I think that our integrity management program overlaps closely with leak detection, and so we're comfortable with where that program is. We recognize that technology is evolving, and so that is our recommendation at this point in time. Happy to take questions.
Commissioner Eden?
I'm sorry, I wanted to just go back to the inspection.
Yep.
Section 4.
Can you go back one sec?
Sorry. Or abandonment.
Oh,
Not.
Oh, wait.
Sorry,
Wait.
even further back.
That's the PDF actually, Chris. Sorry.
Oh, sorry. Okay. Okay, so that's 1105F, where you added that. And then it would be D. And I just wanted to make sure that, you know, that this contemplates sort of third party or independent verification. Sorry, we call it, yes, verification. And you know, I think that this piece is really important. And I just want to make sure, and I know you still have a little drafting to do there, but you know, that we're really contemplating some kind of independent review, either by a third party or I guess potentially commission staff, but we don't want to have to. I understand that, you know, we're talking about a lot of these abandonments, but I think this is really critical.
Commissioner, we agree, and that's why we've included it and also offered to make sure that we report back to this commission in 12 months to talk about where we have been on site, what we have seen, and how we have audited these types of verifications.
Does it contemplate third party or is?
Yes. Okay. D, if the line was abandoned in place, comma, verification
Okay,
performed by a third party.
Commissioner Hopkins?
Just to revisit my earlier question about trying to find out where the actual explicit language is with regard to inspection by COGCC and or the option for the local government to have inspection available during that period of time. I have to admit, I've been looking for that language in 105G under the local government notice and looking at it, and I can't find. So if you could just be kind enough to direct me to the language that explicitly talks about inspection during the abandonment process by commission or local government, I'd appreciate it.
Commissioner, you're right. It doesn't explicitly say the commission shall, or the commission will, or the local government shall or will.
I'm sorry.
It does not say specifically that the commission shall or will inspect. The contemplation for me is that by getting notice in, that is the piece of information we need to know to deploy our people.
Okay.
However, you may be thinking of language in 1102O that is more specific about allowing for inspection.
Oh, okay. It's entirely possible. But so I understand the reason why you do it that way. But I just want to make sure that that ability to do that is above and beyond the third party verification, because I'd like to see the role of government, at least in this area, strengthened.
We have plenary authority to inspect oil and gas
That's
locations
good.
at
And
any
you're going to
point.
grant, and the local government, you're going to allow to have somebody there as well, if they want.
Right, and I think that that's a point we should make clear in our statement of basis and purpose.
Yeah, I would appreciate that.
That's the
because-
purpose of one of the purposes of providing notice. One is to be able to review it. Two is to be able to inspect and be present on site.
And I'm sure that's a local government call for their participation, because having looked at this issue, the citizens expect their local government to do certain things. They expect the commission to do certain things, but they also expect their local government to take care of them too. Thanks.
Commissioner Eden.
Jeff, do you want to say something? Go ahead.
I was just going to, Commissioner Putnam, I think he's now back online. And Commissioner Putnam, if you're there, and if we could move this down to the air emissions abandonment language, which I think is in the PDF. So we're going to pull that up, Commissioner Putnam. And there was a request that perhaps you provide some perspective on this. And the perspective was also that it's a fairly broad or non-defined. Here it is. The operator demonstrates and quantifies that the removal of the flow line will cause significant emissions of air pollutants. One of the points was we can leave it as is, we can try to refine it, or we could, through guidance documents and or the statement and basis, put some parameters around this language. But if you are hearing me and would like to provide perspective, we are listening.
Thank you, Director Robbins. You're coming through clearly. Can you hear me?
Yes, we can hear you just fine.
Excellent. So I think the purpose behind this, from my perspective, is similar to some of the comments and questions I raised yesterday. The extent of potential construction will, I think, pose a significant potential cumulative effect on air quality. If we dig up a lot of these that may not otherwise, pose an immediate risk if they're not in immediate vicinity of current residential development or future residential development. So it's to provide a hook by which, and unless this part was changed, which I can't see just above here, still would require the finding that on balance, the public health, safety, and welfare is balanced. And so, just to create the opportunity for this to be evaluated as one of those exceptions. In terms of the question about whether it is too broad, I think you're right that an approach that would provide guidance, subsequent guidance, would probably be the best way to proceed with this. There are different thresholds we could identify at this point, but I'm not sure we have a full record basis for that, nor has really enough work been done trying to quantify some of these issues to really provide a solid hook now. So I think a generalized standard that would be followed by guidance that could be informed by some of the cumulative impacts rulemaking, as well as some of the resources of the professional commission to be able to provide some bounds around, when it's appropriate, when it's not.
Thank you, Commissioner Putnam. We now have on the screen the director. So subparagraphs 2 and 3 were brought into one subparagraph, and this is the director review language around whether the abandoned in place as a result of air emissions. So this would be the language, and I had testified earlier that indeed sort of the guidance approach is from staff's perspective appropriate here. And we also, in an earlier slide, pointed out that we would be reporting back to the commission in a year on these issues, so we can provide some perspective on that. So those are the 3 points I wanted to make in response to your testimony.
And this is Commissioner Putnam again. I think that makes sense, and I think the key thing is to have this sort of language that requires a finding about the balance between the various considerations on health, safety, and welfare. And to the extent that this does that, I think it strikes an appropriate balance.
Thank you.
Thank you.
So, Commissioners, that comprises the report that we wanted to provide you based upon the notes that Ms. Murphy and I have taken with the suggested edits to the draft that we published on Monday. We're happy to take further questions. And at some point, if we could have 10 minutes where Ms. Murphy and I could huddle and come up with some of this language that you've suggested, we would do that and could bring that back to you.
Let's see if there are any questions first, and then we can always see if we want to call up any of the panelists from before and So let's start with this row right here. Commissioner Overturf and then Commissioner Messner.
Yeah, I had a question about your recommendation to not make any changes to the, I think it was on the last slide of your slide deck, to not make any changes to the leak detection system. And after our conversation, some of the testimony yesterday, I went back and re-looked at the CSU study that was the literature review of different leak detection methodologies. And it seems like there were recommendations that came out of that study about ways that we could strengthen the rules that we adopted back in 2018. The ones that stick out to me are the first recommendation was that leak detection methods must be embedded in a robust leak detection system. And so it makes a recommendation and points to an API specification about how that kind of a leak detection system should be created. And then the other one, which was the topic of some discussion yesterday, is that relying on one technology or method is likely to miss leaks. And so I just wonder, what weight did staff give to that study? Do we really think that there's nothing that we can do to improve the leak detection provisions and the rules that we adopted in 2018?
I would defer questions about the specific study to Stuart, who helped run its course.
Yes, and I think we have that incorporated in our current rule, in that leak detection, and we get into a kind of a, I'm going to call it a wordsmithing perspective, that if you actually take a look at 1104E, F, and G to some degree as a combined element, it really has the perspectives embedded within that within that study, in that particularly E and F talk about the variety of, or several methods in that. Now, the CSU study did talk about API recommended practice 1174, but the point is that that does talk about a system, but when you talk about a recommended practice, you should consider incorporating these kinds of things. So it's a little hard for us to embed within our rules a recommended practice when our rules are guided towards specifics. And so we feel like we've got that embedded. That's one part. The next part is I want to make sure, one of the things that, at least in my presentation a year ago or whenever it was, when I tried to summarize, is to understand that there is a difference in when you discuss a leak, which is small, or you talk an integrity failure, which is large. One of the things also embedded in that study is Dr. Smits. At the time she was with School of Mines. She's now with University of Texas, Arlington. She was trying to measure a leak in a buried line, and she really, an emission leak size, in other words, a 500 parts per million, I think was what she was trying to measure. You couldn't really see it in a buried line. In other words, you had to get your detector on the ground within 2 inches. So when you talk an emissions size leak in a gas, that's very, very small. And that's really the focus from CDPHE's perspective when they talk about a lot of those above ground facilities where you're using a lot of those instruments to detect. And so, you know, there is an evolution in the technology, and I think the CSU report really gets into that. And there are methods where you can find things where you are deploying a large drone that can carry the instruments, or an airplane that you're driving around, and those will give you an aerial perspective that then you can slowly walk your way in with various instruments and finally pinpoint that emissions leak. But in a buried pipeline world, that doesn't necessarily translate as well. And so that's why when we created this leak, we really focused on crude oil transfer lines, which are liquids that are more prone towards an ability. And we really modeled that after North Dakota's when they did their gathering line, and they were able to use instrumentation monitoring more the flow in should equal the flow out. And that's where this is really focused on our leak side of the equation.
Right. So I feel like you talked about a bunch of things.
I know, it's
that
intertwined.
Right.
Yeah.
I get that. And I understand that there are differences between crude oil transfer lines and the things that are possible there. And I also recognize, of course, that the visual camera sort of solutions don't work well for buried flow lines. I see your point that our rules as they're currently drafted provide for different approaches and lay out different options for leak detection, but it's still the case that you're only for active status below ground on location flow lines, and for active status off location flow lines, you're still only required to do one of those listed things. And so I guess the point from the CSU study is build some redundancy into your leak detection system, because what you miss with one method, you might spot with another. And so I guess that's really my question, is that for that 1104E and 1104F, is just requiring only one of those methods of leak detection really the most protective of public health, safety, and welfare in this new 181 world that we're living in, that's different than when we adopted these rules in 2018? That's why I know I've asked a really good question and nobody wants to answer.
Commissioner Messner.
So I'll ask the same question Commissioner Overturf just asked. In order to be able to protect public health, safety, welfare, the environment, and wildlife resources, and leak monitoring and integrity management, do we need to have redundancy? Thoughts?
Well, you're looking at me, so I'm interpreting you want me to answer that question. And I would editorially say, yeah, in many cases, more is better.
So I'm going to share that it's my opinion that redundancy needs to get built into that. Couple things on my mind. Are you done?
Yep, take
All
it.
right. So under, give me a second here. I got so many pieces of paper. Under 1102. All right, so here we are. Sorry, 1105E, the abandonment in place requirements. Number 1, it states that we need to evacuate the flow line or crude oil transfer line of liquids. I think we had talked a little bit during testimony about some different language that may capture it a little more holistically, which would be to ensure that it is free from all hydrocarbons and combustibles and is safe and inert. So I would suggest that language or something close to that language. In 1102A, there was a suggestion, an understanding that it's a placeholder, because what we're talking about in these are registrations and as-builts and, you know, after the fact information, but as a placeholder, understanding that we'll be undertaking rulemakings around mission change, and in mission change, we may very well be looking at permitting for flow lines. There was a suggestion for a siting section that would be flow lines and crude oil transfer lines shall be sited in a manner that protects public health, safety, welfare, the environment, and wildlife. If possible impacts to public health, safety, welfare, the environment, and wildlife must be avoided. To the extent and severity of any remaining impacts must be minimized and mitigated. I would suggest inclusion of that language. That's my opinion. And then finally, and this is just a question, under 1102D installation, we've got some very specific things in here about welding specifications and certifications. But in number 1, it indicates that installation crews must be trained in flow line and crude oil transfer line installation practices for which they are tasked to perform. Do we need any more specificity to that as far as what does that training mean? Or do you feel that that's appropriate?
I think, we've discussed various training, and I think the intention was that there would be a future rulemaking where we would go into more detail on all the training referenced in the rules. So that was my understanding. In the previous rulemaking, we quoted the welding standards, and there were discussions. We had a welders union was party to the previous rulemaking.
Yeah, and I'm sure that's why the specificity in the welding is there. I just wasn't sure from an installation crew standpoint whether we were expecting operators to have a training regimen for that, or whether there's, I don't know what that installation requirement would be.
Commissioner, if I may, I think there are a variety of tasks that go into installation of a flow line. And so on the one hand, on the back end, we've ensured that whoever's inspecting those off-location flow lines and crude oil transfer lines verify it. So I think that that's a good back-end precaution. I think we could take a hard look at articulating some more specific expectations around training for the installers through guidance, if that would be an acceptable step.
Yeah, I'm just asking because I don't know for sure. And that could also be happening in permitting as well, right? So just a point. That's all I've got. Thank you.
Commissioner Hopkins.
Thank you, Mr. Chairman. I want to go back to the integrity management and leak detection technology that's been discussed just a few minutes ago, and provide perhaps a similar perspective, but a little bit different perspective as well, just for give my point of view. I think I was looking at the requirements for the crude oil transfer line, and they have the pressure test maximum anticipated operating pressure every 3 years. And I don't know whether or not that's the same. Oh, and I'm sorry. And then it goes to, under the leak detection part, an annual pressure test to maximum anticipated operating pressure. It's on a 1-year basis. That's a relatively long period of time for leak detection. And I do think that with the emerging technologies coming up and such, it's probably a good idea to try to figure out if there's more ways to do non-invasive monitoring for leak detection for off-location buried lines with technology that's emerging. And I think it'll also give us a better frequency and a better way of looking at these things. And the but is, I don't know what the technology is right now that we could put into a regulation to make that happen that would be workable. I don't feel like at least I know I don't have the information I would need to mandate that kind of thing yet. So I want the staff to instruct me if I'm going too far with where I'm headed next, which is I would like to request the staff to go back and take a look at this particular issue and the statements that were made with regard to the city of Aurora and the city of Broomfield on what they do with their leak detection methods that they've gotten operator agreements for. Also take a look at the CSU study and what the emerging technologies are, and then report back to the commission in relatively prompt order to give us a more detailed explanation, a more educated explanation about the status of off-location flow line leak detection technology and where that might go. That would help me become more educated because I just don't have a clue how to do it at this point. So I wanted to put that on the table for the staff, and that's my suggestion.
So Commissioner, if I may, I have a 3-part answer. One is, and Mark has been whispering to me all about this, so if you have follow-up questions, ask him. There are 2 ongoing initiatives where we're working with PHMSA about some of their leak detection inspection, or not leak detection inspection piece, but like leak detection, emerging technology, what's going on in that space. We're also looking, and our agency is working on how it can implement drones into its inspection protocol to be able to verify surface impacts from oil and gas broadly. And then the third piece is the 2 local governments that have operator agreements around leak detection. I think that that's something that has probably good ground for this, for staff to explore and better understand, and understand how it fits into our current regulatory regime. And if that's an area that we could incorporate, as Commissioner Overturf and Commissioner Mesner have made clear that they're interested in exploring. It's not something that we had time to vet in the last month since we kind of were notified about its existence. And I'm trying to gauge like how, and I heard you say we want it post haste, which probably means 6 weeks ago, right?
No, I don't want you to, that's a figure of speech. I want you to do the job right rather than do the job fast. But I think I realize there's resources and it takes time to do these type of things. I just would looking for a commitment that that's something you're willing to do and provide that information to the commission within the framework that this commission's alive.
You know, it may be interesting later on to call up industry to see what percentage of folks use, smart pigging and stuff, and if it's uniform or what percentage or what the challenges are. I'm sure there's some struggles with all that, but
whoa, it's dropping. I'm just making this up as we go, but we can commit to do that for sure. And then, we could post that as part of, the mission change rulemaking that we're all going to be involved with. And you can have another look at it at that time. Is that appropriate, or?
I personally think that's appropriate because I think we need to make progress on the issue. And I think that, multiple techniques are fine. More monitoring is fine, but I got to know what it is in order to do that. So I think it's perfectly acceptable.
I'll just have the record reflect that Ms. Overturf is frowning.
That's just my face. If I may speak with my mouth, though, I would say that I think there are certain things that we could do in this proceeding based on the record that's been presented to us so far. But I think, Commissioner, what you're asking for is perhaps a step beyond. And so I guess what I'm frowning about, or what's cranking around in my brain, is what could we do in this proceeding and yet still revisit it in mission change, versus does that even make sense, and should we kick this entire issue to mission change? So that's what was causing my facial expression.
Commissioner Boygan, I'd like to offer my 2 cents on that issue. What I was going to suggest before Commissioner Hopkins made his suggestion, which I endorse, is that if we're going to go down this road of thinking about amending rules 1104E and, or I guess it was D and E, to require some sort of alleged redundancy that doesn't now exist, I would at least want to hear from industry in this proceeding regarding what's feasible and whether it makes any sense to make this change. I personally am troubled by the notion that we have sort of accepted a principle that more is better, redundancy is always good. We should go to the actual utmost of whatever is humanly capable of being done on any of these rules as sort of a guiding principle, as opposed to achieving an objective that we set out to do to satisfy the requirements of Senate Bill 181, which are quite explicit, which I think this draft rule does an extraordinary job of, frankly. And we're getting bogged down in around the margins on detail that isn't necessarily going to result in any greater protection of public health, safety, and welfare. It may create a number of issues regarding implementation, feasibility, timing, whatever it is. So I endorse what Commissioner Hopkins suggested. If this is a real issue, by all means, let's deal with it, but let's get a group together. I think there is an ongoing study group, the work group on flow lines, to consider it, and let's report back. Let's have staff and the work group report back and see what we think makes sense.
Commissioner Hopkins and Commissioner Overturf.
Just in response, I'm trying to look for something that's reasonable and necessary with regard to leak detection. And I haven't found it at this particular point because the technology would have to be reasonably available and necessary. I think it's necessary to do this type of action and look at, but all I'm asking is that we look at it and do some technical studies and come back with some information. I'm not suggesting we address it in this rulemaking at this point. I heard that part, but I also heard that we were maybe working on something that didn't have a solution. Maybe I misunderstood Commissioner Boygan. Anyway, thank you.
Commissioner Overturf, then Commissioner Jolan.
And so I just, at the risk of keeping this going any farther, I do feel like I need to respond to that because I think that my proposal is coming out of testimony that we've heard in this proceeding. It's coming out of the CSU study, which we explicitly asked for in the last rulemaking. We asked for the smartest people to kind of get together and think about whether there were leak detection technologies, methods, programs that were available that we should be considering. And there were parties that raised leak detection standards as part of this proposed rulemaking from the beginning. So I don't think this is a new issue that's suddenly coming up at the last minute. I think industry has had an opportunity to respond to those proposals. So I don't think that it's categorically inappropriate to be considering it as part of this rulemaking. I can see the benefits of taking a more comprehensive view where staff has an opportunity to do some real digging as part of the mission change. But I certainly don't think it's far afield or that responding to a compendium of information from the CSU study is in any way extreme or pushing the bounds.
Commissioner Jolan.
And what I would like to add to that is that my understanding of the CSU study is that it indicates that there may be different types of materials that have different frequency of leaks and some other factors that decide where we're more likely to find leaks and less likely to find leaks. So sort of to split the middle between some differing opinions about how far do we go and then are we tasked with going that far, there may be some stratified answers, which has to do with taking the information in the study and saying in these circumstances, and this would probably go to the work group and to the further study and potentially part of mission change, but I would like to see it looked at from that lens, which is, is this type of material warranting this type of more frequent leak detection and this type of material not? It seems to be some differences.
Mr. Chair, just to sort of defend myself, I wasn't suggesting that this is a brand new issue. I recognize the issue's been in the record. Staff, however, in their latest proposal, recommended that we not deal with it immediately and that we continue to study the matter. And so if we as a commission are going to override that consideration, that recommendation and consider it now, I would like to hear further from industry and any other party that has relevant information to give us about pros and the cons of changing the rule the way it's been proposed. And maybe there's another way to change the rule that's even better than what's been proposed. I personally don't feel qualified to have an opinion on it right now. And so if we're going to dive into it, let's dive into it and get the parties back and talk about it.
Yeah. Dr. Robbins.
So I think we need to get some thumbs up, thumbs down consensus of the commission as to what it would like to do with this. you certainly have the ability to call back up, an industry representative as well as some of the stakeholders that were advocating for this. We could give each side 5 minutes and get further perspective. If that's the desire of the commission, I guess we kind of need to get a sense of, the staff's perspective was no change, but we are certainly happy to follow the direction of the commission as a whole.
Well, I'd say not just on leak detection, but let's make sure we're done with the presentation. We could take a break. We could always call up groups with follow-up questions on other issues too while everyone's here. Yeah. Commissioner Hahn.
I think that's a wise decision, a wise approach, because everybody's here. We're on topic. Let's just go for it.
Commissioner Messer.
Wait till you hear what I have to say. No, thank you. I just want to be clear that the recommendation that I'm making isn't to blow up the rulemaking or to bring up, a bunch of new information. It was to place the word redundancy in there. And so as I'm looking at this, some of the integrity management stuff we've got in here is an annual pressure test every 3 years, or continuous pressure monitoring, or smart pigging every 3 years, or annual instrument monitoring conducted pursuant to Rule 1104J2. And so all I'm saying is that it needs to be 2 of those. So every 3 years, there has to be a test on one thing. The other 3 years has to be a test on something else. And it's just a redundancy thing. It doesn't seem to be particularly burdensome or problematic, and it doesn't require any new technology. Now, I do think there's probably new technology in there, so some language around best technology available or best practices or something like that could be helpful as well. But I don't think this is an outrageous ask for redundancy.
Yeah.
Yeah, Ms. Berge.
Commissioner, so I understand your comments. You're speaking specifically to 1104F or integrity management?
Well, I mean, some of that language is, I just pulled 1104F, but some of that language is redundant in some of the other sections as well. So as I look at, 1104E, 1104F, 1 and 2, 1104G has some similar things, but I think my point is that we're appropriate in these to encourage redundancy, right? Because I think that the check and balance is not uncommon in industry across the board as far as ensuring public health, safety, and welfare.
And the reason for my questions, Commissioner, are that those different subparts relate to different types of lines.
Understood.
So for me to be able to carry out your vision means I need to understand fully what it is, and is it redundant for every single flow line and crude oil transfer line? Is it for some? We do treat crude oil transfer lines differently. We do treat off-location flow lines differently, and so trying to understand that perspective. And then the other thing I wanted to offer is when we talk about best available technology, in 2008, this commission was quite wise, if I might add, to include subpart D around annual instrument monitoring. And that provision was included to provide the flexibility for operators to come forward with the best available technology as one of the options for integrity management. And so I want to convey my perspective, at least, that we do have the tool to accommodate the best available technology. So.
Commissioner Overture.
I want to just be clear that I'm agreeing with Commissioner Messner, and that when I brought up this, I feel like I opened this Pandora's box of redundancy. My thought was very simply to change in 1104E1, in 1104F1, and 1104F2 to change the word 1 to the word 2. That was the extent of my proposal. I think there are other things that we could look at in terms of updating the technologies that are available and looking at other forms of leak detection, and that may all be appropriate for a mission change rulemaking. But this conversation has gotten much bigger than my initial proposal, which was to just require 2 of those things that we've already identified as workable options.
And Commissioner Ortrup, if I may ask, would that include 2 annual pressure tests per year, for example?
No, you would have to choose 2 of those options.
Okay, so what I propose is commissioners take a look at what we have before us right now. This will give staff some time to chew on everything you've heard so far. We can think of other questions for staff. We can think of if we want to bring up the parties with specific questions, because once we close, we're going to lose that opportunity. And also as commissioners make recommendations, I want to be clear that we're all in agreement too with what's being proposed. We may be voting too. And we're not at that stage of really, going through each rule and so forth, but I just want to make sure we're not directing staff on issues that maybe there could be split votes on. So, so with that, let's take a little break. Commissioner Egan, you have something you want to share?
Well, I had something before this conversation started that I just wanted to ask about. Can I do that before we break?
Sure.
Okay, so in 1105G, which is the notification to local governments, we basically have a notification provision, but not a comment. You deleted the comment here piece of that. And I, before I saw this, had a question about whether there was going to be a response from the director to comments. So I would like to understand why we've made this change.
Commissioner Eaton, yes. In the revised 1105, in revised 1105 subpart G, we reverted back very similarly to what was existing language with one modification, because in the draft you have before you today from today's edits in 1105D subpart 4, we added language there that specifically requires notice in the pre-abandonment phase to the surface owner and the relevant local government, and that also articulates the opportunity for the local government to respond in the pre-abandonment status. So I think our intent was to preserve that opportunity, but to make it simpler to understand as somebody was reading our rules, and then clarify that once abandonment is complete, that complete, the information that comes into us upon completion of abandonment also goes to Colorado 811 and also goes to the local government. The sub piece of your question about a duty to respond, we have not included a mandatory response from the director or staff to the local government if we receive questions, I think.
But the information would be included in the director's review.
Mm-hmm. Absolutely. And I think would be instructive in the director determining whether to undertake a review. I think would be critically important if we're receiving comments from a local government or service owner to understand.
You don't really say anything about how it will be addressed, and so I'll look at this formulation, and I just want to make sure that they have the opportunity and that there will be some review and response of that to the submissions. So, thank you.
So how much time do you need?
6 weeks.
Yeah.
3:30.
Okay. Okay, let's take a break till 3:30, and commissioners think about what other questions we want to ask staff and if we want to bring up parties for clarification as well. Thank you. Okay, this COGCC hearing on flow line rulemaking will come back to order. Staff had some time to contemplate some of the discussions we had earlier, and I believe had put together a revised PowerPoint, I think. So I don't know, Director Robbins or Chief of Staff Murphy, or who wants to take it over from here? But we're online now.
Yeah, we have two documents for you. One is or three documents. The first that we're going to share with you is the red line, and we have highlighted changes that were discussed by the commission and direction that was given to us, and we're going to go through that right now. So it'll be the first document.
Commissioners, thanks for the time. What I wanted to talk about first was the discussion about the specificity, data, and accuracy of information for flow lines in existence as of May 1st, 2018. We did not make changes to the language. We heard you loud and clear about the best technology for post-96 lines with metallic elements. We think that the ability to use those metallic tracer lines and or metal lines, that would fall into kind of the most accurate data possible category. And so we think that this rule encompasses that opportunity without being totally prescriptive about plus or minus 3 feet. And if you'll bear with me and let me walk through the suite of changes and then we can discuss, I'm losing my touch and losing connection to all of my thoughts. So that would help me. And forgive me, everyone who's getting dizzy on watching my screen scroll, but this is the master document. So again, on sharing with local governments, I think we've incorporated language that I hope addresses Commissioner Overturf's concern, that makes clear that the local government can reproduce or publish the data that the commission makes available on its website, and clarifies that the local government may share the more specific data so long as the local government also treats that as confidential. So that is designed to accommodate the citizen who shows up to a local government's office and say, hey, I want to see my parcel. The local government is empowered to do that, but not mandated to do that. So, and I guess I should clarify where I've highlighted language, that's where we've taken action in our little, quick study session. On the installation and siting question, Commissioner Mesner, I hear you. I worry about implementing language today that will be effective in the middle of January before we have a complete siting protocol and review process. So we have not included those changes here, just as a heads up to you. Yeah, and also I have a software center update and all sorts of really helpful stuff right now. But listen, my computer's, okay, we have 60 minutes, guys, and that's it. And I can't hide it. I'm sorry. I'm just gonna have to scroll through as is. I can't hide. Maybe Stuart's gonna solve all my problems. Nope. I'm trying. So we're just gonna stick with the scroll. We did not make changes to the inspection. So getting to the hottest topic, I think, of the last 30 minutes around integrity management and leak detection. I hear you, Commissioner Overturf. I hear you, Commissioner Mesner. As staff thinks about it, whether we approach this from changing our integrity management program for a number of subcategories of application flow lines and crude oil transfer lines, or whether we approach this from a leak detection standpoint, is something that we would like more time to think through. And we think if you're amenable to Commissioner Hopkins' recommendation to take that up as a robust conversation during mission change, we would prefer that path.
Commissioner Overturf.
Thank you. So I think the overarching message that I wanted to communicate is that I do think it's better for us to do better on leak detection and integrity management. I think there's probably opportunities for us to do better on leak detection in areas outside of even flow lines. And so I am comfortable with having that broader and more detailed conversation as part of the mission change rulemaking that's forthcoming.
Commissioner Boygan.
Second.
Okay, I think
if you need a third.
Okay, you see a thumbs up on that. So.
Thank you. We appreciate that. Sorry, those are my comments about that issue.
You better go fast before the time runs out. Right?
I know you're getting all nervous now. I think the balance of the changes are in a separate red line because I didn't make this easy on myself, but are in the abandonment language. And so recognizing that with the compressed time, I don't want to make a mistake about our internal form process. What I have recommended is that we delete the specification of what form we're going to use and instead say that the notice needs to include documentation. And then we'll solve that problem between now and January 14th with how that information comes into us.
January 14th being the date these would be effective if they are passed.
Correct. Thank you. That's a great clarification. On the federal government piece, Commissioner Mesner, this is where I think we landed with lines that are subject to the jurisdiction of the federal government and the relevant federal agency directs abandonment in place. I believe that was the language. I'm getting thumbs up at least. This language in D, I think we've captured the concept. We were worried about irreversible being a virtually unachievable standard. And so we thought significant damage made sense. And then thought that Commissioner Mesner, you were trying to broaden the consideration of natural resources that could be impacted by removal from just vegetation to encompass other natural resources. So we tried to include that, and then provide at least the beginnings of the specifics of a list.
And the use of the word including does not mean that it's just those three. So there could be others that we're not thinking about that we could analyze when there is an abandonment in place request.
And then I think this is the last change we made is 1105E, evacuating the line of any hydrocarbons or produced water, and it is safe in.
I'm sorry.
Commissioner Messner, did you see that? I think you
No,
were contemplating.
I was trying to get clarity on a previous one.
And we can slow down, but I just wanted to make sure that you saw this. This
I
was.
do understand we only have 60.
This is how I'm going to run all rulemaking hearings from now on, right?
Yes.
Yeah, Commissioner Messer.
Could I just ask a clarification on the revegetation one? Because I'm having a hard time seeing it a little bit. So there was just an addition of removal of the line, so that successful revegetation has occurred that's not struck, that's still there.
Correct.
Okay. I mean, that's not what I said, but I mean, we can have that discussion, so.
Commissioner Messer, are you all right with that language?
No, I mean, my suggestion, and I want to allow
okay, let's just get through and then
them to get through before I.
Okay.
And so then we also heard from the commissioners, on top of specific rule changes, some guidance about where to put some of the other things. And so we created this quick PowerPoint that the statement and basis and purpose needs to address the conflict between current surface owner and former surface owner under a surface, that should be surface use agreement.
Oh, no.
It's gonna come back. Yeah, right. We also were directed to define invasive methods in the statement of basis and purpose, and to clarify that both the local government and the COGCC can inspect abandonment in place. Those were 3 points in our guidance documents that we would promulgate ahead of the rule becoming effective. We were informed to create the process for review of the abandonment notice. And then in defer to mission change is the siting and permitting of flow lines and leak detection, integrity management. At least that's what staff would suggest. And then we would also do the redundant leak detection would go on this document as well under defer to mission change. And so I think that is the sum total of the changes that we think we heard from you. And at this point, we'll turn it back to the chairman because we need to determine from commissioners, obviously you need to get some sense on these things and then see if there are other areas of the rules that deserve additional attention or scrutiny. The record is still open at this point, and Mr. Davenport will tell us at some point that we should close it, but I think we need to have further discussion amongst the commissioners at this point.
Okay, any further comments about what we've just seen here? You want to, Commissioner Messner, you want to go back possibly to vegetation? Yeah, Commissioner Eaton as well.
Well, there were two things that I wanted to just go back to. One is the revegetation, and you basically left successful revegetation, but took out or in process and made it an or removal would have, right, instead of an and change the, I just want to try to understand what's happening with this. Well,
Yeah, we're noting the hastiness within which we were doing some of these edits. I think that that's a good catch, Commissioner Eaton, is that the and removal with harm was not supposed to be removed, but we were trying to create this new category. And again, this is staff's suggested after listening, obviously is your rule.
well, I think if you changed it to and, successful vegetation has occurred and removal, or you could change it.
There's a fair amount of wordsmithing that needs to occur. I think the fundamental question is, Commissioner Messner, was it your intent to pull the successful revegetation has occurred entirely?
Yes. That was my suggestion, was to remove the successful revegetation has occurred and just include removal of the line would cause significant damage to natural resources, including wildlife resources, topsoil, and vegetation.
And so, Commissioner Messner, if I can ask, the idea is that we would be drafting something that would encompass damage to successful revegetation, right? Like subpart D as revised. Successful revegetation would be one of the reasons.
I think my point is that there are instances where there has been revegetation, and I can think of situations where there's some grass that's been over a flow line, and really the right thing to do for preservation of public health, safety, welfare, and environment, and the de facto thing to do would be to remove that. And that by removing it, it wouldn't cause any irreversible damage to vegetation, because that vegetation in particular situations, could come back within a year or two. Now, there's other situations where you've got cryptogamic soil, or you've got other situations where, going in there again and pulling a line, could cause resource damage that would take a decade to go back, right? And so I don't want to make it de facto that if there's any vegetation over the top of it, that they don't have to remove it. You know what I'm saying? I'm trying to come up with some language that was really clear, or as clear as possible, as far as, it is still expected in these regulations that the default is removal, and that the exceptions are these things. But if we just put in there successful revegetation that has occurred, then any kind of grass that's over the top of this could be used as an exemption. And so that's my intent. And so that's why I did use the word irreversible resource damage. I know that irreversible is maybe not the ideal term, and I do think that significant is probably a better term. But that's my thought process. But I am only one.
Okay. Commissioner Jolan.
Make that 2.
Yeah, Commissioner Eden.
And then the other one that, thank you, and I support this direction as well. The other question I have was on the federal government piece. Okay. What I'm trying to think about is how this applies on federal land and it's specific, because we're trying to make it more broad than just federal land, but that would specify. And I think that one of the commenters talked about, trying to make that be a specific line, but I think that this. Well, here, I guess this is a question for you. It says subject to the jurisdiction. It could be the joint jurisdiction, right? I think the only concern I have is whether we're making it sound like we don't have any jurisdiction over that line. So,
Commissioner Eden, I think that it's important to remember that these are reasons in a notice that comes in to us. And so in the SBP, we have articulated at least 3 things that we would consider important in evaluating this from BLM in particular, a field office directive, a permit condition, or a rule. And so I would hope that an operator would see that and say, oh, this is the documentation I need to provide. And if we don't see that level of documentation, it would raise questions, most certainly. And also,
yeah, in the new structure, it has less. It's less concerning than it was in the sort of initial formulation. So I think it makes sense. Those were my 2 questions.
I mean, that language captures what I was trying to accomplish, and so I do think that that is.
Other folks give it a thumbs up.
Can I just be
Commissioner Overture.
the worst and recommend that we change the and to an or?
Can I get a little guidance as to what or?
The or in D, removal of the line would cause significant damage to natural resources, including wildlife resources, topsoil or vegetation.
Excellent catch.
Second.
Thumbs up.
2 other people willing to be the worst with me. Thank you.
Always. Yes, it's a very good catch.
If we're just, I wanted to, could you go back up to the local government providing stuff to people?
Is everyone busy yet?
Yes.
So I want to just make sure that in sensitivity to, what I heard, the concerns from some local governments that they don't want to be responsible for maintaining a separate database, that what we are envisioning is that this will be accomplished through access through a special portal to the COGCC system.
Commissioner Overturf, yes.
Okay, and I want to just say for the record that for me personally, some may remember that on the last season of Flowline Rulemakings, I had some disagreements with folks about how the confidentiality provisions and whether or not CORA requires that these things be sort of held affirmatively confidential. Personally, I think that the idea that if an individual wanted to see information at an additional level of accuracy, that they would need to log on or register themselves that they had viewed a particular parcel. To me, that feels sufficient. That if something then happens to that line, we have a record of who viewed that information, and you know, we can provide that to the relevant law enforcement authorities or whoever. So I think the must be treated as confidential. I do have some concerns that that is somewhat vague. If an individual goes into their local government office, finds out that there's a flow line in a particular location, and then goes home and tells their spouse, for instance, is that a violation of our rules? What say do we really have over that? So I don't want to belabor this because I also recognize that it's late, but I did want to just raise that as something that we may wish to explore further in developing this portal and figuring out how we're going to implement this whole program.
May I respond a little bit? I hear your concern, and I think that the parties have and stakeholders have articulated the desire to have a disclaimer on our map. And so I think an important feature of that when we make our map available to local governments, and I'm looking at you, Chris Heisinger, is making sure that that same disclaimer comes through that portal to the local government to help remind folks that this is for illustration purposes, and please don't go down.
And then would this be the appropriate time to talk about something else that wasn't part of staff's presentation, or are there other things?
Yeah, I think as long as we're ready to move on, is there anything else in terms of what they captured before we move on? Commissioner Eden?
Right, just one more question. Where the words in person are in here, it seems like we're saying that they can make available data that more than what's available by the commission. I think that.
Motion, no.
Commissioner Mester?
I think you showed it, but I missed it. Was the change in the language around liquids? Let me just look at that quick. That captures what I mean. That's fine with me. I will state that I acknowledge that, again, citing is something that would be contemplated in mission change. I would still recommend including it in this with the language that I had indicated before. But I do understand the meat of that is in mission change, and that's where the discussion would occur.
Commissioner Overturf?
I think there may be some words missing. Evacuate the flow line or crude oil transfer line of any hydrocarbons or produced water and is safe and inert. Do we want to say and ensure the line is?
Yes.
Commissioner Boygan?
How would they ensure it other than evacuating the line? I'm not sure what that means.
or to ensure?
To ensure. Yes, I like that better. Second.
Okay, thumbs up. Commissioner Jolan.
Can we scroll back up to the very first highlighted section that we went through quickly, which was the 25-foot? Right, if that's what we're doing right now, is going over anything.
Well, right now we're focused really on what staff recommended from what they heard before, and then we're going to open it up more broadly.
So I think this fits into that category because we did that one real fast.
Yeah.
Thank you. So no changes here.
Correct, Commissioner Jalan. We contemplated or suggested incorporating into the statement of basis and purpose the discussion that the commissioners had around locating lines that are either metallic or have been located with a tracer line, that using a wand, as Stuart described it earlier, likely provides the best available data. And that would be the expectation.
And so we can have guidance around that. That's not in the rules, but addresses that. That's okay. Thank you. That's clarifying and helpful.
And just for the record, AG Minor, you're keeping track of these guidance, right? Thank you.
Anything else in terms of staff recommendations or information that we directed them to look at before we look at more broader rules? Okay, let's go to more broad now.
I'm sorry.
Commissioner Overturf.
So the one proposal that was made by Ms. Martinez that hasn't really been the subject of much discussion, to my surprise, is her proposed addition of language to Rule 312 that would require that a flow line be subject to a pressure test in accordance with Rule 1104H prior to transfer of ownership. And so I wonder if staff is okay with that change, if you have thoughts about that proposal.
One of the questions that staff has posed to the broader world through its white paper is a question of transfer of assets and what oversight may or should occur. And to me, this question fits better in that conversation.
In the mission change white paper?
Change, yes. Right. I mean, we think it is a broader topic than just flow lines.
Sure, I get that. I would like just to make a note for whichever AG in the back is keeping track of such things, that I think this is a good suggestion that I would like to see further explored as part of the mission change rulemaking, and that my only suggested change would be to be a little bit more specific with the reference to Rule 1104H, and to clarify that it's in accordance with Rule 1104H2. And so hopefully that can go into the mission change bucket. Thank you.
I guess I'll hold my comments on that till we get to it, because I'll have thoughts. I do have and will have thoughts on that issue, but no sense in prolonging this discussion.
Okay, again, we're discussing broader issues, topics, rules. You have questions about, clarifications? I'm sorry, Commissioner Eden? Yeah.
Just to clarify, because I wasn't completely paying attention. So we're done with the staff's proposed changes and moving on into issues that are beyond.
Yes, yeah. I feel like everyone gave a thumbs up in terms of the staff presentation. I didn't see any major concerns, so I thought we would just move on. Is that all right? Okay. So yeah, again, we'll talk about broader issues. You know, we records, everything is still open still. We can ask staff if there's any clarification from any of the parties that are here. There's flexibility to do that still. So Commissioner Messner?
So just for the record, I'm still struggling a little bit with the language around the plus or minus 25 feet, particularly for flow lines that are post 1996, and maybe even more so with stuff that's pre 1996. Although I acknowledge that the number of those is going to be significantly smaller than the flow lines that have been installed since 1996. I understand some of the technical challenges that we're talking about here. I understand some of the issues around the invasive methods that have been indicated that are necessary in order to be able to accomplish that accuracy. I appreciate that the language that you're proposing includes the terms "must be the most accurate data possible." I think that's important, and I think that, you know, at one point I heard that there's no middle ground between 25 feet and 3 feet. I just heard now that there actually is middle ground between 25 feet and 3 feet. I'm trying to come up with language in my head that is better and more specific than the most accurate data possible without using invasive methods. And so I'm going to think on that for just a little bit, but I understand that intent. I also understand the problems with just being plus or minus 3 feet, you know, and being really prescriptive with that. So let me work on that here a little bit.
Can I add to that?
Commissioner Eden.
And I've been trying to think about that too. And I think that my thinking is that, you know, for lines that are going to be around longer and are old, that getting more accurate information into the system is better or is important. And so, you know, I've been trying to think about, is there a way to just make these flow lines subject to the existing or to the broader rule at some further date in the future? Because I think part of this is our argument that there's a technological solution, but it's down the road. So, but I continue to try to think about how we could get to the level of accuracy that's consistent across all the flow lines. That'll make the data much better and more useful over time.
Commissioner Jolan?
For the kind of post 1996 or 97, it's not clear to me when the change was made, but is there an industry standard of when a line should be taken out of use, or is that something that is all over the map?
Yeah, it's all over the map. There's different materials, soil conditions, how you've handled it, what kind of coating was used. So you have some old lines that are in good condition. BP down in the Southwest did some destructive testing on their fiberglass lines, and there was no deterioration. Those had been put in the 80s, early 90s. They did have some issues where the lines had gotten stressed due to too much bending when they were installed, and some of the fill was not sufficient. But yeah, it's all over the place. So there are some very old lines that were done after World War II, larger lines that are still in use. So. Commissioner Mester?
So I am going to suggest some language to this. In the last sentence, and I'd be curious to hear your thoughts on this, but some language that could be incorporated would be this GIS, or the GIS data for these off-location flow lines must be the most accurate data possible as determined by the COGCC director without using invasive methods and at a minimum. And the minimum horizontal positional accuracy of plus or minus 25 feet. To me, that would just be a check and balance to ensure that, you know, on a situational, a site-specific situation that there was the most accurate data developed.
Thoughts on that by staff, probably first, and then commissioners. Director Robbins.
We were just mumbling amongst ourselves about how we would accomplish that. You know, I think, you know, first blush it maybe is working with my engineering staff and developing through guidance documents what is meant by that, so that we have various types of flow lines or dates of flow lines, and we could create buckets in terms of how that would be implemented. Again, at first blush, my initial response is I wouldn't want to be, you know, like having discussions with each operator about a particular flow line, but rather to create ideas.
Commissioner Overturf.
I think your idea about guidance that provides some sort of categorical direction to operators is a good one. I think one of my concerns with the as accurate as possible is that it is kind of squishy. And if an operator comes in and says, well, yes, there's a tracer line, but I think the easement is going to be a better way to do it. You know, I'm not sure how you would resolve that potential dispute. So whether the language that was proposed by Commissioner Messner is adopted or not, I think this would be a really valuable thing to add to the guidance list about, for these types of flow lines, this is the presumption of what you need to be doing and what the most accurate data possible is at a minimum.
Commissioner Jolin.
Yeah, and I would like to second Commissioner Overturf's ideas.
Commissioner Hopkins.
I guess I can live with that kind of addition. Although I guess I feel a little let down in that we've been talking about this thing with a lot of stakeholders in a lot of different ways, and kind of it somewhat looks like you're punting to the director to do some more research in the area and maybe change the game plan. But I guess if it goes into a guidance type area that provides some discretion, I think I can live with the change. It's just a little disappointing, that's all.
Let's have the language up there. Let's see.
Yes.
Okay, there's it. Okay, there we go. Yeah. Commissioner Messner.
Commissioner Hopkins, are you disappointed because you want to see it plus minus 3 feet, or what makes you disappointed?
What makes me disappointed is we've had a discussion, and we've got it in front of us, and I'm not going to say which way I go at this particular point, obviously, but I do think we've had a good robust discussion on it, and I'd like to see it in the regulations if we can agree on it. If we can't, like I say, I'm willing to live with it. Because I don't know if I'm answering your question, but I'm doing my best I can.
I guess I'm just confused that you want to see plus minus 3 in the regulations, or you want to see plus minus 25 in the regulations?
I want to see, my goal is to get this the best information we can in the fastest time period we can. And so I'm concerned about toying with the idea when we know that there's trade-offs. We've certainly heard that there's trade-offs between more and more accuracy and the time it would be required to do those things. And I guess when I do the weighing of those things in my mind, I think time is of the essence. I want to get this out to the public as fast as we can with the best that we can. And I just don't want to have things that might be used to lengthen the process of getting the mapping out. So that's about as transparent as I can be.
No, I appreciate that. I think I'm not suggesting changing the timeline at all. And you know, if anyone, I think I'm trying to come to a compromise with this language because I still do believe that plus minus 3 feet is the way to go. Personally, I know that may not be palatable to the majority here. So I think that this does accomplish what ultimately my goal is, which is the best and most accurate data available for the citizens in the state of Colorado. And so I think that is what my goal is. And I think it can be done in the timelines that we have in here.
Did I respond?
Sure. Yeah, Commissioner
Sure.
Hopkins.
Yeah, I don't disagree with the ultimate goal at all. But I think we're going to be starting a journey here. I view this more as a journey down the process. And I think I have, with the plus or minus 25 feet, some type of clear direction to the industry in terms of what the quality is that we need, et cetera. We've had a good discussion. But that doesn't mean that I think that's the end of the journey. But I think as things improve and this whole issue evolves over time with right to know and giving the citizens the best possible thing that's possible, I don't have problems revisiting it. But and again, I could even live with what you're doing, Commissioner Messner. I don't want to say that I'm not all to be opposed. I just wanted to express my point of view.
Sure. Commissioner Jolan.
And Commissioner Hopkins, to address that, plus or minus 25 feet and the most accurate data as possible does not feel like clear direction. So I think that some of this is an attempt to clear that up. You're saying that you like plus or minus 25 feet because it feels really clear. And I think having both of those in one sentence feels less clear, as Commissioner Overturf likes to describe it as squishy. So I think that's what we're trying to kind of move it towards something less squishy.
Commissioner Hahn.
Well, I just wonder if we should remove the as determined by the director.
That's where we were before.
Yeah. I mean, but I think we need without invasive methods because I think I wouldn't want to think that we're going to encourage potholing.
Commissioner Hopkins.
I support Commissioner Hahn's impression because I think it gets squishy when you leave it to the discretion of the director. Myself, and you've got a regulation there, but I guess like I say, I'm willing to defer to both the other commissioners and the staff, but it just gets more squishy when you leave it to the discretion from the director. I don't think we'll always have as good a director as we have with our current director, who's been doing a marvelous job. I certainly trust his discretion. I'm not sure I trust the next director's discretion as much as I trust this one.
Commissioner Overturf.
I guess I have a question for Director Robbins is that do you think there would be value in promulgating guidance on what constitutes the most accurate data possible, regardless of whether there's a reference to the director in there?
I think whether the as determined the director is there or not, that's probably what we would need to do, is to put through guidance some additional information around what we expect.
Anyone else? Commissioner Jolan.
What is your suggestion for the best way to memorialize in the rulemaking that that's something that's important to this commission?
I don't think I mean, I appreciate the distinction, but I think in implementing this, it's a distinction really without a difference whether the language is there or not. not to undercut the significance of the language of Commissioner Messner. But it just, I think it puts a fine tooth on the fact that we're going to have to work with operators to ensure that the most accurate data is indeed generated.
So, Commissioner Messner?
And I would just point out that without, and maybe it's not true, but without explicitly calling out somehow that direction and determination and guidance is coming from the Colorado Oil and Gas Conservation Commission, then that determination and guidance is actually coming from the operators themselves. And so I do think that having some understanding, and whether that's in guidance, I would like to see it memorialized. Maybe it inherently is because it is in the rules, but that we're not just de facto handing over that authority to operators to determine what the most accurate data is.
So it sounds like staff's kind of indifferent on it. It's fine either way.
Yeah, either way.
Yeah. Well, we have to make a decision. So thumbs up to keep it, or thumbs down? Thumbs up.
To keep what?
To keep the in by the director?
Yeah. Well, you know, staff is kind of indifferent on that, so I just want
to. Appreciate your support, Howard.
Commissioner Overturf, do you have a comment on?
No, I think it doesn't matter whether you have it in or not. I think the guidance is going to be promulgated, and so if it makes.
So I have it in.
Yeah, I think take it out.
Right.
Fewer words is always better, right?
Everyone all right with that? Take that out. Yeah. I know it's kind of. This is how we're moving the process forward, though. Okay. Other items. Commissioner Hahn.
So Director Robbins, I'm wondering if, are you anticipating being overwhelmed by Form 44s for abandonment in place and operators finding all kinds of reasons to abandon in place?
Yeah. I'll let my deputy respond.
Commissioner Hahn, I think that has been an important conversation that we've had internally as we've evaluated the best processes for submitting information to us about abandonment in place. I think understanding the complete life cycle of the flow line is important, as we've articulated in a statement of basis and purpose. And so there's a balance that we are trying to strike around getting the information into the agency to create a record, should that be necessary moving forward on one level, and also preserving the opportunity to take a review also. And so I think that with the languages we've amended it this afternoon that provides staff some flexibility in how that information comes in, I think we will develop a process that is manageable for us. I think that the guidance, what I hope is that this commission promulgates 1105 D with some semblance of the subparts that are included as reasons to abandon in place, because I think it helps us articulate those reasons for which abandonment in place is appropriate and can move through those types of forms quickly. As we move into arenas that require additional review, I would be very concerned about the staff's ability to process the Form 44 and make a line-by-line determination about whether to remove or whether to abandon in place. Does that very verbose answer help at all?
Well, and I guess I also just have concern that, you know, leadership changes and how some of these stipulations might be interpreted in the future could allow for more abandonment in place than what we're hoping for.
Commissioner, and if I can respond, I think it's important to remember a couple of things. And one of the things that I think is important that staff is committed to today, subject to you telling us to do it on some level, is to come back in 12 months and report back to you about what we're seeing around flow line abandonment, right? When are we inspecting? What are the reasons for? How is it going? And I think that that will provide the next commission the opportunity to take a look at this and whether we've struck the right balance. But I think one of the advantages of transitioning to a professional commission is to have commissioners that are day in, day out monitoring these types of pieces and making sure that our rules are implemented in the manner in which they were designed. So it's a much bigger answer to your question, I suspect.
Any more questions? Any commissioners have any clarifying questions for anyone in the audience as well? We are not in the deliberative stage yet. The hearing is still open. Commissioner Hopkins?
I don't have any burning need to hear any particular issues clarified from my perspective from the stakeholders. But I do not want to, at least you talked about the fact of letting folks perhaps get a chance to have some type of reaction to this in terms of what the changes were. I don't really know whether that's a good idea or not, but at least I wanted to at least raise the issue if we should at least open it up for folks who have a burning need to have a talk about it, a chance to do that. But I don't want to go there if it's not productive.
Director Robbins?
I would suggest that we have 55 parties, and if you were to seek input, that you would need to schedule several more days of hearings. We have allowed all parties to present, and I would suggest that the edits or changes that have been made today are good edits and changes. I do not think that any of them are outside the scope of things that people have been talking about throughout this rulemaking.
Commissioner Hopkins?
I'm certainly satisfied with that. I just wanted to raise the question, and I'm happy with the answer.
You know, folks are kind of looking at notes here and there, but you want to move into, you want to close the hearing yet? Move towards more of a deliberative process yet? Or are there any further questions? I just want to.
So I can make a motion if you like.
Yeah, I just want to get the pulse just to see, you know, and Mr. Davenport, maybe you can read again when we do close what that means, just for a refresher for everyone. You want to let everyone know what that means if we move to close?
Sure. Thank you, Mr. Chair. This is AG Kyle Davenport. You'll be deciding on whether or not to close the record, which means there's no more substantive information from the staff or the parties, no more ability to ask questions of the parties. Staff can certainly be available to make changes to the working draft that you'll go through to the edits and help clarify some things in terms of language or where something appears in the rules. But if you close the record, you are effectively saying that you've got all the information you need. You don't need to hear any more things, substantive information from either staff or parties.
Commissioner.
All right, so I want to ask one more about one more idea that we heard about from a number of folks, which is the consideration of future land uses as you weigh the abandonment in place question. And there was a recommendation to just add the words "and future land uses" in 1105D4. And I think that is an important part of the balancing as we think about the abandonment in place versus the removal. So I wanted to float that idea.
Commissioner Boygan.
Thank you, Mr. Chair. I would just respond briefly to that I'm not sure how we would implement such a standard. How would we determine, how would it be determined what the future land use would be, and what type of land use would affect the decision in what way? It's pretty, to use our new term of art, squishy.
Commissioner Eden.
Well, I think that, there are a number of ways you could do that. You could look at what the plans and the zoning rely on local government to help inform potential future land uses. So that, if there is a decision on the books about the future use of that land, you could rely on that information. That's one thing.
Commissioner Overturf.
If what we want to do is to rely on local governments to provide that information, one idea would be, and I'm looking at the Conservation Colorado red line edits, that would be to include the future land. Currently, the language in 1105G, local government notice, states that they can provide their comments regarding the proposed abandonment's impacts on public health, safety, welfare, the environment, or wildlife. We could also include or future land use there. Just throwing that up.
But the question would be, would that be determinative in any way, just because there is a future land use that somebody is thinking about? When does it get to the point of being determinative in terms of how you make a decision on removal or abandonment in place, and what are the criteria? I'm not necessarily opposed to the concept of considering, I'll just say, land use. In fact, the current Form 2A asks the operator to check the box to determine what the current and future land use is, if I'm not mistaken. It's a relevant consideration, or can be, but I just think that to put it in the rule without considering how we would make the determination and what would be the factors that would be relevant, it concerns me.
Any opinions from staff?
I mean, I tend to agree, Commissioner Boygan. I think there would need to be some understanding of what is meant. Local governments have zoning that defines future land uses. Local governments have comprehensive planning. They have master plans that are a little more vague in terms of what future land use is. They have subdivision planning, et cetera. So,
Commissioner Overturf.
I guess it seems as though this conversation is desiring a level of specificity that we certainly have not provided for any of the other comments that local governments can make. We haven't defined public health, safety, welfare, the environment, or wildlife, and what specific criteria we would want local governments to be weighing in on those things, or how we would evaluate them. To me, it appears to be a solicitation of information that is going to be very fact specific. But if for instance, there's a request to abandon in place, but we know it's going to be turned into a subdivision in 6 months, that may be relevant to the decision about whether the vegetation exception should apply, for instance.
Commissioner Boygan.
I'll just offer up that if all we're talking about is a solicitation of information, or a willingness to receive information from the local government regarding land use, to me that's sort of implicit in the fact that local governments are going to be consulting in the first place. I mean, what else would they be consulting about? So I'm okay if you want to add some language to that effect. I was concerned more about, we're starting to talk about binding language, then I'd want to be clear on how you apply it.
Commissioner Eden, any follow-up on that?
I'm just looking at where you would do that solicitation. But really, I think that the idea of soliciting that is to get the consideration, as Commissioner Overturf said, of some of these factors relative to land use. So how to.
Well, again, I'm sorry to jump in, but
yeah, Commissioner Morgan.
Putting it in 1105G, I have no objection to that. That's fine. I think that's implicit in the current language. If we're talking about going beyond that, that's when I start to get concerned about the other factors.
We should, yeah.
Just to provide some further thoughts on this, in 1105D, 4, where it talks about the relevant local government must provide their comments to the director within 15 days of receipt regarding the proposed abandonments, impacts to public health, safety, welfare, the environment, and wildlife resources. I mean, I would anticipate that that's broad enough to where we would be getting, I mean, land use, current land use, future land use, if that's a concern, et cetera. I think that the local government can use that piece to be able to provide input. Do you want to?
This is Julie. I agree with the director. It would be relevant in any circumstance, and I think that staff is appreciative of and aware of the fact that land use changes are some of the concerns that stakeholders have brought forward. And so with that framework, I think it is something that we would be thinking about as different exceptions come forward, and we can articulate that in the statement of basis and purpose.
That would be helpful. Thank you.
Is there thumbs up on that? Yeah, thumbs up. Okay. Thumbs up.
We'll make sure that the Attorney General Minor adds that to the statement and basis of purpose edits.
He says thumbs up.
Any other questions while we still have staff available? And are folks in a good spot after a few days? Are we ready to move into the deliberative stage and close the hearing, or you all need to take a 5-minute break, or just kind of touching base and see how everyone's doing?
Do we have a draft rule now, a cohesive sort of all in changes set up and ready to go?
It was the document that was on Chief of Staff Murphy's computer that has now been updated. That document was emailed to Mr. Eisinger and myself and Joel Minor. We can get that document back up, but it's the same one.
I'm wondering if we can maybe get it on as part of our packet or on our screens, or I guess if you put it up there, then we'll get it on our screens, right?
Yeah, I was gonna say, let's do a quick break. You can put it on the screen, which will go on our screen, and we can just make sure everything says what we think it should say. And
yeah, I mean, I'd sort of like to have the, oh, I'm sorry.
You're all right, go, yeah.
Well, yeah, I'd like to have the document myself so I can go back and forth in it during the discussion and not just be, hostage to whatever's on the screen.
Yeah.
Not that bad.
I remember the thumbs up that you gave though, so I remember that. Commissioner Hopkins.
Could we accommodate eyes that don't like computer screens and get a hard copy for folks who are kind of old fashioned with a hard copy?
Ms. Murphy?
Commissioner, if I can get 10 minutes, I need to consolidate documents. I'm going to remove all the track changes so it's a completely clean version, no highlighting, no red lines, and make copies for all the commissioners, get it queued up on the screen so that all of our parties know what's going on. But I probably need at least 10 minutes to do that.
Should we come back 5:15 or 10 after 5? What's realistic?
I think 10 after 5. I just confirmed with Hannah that we can get hard copies for everybody.
Okay.
And we'll probably get it emailed to you as well for those that would like to see it on your screen.
Okay. Do we want to close the record before we break? You can move this along?
I'm
Yeah.
sorry, a red line to what, Commissioner Boygan? To existing rules? To
Yes, the existing rules.
Okay.
We have the whole
Shebang.
new rule, but all the new proposed changes.
Okay. So you want 2 copies, 1 clean and 1 red line to existing, or just red line to existing?
Red line, fine.
Just red line to existing.
For me, that's fine.
Okay. Great.
That's fine.
Okay.
If we close the record now, some people may feel that they can go home if they want to. You don't have to.
Are you proposing a motion?
I would move that we close the record.
Is there a second?
Second.
Is there any discussion on this? Seeing none, all those in favor signify as aye.
Aye.
Any opposed? Seeing none, we've closed the record and we will come back at what, 10 after 5? Okay.
So yes.
No, I'm good, thank you.
So no that.
So let me see. Can I move
Okay, we are going to come back, COGCC meeting. Before we took a brief break, we did close the record. And before us, we have an updated version of the rules. And I'm looking at Julie Murphy. So, Ms. Murphy.
Thank you, Chair. Commissioners, you have a hard copy in front of you that does not have one change that I told you that I was going to make. The red line that Chris is pulling up and that is available online includes this change. And it is in, it would be on page 21 in subpart D2, directly above 1105G. Page 21.
Page 21.
Yes. Subpart D, Roman 2. I told you that we would clean up the language about a registered PE where it's the direction of a PE. I forgot that change before I sent these to print. I've made that change, so now it mirrors the language around being a registered professional engineer in the state of Colorado or works at the direction of a registered professional engineer in the state of Colorado. So I want you to know that that's the one difference between the hard copy in front of you. The red line that Chris is pulling up, which is the red line available to the world on our website, that is the correct.
Great. Thank you so much for the quick turnaround on this. Amazing. Yeah. Okay, commissioners are looking over the new document we have before us. And let us know if there are any questions.
Increase the size.
Yeah. Keep going.
21.
And for folks listening online, we are just looking over the new printed out version that we have before us. Director Robbins?
Yeah, Chairman Gibbs, I just wanted to inform the commission that Commissioner Putnam is on the phone. He has an ability to speak if he so desires, and he has a copy of the red line as well.
Great.
They're reading. Should we what?
Commissioners, let me know when you're ready with motions or deliberations.
Mr. Chairman?
Yeah, Commissioner Putnam? We are just...
While people are...
Yeah, I'm sorry.
While people are finishing up, thank you. This is Commissioner Putnam. I just wanted to flag a couple of typos before anybody makes a motion or starts addressing other substantive issues.
Please.
So in section 1105D2, on the, I think, 6th line down, there needs to be a space between the word to and public.
Okay.
And then in that same section, but sub 3, on the 2nd line, where it makes reference to sections 2, I think that should be singular section 2.
Okay. Thanks, Commissioner Putnam. Anything else you noticed?
I had one recommended change. Let me find the right section. It's in section 906B2. 2C. This is related to reporting of spills. So there's a proposal in the draft rule to include a new description of threats to waters of the United States, residents or occupied structures, livestock, or public byway from the spill release. I would suggest before the or, including the phrase air quality, comma.
Seconded.
Is it a thumbs up for everyone on that? Does everyone see where we're at? Page 26. Way in the back. Mine's, you want to do
Yeah, once to insert towards the requirement, so livestock air quality, comma,
We have it on the screen too. So did everyone see that? Proposed changes, everyone all right with that? Thumbs up? Thumbs up, thumbs up? Okay. Make sure. Oh, that's true. Thumbs up. Commissioner Putnam, anything else?
Thank you, Mr. Chairman. I had one other comment to make, but not a proposed change at this point. I think allied local governments had recommended a new addition to Rule 1105 that would require a certification by a responsible official, similar to what's done in our air quality regulations. And my recommendation on that, I think it's an interesting suggestion, but one that didn't get a really thorough vetting from the stakeholders, and also one that I think is not limited just to the flow line issue. So I would suggest that when we return in future rulemakings to enforcement and related issues, that this be one of the issues that could be taken up at that point.
Okay, noted.
This is AAG Joel Minor. I have another typo to flag for the commission. This is also in 1105D2. The original version of this referenced a field operations notice form 44, and that, 42. That reference was removed from the first sentence, but the reference to that form remains in the second sentence. So that would need to be struck. The word field operations notice, it could be replaced with notice and appropriate documentation as used in the previous sentence.
Yeah, let's get that, yeah, from the screen.
And then there's a second reference to that once Ms. Murphy has made that. The same field operations notice is also cross-referenced in 1105G. I believe that's, no, okay, that one's okay. Thanks.
Okay.
Ignore that.
Okay. Commissioners, any comments?
I've got one.
Yeah, Commissioner Messner.
Thank you. And this is, I apologize, one I missed before. We did make a change.
What page you at?
We did make a change to 1105E1, which is on page 20, to change that language to evacuate the flow line or crude oil transfer line of any hydrocarbons or produced water to ensure the line is safe and inert. On page 1, 1101A3B, I would suggest we use the same language there, because that one also says just evacuate all liquids. I would suggest that we say evacuate the line of any hydrocarbons or produced water to ensure the line is safe and inert. Unless I'm missing something. Well, this says flow line or crude oil transfer line. So it does need to continue to say depressurize the line. So my suggested language would be for B to say to evacuate the flow line or crude oil transfer line of any hydrocarbons or produced water to ensure the line is safe and inert, and depressurize the line. Commissioner Hopkins?
Yeah, just a question on this. This, on page 1, or on the 1101A, this is in the context of out of service and how it's described. The other one's in the context of abandonment.
Correct.
In place. And abandonment status is the next one, number 4. Now, I don't know if that's significant, Commissioner Mesner, or not, if 3 and 4 should have the same requirements or not. So it's more of a question. They are listed as 2 different statuses.
I agree.
And I'm not sure what the significance of the language is different. For
my point would be the out of service status means a flow line or crude oil transfer line that is associated with an inactive well or the operator has ceased normal operations. For an out of service line, the operator must, and this is in order to be able to put it out of service, isolate or disconnect it from all sources of oil, condensate, produced water, and natural gas, number 1. And B is to, it currently says to evacuate all liquids and depressurize the line. I think we had a discussion previously that liquids probably didn't fully cover what needed to be evacuated from the line in order for either to abandon it or in this instance to put it out of service. And so all I'm saying is that based on the testimony we heard from operators, the concept is to evacuate it of hydrocarbons and to ensure that the line is safe and inert.
Commissioner Eden.
And then 4 gives similar direction for abandoned lines, but in section 11.
Well, it references then section
1105,
to
yeah.
abandon it.
Commissioner Hopkins.
Yeah, I guess I don't have any particular problem with it. I was just noting that it was different language in a different section, but I honestly can't tell you that I think there's a difference between 3 and 4 with regard to what you're talking about. So I'm not disagreeing. It was just a question. The difference between out of service and is it appropriate in the same place, but I think it is. That's the best I can do.
So I've suggested language. I think you can decide whether to accept my language or not.
Can we go over that one more time?
You want me to say the language again?
Yeah.
So my suggested language is to mirror the language that's in 1105E 1, which is to the language in 1105E1 is evacuate the flow line or crude oil transfer line of any hydrocarbons or produced water to ensure the line is safe and inert. In 1101A3B, currently it says evacuate all liquids and depressurize the line. My suggested language is in 11013B to state evacuate the flow line or crude oil transfer line of any hydrocarbons or produced water to ensure the line is safe and inert and depressurize the line. Semicolon and then it would go to C, apply at least that.
Can I, Commissioner Boygan, can I ask a question of staff about that subsection? Because, I mean, I think the language that Commissioner Messner suggested, it makes sense to me if we're talking about inactive wells. What I struggle with on this one is, what does it mean to say the operator has ceased normal operations? Does that mean normal operations of the well? And what does normal operations mean? If it's an inactive well, presumably that means it's not producing. Is there some other type of status or circumstance that renders a well inactive besides the fact that it's not producing? Is it or not producing for some period of time, or what does inactive well mean? I mean, you know, wells are often shut in for repairs or.
Yeah, I think that's what we were trying to
maintenance,
reflect in this section, was the fact that people would, as opposed to a permanent abandonment, people also shut in wells. We do have a definition for the different well statuses. So that is a defined, in terms of wells, that's a defined status.
This is where you're defining it, right? Is there some other place where you're defining out of service status?
This is where we're defining out of service status, but there's also a well status. Well status definitions. So this is out of service definition for a flow line or transfer line. But it says it's associated with an inactive well.
So you're not focused on the well here, you're focused on the flow line.
Yeah, but they reference inactive well. So
right. It's
which is a defined
term.
Right.
Got it.
So that's what I wanted to, that was a point I wanted to make.
And so where it says the operator ceased normal operations, that means of the flow line?
Yes, that would be, they're not operating the flow line.
What does normal mean?
Well, that's, this is out of the PHMSA wording, and they do not define normal operations, but they use it. So that's what I can tell you. This is the PHMSA wording, and its normal operations is not defined by PHMSA.
Okay, and so inactive well, show me where I'm sorry, but show me where inactive well is defined. Microphone.
Talk too long.
I can read you the definition.
Oh, Chris just muted me. Wise. Anyway, the definition of inactive well is in the 100 series for our rules.
Yeah, okay. Can you read it?
Do you want me to try to pull it up? Are people tired of hearing it? Okay. Inactive well shall mean any shut-in well from which no production has been sold for a period of 12 consecutive months, any well which has been temporarily abandoned for a period of 6 consecutive months, or any injection well which has not been utilized for a period of 12 consecutive months.
Okay, so that's a long-term status, as opposed to like short-term shut-in maintenance, repair maintenance kind of.
Correct.
So is it the repair or maintenance that you're trying to get at with ceased normal operations?
Yes.
Because it seems to me the definition of inactive well contemplates a long-term shutdown, right? If you're talking extended shut-in, temporarily abandoned,
Yes.
Or an injection well that's been offline for a sustained period. But aren't you intending this status to apply to those situations where a well is shut in for short-term purposes for whatever reason? Or are you? Is that an out-of-service well?
No, we're intending, if it's shut in for a short time, that would fall under the active status. This is intended to cover the cases where, cases like where the gathering system is too high pressure to produce, so it may be shut in for an extended period of time, and then they plan to produce it later, but they're not ready to abandon it yet.
Okay, so you do then intend to link it specifically to the inactive well definition, which takes me back to the question, what does it mean to say the operator has ceased normal operations?
I think the intention is to reflect a longer term shut-in where the well is not producing, as opposed to a shorter term shut-in for repair or maintenance that would still, the well would stay under active status. So this would be reflective of a long-term shut-in where the line is not used and not expected to be used for a longer period of time, but it is not yet ready to be abandoned.
Okay, to me it's not clear. It's ambiguous. I don't know what this really applies to, but maybe I'm the only one who has this issue.
Commissioner Hopkins.
To address Commissioner Mesner's actual suggestion about changing the language on 101A3B so that it's consistent with regard to mentioning, instead of all liquids, hydrocarbons, and then fitting in the idea that it's the same concept with regard to the line is safe and inert. I think I'm fine with that, because I think in the context of the way Dee talks about, I don't see a difference in the end result. And I think if you want to have the language parallel the other one, I don't have a particular problem with it at this point.
Okay. Yeah, I guess I wonder if there's any, is there a difference?
I don't see.
Okay, thumbs up. Okay. Let's continue with deliberations. Any other items that folks want to raise and/or motions or comments or all the above? Commissioner Hopkins.
Just a comment on process. Maybe you're doing this already and I'm just a little slow to catch on. But I was hoping that we might be able to do this section by section in an organized way. And you know, let's do 101A first, come up with any thoughts, go on to 101B type of thing. Are you going to do a more broader approach?
What I'd prefer to do is everyone look through it and you let us know what you have problems with. Silence is approval, or else we'll be here another day. So I just want you to look.
I appreciate that.
Yeah.
I appreciate the guidance.
Yeah. So. But take the time you need to look through. I don't wanna- Commissioner Hopkins.
Okay, with those guidance, I do have a question on page 16, 1104G, leak protection, detection, and monitoring. I obviously missed the discussion about all location flow lines must have a program for monitoring or detecting leaks. I don't know, I don't remember the discussion. I don't particularly have a problem with the addition. It was my fault. I missed the discussion. My apologies.
Commissioner, that's my mistake.
That is a mistake? Okay, so you don't intend to can have that in there?
Correct.
Okay. Okay, so that's just struck. The typo type thing.
Let's get that in front of us so we can see it.
What is the citation? I'm sorry.
Page 16, 1104G. No.
Three?
It's 1104G3
Yep.
on page 15. And I just hadn't heard a discussion on that, but it sounds like it might just be inadvertent. I mean, that's fine, because that's consistent with my understanding. But I just, when we should strike that. Okay.
Here, thumbs up.
Thumbs up.
Yeah, with the understanding that we're going to be having a more thorough conversation about leak detection and the mission. And that's all this others.
Yeah.
Oh, absolutely.
Yeah, good catch.
Thank you.
Commissioner Hopkins.
Yeah, just addition, one point of clarification. On page 22, comprehensive drilling plans, looks like the whole thing is struck relative. So basically there's no, and I think when I read that, there's no changes to the current way 216 is written.
That's correct. We
Okay.
have recommended deferring that conversation to the mission change rulemaking as part of the
So I'm
process.
reading it properly.
Yes, sir.
Okay, thank you.
Any more questions or comments?
I have,
Yeah, Commissioner Jolan.
I have one thing about this page.
Yeah, please.
Is this an appropriate time for this page?
Yeah, it is.
So under direction to, I think this would go into directions to staff, and I'm sure this won't get lost, but we had a considerable discussion around gathering lines and interactions with the PUC, and I think that should at least be listed here. I'm sure there'll be more to come on that.
Yeah. Thumbs up, everyone.
Yeah, it should, I think, reflect that we direction the staff to work with the PUC and ideally in advance of their rulemaking to, and also to, provide our expertise and the model of our rules for their rulemaking.
Commissioner Boygan.
I go to 1105. I mean, it's really the only place where I have any comments. If you want,
Please.
we'll launch into those. So 1105B on the bottom of, I'm looking at the red line, the bottom of page 18.
Bottom of 19.
Is that bottom of, it's 18 on mine.
Oh, 18, okay.
Yeah. So I'm trying to get a handle on this concept of abandonment and what constitutes abandonment. And it also links back to the discussion we had a few minutes ago on inactive wells. It says upon removing a flow line, this is 1105B, upon removing a flow line or crude oil transfer line from use with the intent to abandon. So that's focusing on the flow line, not on the well. In other words, if the well doesn't say, although it's sort of implicit, I guess, that if the well to which the flow line is attached is abandoned or should be abandoned, then the flow line likewise should be abandoned. This is focusing on the flow line itself. Because you could have situations where a particular line is abandoned where the well is still producing in some other way, correct? Okay, so what you're saying here then is the operator's subjective intent has to be to abandon the use of this flow line.
Yes, sir.
In order to trigger all the abandonment requirements.
Yes.
Okay. Sort of leaves the obvious question that there may be no way to answer of how do you determine what an intent to abandon is, and how do you enforce an abandonment in a situation where it has been abandoned, but the operator is not right. Well, the operator's not doing it. So is that to say the operator, by not doing it, the operator doesn't have an intent to abandon, or are you relying on the operator's subjective intent in all cases? If not, how else do you enforce a requirement that a line be abandoned? And frankly, to me, this is the crux of what happened to Aaron Martinez. This line was described as abandoned, but there apparently was not a real intent to abandon it, or at least it was reactivated. So did the operator at the time have the intent to abandon and take some sort of half-hearted steps to do it? Maybe they were in full compliance with the procedures at the time. I'm not sure. I have the sense from the report that maybe some of the steps that were reported to have been done were not done. So I'm just trying to understand here what this means and how do you enforce it?
Can I address
Commissioner
that?
Hopkins.
If you go on to read the rest of it on page 19, if they have the intent to abandon, what I think the applicable requirements are that they're trying to get to in that case is the out of service. I don't remember what USLAT. I can't get the whole phrase there, but I know it's make sure it's tagged and everything else. So I think it's basically applying this. I guess it's a PIMSA related requirement for that. No, okay. For the flow lines, it's talking about what needs to be done. Right. So it starts an affirmative process what the operator has to do. So I'm not sure they can use it as a dodge rather than to use it as a start of a process. But that's my quick.
Clearly, it's yes, they have to do it, but they don't do it because they're not intending to abandon the line, even though, to all appearances, the line's been abandoned.
May I?
Commissioner Overturf.
I think it's important to read it in context with 1105A above, which is that if you, insofar as I don't think there is an enforcement gap, which I think is your fear, Commissioner Boygan, because if they don't go through all the steps to abandon, then they're still subject to all of the requirements in rules 1101 through 1104 until all of the conditions of abandonment have been satisfied.
Good point. And so if this goes back to Commissioner Messner's language about inactive lines, presumably the line has been inactive, therefore it will have been purged and disconnected from an active hydrocarbon source. So that's good. It could be reconnected. What I'm trying to avoid is obviously what happened, which is the notion that you'd have a line sitting out there for an extended period that where the risers haven't been removed, hasn't been cut off, and could be reactivated. And I guess what you're saying is, well, if you do that, if you reactivate an inactive line, you have to file the report, pressure test it, and so forth, which is good. And maybe the question I'm raising is an unanswerable question, which is how do you sort of make sure all that happens? And so.
Ms. Murphy.
Thank you, Chair. Commissioner, I think we have built in a couple of pieces in the rules. One is that until abandonment is complete, the line is subject to the provisions, as Commissioner Overturf noted. In addition, unless a line is in pre-commission status, is in out-of-service status, which also requires USLOT, or has been completely abandoned, it is in active status. And so any line in active status, then if you look at 1102.0, requires pressure testing and tag out devices. So I hope that answers your question about whether there's a regulatory gap.
I think so. I think the answer you're giving me is that what's new in this new set of rules is enough procedures around inactive lines, out of service lines, so that they can't be ignored, forgotten about. The commission will be aware of them and will be requiring periodic work on them or reports about them before they could be put back into service. If they remain in that sort of inactive status for extended periods, then so be it.
I agree, Commissioner. And we require notice before returning a shut-in
Right.
or out of service flow line so that we can inspect if it's been in that status for more than 90 days, or that's what the proposed rules would require.
Okay. I think I'm okay with that.
Good question.
Okay, good. Thank you. So my next, I will just make the comment that I've stated before, which is this doesn't deal with the question of inactive wells that are shut in for extended periods, temporarily abandoned wells, all of that, which we're going to deal with at a later rulemaking. 1105C on the top of page 19, there's by changing, you removed I guess it was a title. It wasn't underscored. It just said for abandonment, which you took out. So now there's really no lead into this paragraph. So it's not clear when this is supposed to happen. Presumably it's when you're abandoning a flow line.
Correct.
So I guess I would suggest adding that lead in, unless I'm again missing something here. This is 1105C, the beginning of the paragraph, says isolation, which is now the title. And then it just starts off, operators must permanently remove a flow line. Presumably when they're abandoning the flow line. I mean, it's implicit, but never stated.
Commissioner Bogan, can you, I guess you're making recommendations on language. Let's make sure we see what the language looks like.
Well, what was implicit to me was it would say when abandoning a flow line or crude oil transfer line, operators must remove it. I would guess then you'd have to repeat it again. Or it must be, well, yeah, then the rest of it could stay the way it is, but
Just take a look up there and make sure it's what we're on your computer. I don't know if you have Zoom on your computer.
when abandoning
Just a second.
Oh.
Yeah, that's what,
is line a defined term? But, I mean, I would just say when abandoning a flow line or crude oil transfer line.
Commissioner Hopkins?
I was just going to make the observation for Commissioner Boygan that the title of 1105 is abandonment, and they talk about the first step is you're subject to all the rules until you complete the abandonment requirements set forth, and then it talks about the intent to abandon. So it seems like that lead-in that you're looking for may be there already, but I'm not going to presume that's the case. If you'd like to see some more specifics.
Well, it's sort of lawyer persnicketyness that we don't rely on titles or headings for substance. We actually like to have the substance of the wording stated in whatever section.
I'll be happy to support whatever you decide.
I mean, it's obvious this is a whole section on abandonment, right? So we're talking about abandonment.
And there's steps in the process
Right,
that I think are
right.
outlined.
But still, and yet, I feel better if there's a lead-in to this paragraph that describes when we have to do this.
Okay, thumbs up.
If I got Commissioner Overturf, I'm happy.
I just want you to be happy. That's all.
Okay, well, bear with me. I've got a couple more of these, and I'm probably being unduly picky, but it helps me to go through this exercise. I had the same reaction when I looked at 1105D. again, this is part of the abandonment process. And it particularly starts to get a little confusing to me when I look at the way this is worded, the lead in 1105D, because it says operators must remove the flow line or crude oil transfer line and the risers, blah, 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 and above ground equipment, except where abandonment in place is less impactful. And I think the except is not supposed to qualify the requirement that you remove the risers. In other words, I think you've got two different things going on in the sentence that have been sort of combined. In other words, you've got, here's what you do if you're removing it in place. And then later on, we deal with what do you have to do when you're, excuse me, this sentence is supposed to apply only to removal, as I understood it. The way it's worded, the inclusion of an exception where abandonment in place is, so that is intended to be an exception to everything that's come before. You don't have to do any of those things.
Ms. Murphy?
Thank you, Chair. Commissioner, that's an important point, but I believe that we cover those same abandonment requirements as part of 1105E.
Right.
In subparts 3, 4, and 5.
Mm-hmm. Well, I just find this really confusing. If I'm the only one confused, I'm happy to defer to the rest of the commissioners, but I wouldn't word it this way. No, I don't even see why you need the exception. Or you could start out by saying when abandoning a flow line in place, blah, 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 period. Or when abandoning a flow line, because it applies to all abandonment, right? Whether you're removing it or abandoning it in place. Is that correct or not?
Ms. Murphy?
My concern is that it says operators must remove the flow line or crude oil transfer line.
Right. Yes.
And so if
agreed.
you are
That's
abandoning in place, you are necessarily not removing.
Yes, right. Okay. So, but you are, in either situation, you're removing the riser. Is that correct?
Yes.
And the above ground equipment.
Yes.
So the exception to those things is really not, like the exception applies to all of it, not just to removal. That's what I'm trying to get at.
Yes, you can put that clause.
Commissioner Eden.
Sorry, you can put that clause after crude oil transfer line, comma, except where abandonment in place is less impactful, blah, 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 comma, its risers, the risers associated on the above ground. Because you're only wanting that exception to apply to the line itself and not to the associated equipment.
Is that language you're proposing? But Commissioner Boygan. Take a look at your computer to see what Commissioner Eden proposed, to see if that's what you're looking at.
Yeah, I still have concerns with that the removal of the riser and the above ground equipment follows the exception, except where, so I see what you're doing. I'm not sure if that's better or not. I'd get, and I would take the comma out after risers. You could say, okay, operators must remove the flow line or crude oil transfer line and its risers, except where abandonment in place is less impactful, comma, and shall remove the riser associated with cathodic protection above ground. I don't know if that helps it or not.
Just to clarify, the and its risers, I intended that to be after the clause, so it would just say remove the lines except, and then, and the risers, blah, 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 and all that.
Yeah, no comma.
Oh, and no and, right? It should say line, comma, exception, it's risers, blah, 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 blah.
No, take the, no comma after line. Yeah, step floor granite. And then you go into the risers and I think so, but I don't know. I mean, see what anybody else, how everybody else reacts.
Commissioner Hopkins.
My reaction when I read it is that the purpose of D is really to get out the presumption that they must remove the flow line, which is kind of the, what's the word we're looking for?
Yes.
The presumption. So I think this, the purpose of this is to put in presumption for removal.
Yep.
And then they put in the words about the risers, et cetera. And then I think they just want to make a distinction between that and then abandon in place, which is this, let's put it this way, I don't know, a second preference, a different process. And then they describe it later. So for me, that's when I read it, that's the way I read it. And I don't find it that confusing, but believe me, I don't want to.
Well, how about this? Let me propose this then. Do a lead in to that sentence saying, subject to subparts 2 and 3, operators must remove the flow line and its risers, and above ground equipment, period. So instead of using the language, except where abandonment in place is less impactful, it's articulated in 2 and 3, you would just start the sentence by saying, subject to subparts 2 and 3. And then you would have the rest of it go the way it is until equipment, then you put a period. Does that work? Is that better?
In my opinion, no. I think it's written very clearly, but I'm not going to quarrel.
If I'm the only one who's got an issue over this, then, you know, fine, I'm happy to go on.
This is the same thing, but
It makes the presumption more clear. I'm good.
okay, thumbs up on this.
On which? Oh,
On Commissioner Boyden's suggestion.
Yeah, your thumbs up. Yeah. Thumbs up to the proposed language change
That language off that's on the screen.
on the blue. Okay, Commissioner Boygan, you're on a roll. Anything else?
Commissioner Hahn still thinking.
Commissioner Hahn.
Sorry. I'm not crazy about this wording either. I think I prefer the original to what we have up here.
Okay, well, if I'm the only one who had an issue with it, nobody else does, leave it as staff wrote it.
Okay.
I'm fine with it.
Thumbs up for how staff originally had it. Okay. Okay. Any other comments?
I have a
Commissioner
question
Hahn?
back to 1105B that Commissioner Boygan was talking about. So on the on page 19 at the top, operator must immediately. Do we need to define immediately? I just think that could mean lots of things for lots of people.
I don't think so.
I don't think there's a shorter time than immediately.
I think people could define immediately differently, but
You want to, I mean, if you can come up with a definition of immediately that's better than, you know,
But
more
doesn't use the word
more clear than immediately. When I think of immediately, I think as soon as that decision's made, they go out into the field and do that. And they start that process. At least that's the way I read it. But if there's a better way to do it, I'm open to that for sure.
Well, if we're trustful that immediately is immediately, then
I'm open.
Okay, other commissioner comments?
Is there a process? For
Commissioner
notifying-
Boygan?
Oh, I'm sorry. Is there a process for notifying the commission when this is done?
Ms. Murphy?
When they have the intent to abandon.
Yeah, they apply post-line.
No,
Commissioner
not
Boygan, make sure
specific-
you speak into the microphone so everyone can hear.
Not specifically. We do require the pre-abandonment notice. And so if that occurs prior to the step of isolation, yes, we would.
I'm sorry.
The step in 1105C isolation, if that is part of commencing abandonment operations, it would occur after we receive the pre-abandonment notice pursuant to 1105D.
Talking about 1105C or 1105B?
1105D requires operators to provide notice to the commission 30 days before commencing abandonment.
That's in 2. For on location. Why does 2 say, I'm getting bollocksed up again. Why does 2 say if the off-location flow line will be removed or abandoned in place pursuant to one of the following exceptions? Oh, the following exceptions only applies to abandonment in place. Confusing, but been down that road.
Commissioner Boygan, regardless of the process by which a flow line or crude oil, off-location flow line or crude oil transfer line will be abandoned, we want notice 30 days before those operations commence.
Yeah, I was just wondering whether, when going back up to 1105B, when the operator applies OSLAT, whether commission gets a notice of that or it doesn't matter.
Commissioner Hopkins?
You know, the way I read this is the operator could put that in before they notify the commission that they want to abandon in place as a prudent step. And I wouldn't necessarily have them have to wait till they file the notice 30 days before abandonment. But if they want to apply this technology before they notify the commission of what they're doing, I don't see a problem with that. It seems to me that it would be a prudent thing to do once you've decided to abandon it in your mind or in your policy, in your decision-making process. You do this right away. And then you've got this next step of notifying the commission about what's going on. But I would not want to discourage an operator to have to wait until the notice process to do that. I want to give them the opportunity to do it earlier because I think this is good safety. This is a good procedure. That's all. That's the way I would, if I was an operator, that's the way I'd do it. I just think it's a prudent thing to do. I wouldn't want to limit it by saying
no,
as part of the notice requirement.
I wasn't proposing to limit it. I was just wondering if after they did it, they would notify the commission so that the commission would have a record that this is a flow line that's the operator intends to abandon.
Ms. Murphy?
But if it's not necessary, then.
Ms. Murphy?
Thank you, Chair. Applying the tag, USLA requires applying a tag to the riser, which means all of our inspectors will be able to identify that it is tagged out and the reason it's tagged out. If it's for this purpose, it would be identified as tagged out for abandonment. So I think that we do have, when we have folks in the field, we will know the purpose for the tag out.
When you have somebody in the field.
Mm-hmm.
Yeah, I get it. Look, I'm just, sorry to beat the dead horse here, but I'm trying to avoid situations where you've got lines that are potentially indefinitely abandoned. Nobody knows about them. And then, nobody's following up on, hey, has that line really been adequately addressed? That's really what I'm trying to get at. So if everyone's comfortable that the process here works, great. I'm trying to make sure there's no regulatory gap.
Commissioner Messner.
Mr. Chair, when you're ready, I'd like to make a motion to approve. Are you ready?
Yes, I'm ready.
Okay. I'd like to make a motion of the approval of the flow line rulemaking document as presented. Do I need anything in addition?
As it is up there.
Yeah. Mr. Davenport.
Thank you, Mr. Chair. I just want to make sure that it's clear on the record that we have is there a way to, Ms. Murphy, is there a way to signify this document that Commissioner Messner's motion didn't?
The document that's on my computer that all of Zoom is looking at.
Okay. I mean,
Put a title on it, a date.
I mean, it has a title on the bottom.
I do see a title that's 2019-11-21 final draft proposed rules red line.
Correct.
Yes. I'm
Okay.
going to resave it as a separate document so it's not confused with the documents that have been posted online or that have been sent out previously.
Okay.
Does that naming convention work for you, Mr. Davenport?
Sounds good to me. So that document is the 2019-11-21 final draft proposed rules red line with abbreviated commissioner edits. Commissioner Messner, is that the document you're referring to in your motion?
That is. Mr.
Okay.
Davenport, do I also need to include?
And I would just include, no, we'll do that in a separate
We'll do
motion.
a separate motion.
Yeah. I would also just include with the amendments that commissioners have made during deliberations as part of your motion.
So moved.
Motion's been made. Is there a second?
Second.
Okay, discussion.
May I?
Yeah, Commissioner Overturf.
This is not relevant to what we were talking about, but I've been sitting here for 2 days and thinking that this would be the appropriate time to raise a couple of issues that I just wanted to clarify my position on. The first is that I was somewhat surprised by the number of comments that we received over the course of this rulemaking that questioned the motivation or the rationale for conducting the rulemaking at all. And particularly surprised by comments that accused staff or the commission of having some nefarious agenda. And so I would like to make it crystal clear and to point out for the record that the reason why we're conducting this rulemaking is because we were explicitly and expressly directed to do so by the legislature. And so would point individuals to 30-60-106 subsection 19, which specifically requires this commission to conduct a rulemaking on the topic of flow lines, notwithstanding the fact that we just recently addressed this topic. So I wanted to make that expressly crystal clear. The other thing, although it hasn't come up in the course of our deliberations or our discussion, is that while the jurisdictional issues around gathering lines are complicated, they're certainly not unknowable. And I feel like we have a very good understanding of where our jurisdiction stops and starts with regard to flow lines and other pipelines. And I would, once again, strongly encourage individuals who are disappointed with the stringency of regulation of gathering lines to engage in PUC and PHMSA rulemaking processes that are addressing those issues. So those are two broad and overarching comments that I wanted to place on the record, as well as expressing my sincere appreciation to staff for all of their hard work in pulling this together. Thank you.
Commissioner Hopkins.
I'd just like to say that I'd like to associate myself with Commissioner Overturf's comments. Support them fully.
Any further comments before we vote?
Mr. Chairman.
Commissioner Putnam, please.
Thank you very much. I think one thread that I don't want to lose is based on some of the discussion about jurisdictional and other issues, I think, and given the fact, as Commissioner Overturf pointed out on Wednesday, I believe, that the Colorado Public Utilities Commission will be or has opened a rulemaking on this front, whether in or outside of this particular motion. I think it would be helpful to also direct the director of the commission to send a copy of the rules, assuming that the vote passes, to the PUC to assist them in developing regulations related to gathering lines and other lines within their jurisdiction, and maybe ask Mr. Davenport whether it would be more appropriate to do that in a separate motion.
Thank you, Commissioner Putnam. I think a separate motion would be appropriate there.
Great, thank you.
Okay, we have the motion before us. Any further comments? Seeing none, all those in favor say aye. Aye.
Aye. Aye.
Opposed, say no. Ayes carry. Do we have another motion? Commissioner
Mr.
Putnam?
Chairman?
Yep. Yes.
I'd like to make a motion that the commission direct Director Robbins to send a copy of the rules that we just passed to the Colorado Public Utilities Commission for their consideration in their upcoming rulemaking regarding lines within its jurisdiction.
Is there a second?
Second.
Motion's been made and seconded. Any further discussion? Commissioner Eaton.
And I think we talked earlier about encouraging the staff to work with the PUC staff to engage in the rulemaking as it goes forward. I think that we should be trying to line up all of those things.
Mr. Chairman?
Yes. Commissioner Putnam.
I'd be happy to accept that as a friendly amendment, assuming that the seconder agrees.
Oh, agreed.
Okay. We've heard the motion. All those in favor say aye. Aye.
Aye.
Any opposition? Say no. Seeing none. That carries. Do we have another motion for a statement of basis and purpose? Yeah. Yep. Mr. Davenport.
Thank you. Commissioners, you have a document in front of you. Ms. Murphy, is it this document that includes things about the statement of basis, purpose, and guidance? Is that something that we can all look at together? I apologize for asking that question based on your facial expression. Should I read it? Would it be helpful if
That would be outstanding. I don't have it, I don't believe.
All right.
May I ask sort of a procedural question?
Commissioner Overturf.
Thank you. I was looking through the statement of basis and purpose again, and there's language in there that needs to be updated based on what we've just accomplished. And so I wonder if it would be possible to pull together an updated version of the statement of basis and purpose, and then perhaps have a brief telephonic meeting where we adopted that in the next 24 hours, or longer if you need longer. I just wasn't sure if we needed to do that today.
Ms. Murphy.
My recollection is that historically we've received direction from the commissioners to conform the statement of basis and purpose of the rules as adopted and the testimony and the deliberations of the commissioners.
Okay, my apologies. I thought we had edited that statement of basis and purpose in the past, so never mind, disregard.
Mr. Davenport.
So, Commissioners, you have in front of you a piece of paper that has a number of different things on it, including what I believe is direction from the commission or proposed direction from the commission to put certain things into the statement of basis and purpose, in addition to what Ms. Murphy and Commissioner Overturf just discussed. I'm going to maybe suggest a motion, a couple of motions, I think. The first motion that I'm going to suggest is in regard to the statement of basis and purpose. The second motion I'm going to discuss is in regard to the guidance and the direction to staff on that piece of paper in front of you. So I hope you'll bear with me for a moment. I'm going to try to put together a suggested motion in the okay. Will you recognize
Commissioner Overturf?
Thank you. I wanted to just, it's not listed on our bullet pointed list here, but my recollection was that we did have a discussion about including language in the statement of basis and purpose that future land use information from local governments is an appropriate thing for them to provide to us under the consultation provisions. That was a poor way of saying that, but I think you know what I am referring to. Is it? I'm sorry, it is on there. I'm sorry. I'll stop talking.
It's okay. We're on hour 25 of this.
Commissioner Hopkins.
Mr. Davenport, if you're willing to describe that in the ways you would describe it, and we can go to the motion so moved, I would be happy to participate in that process.
Okay. I think, Mr. Davenport, you want to walk through it?
I'm gonna do my best. I think the clearest way to do this is actually to do two separate motions, one in regard to the statement of basis and purpose, and another one in regard to the guidance and direction of staff. So this is the best I can do in regard to my suggested motion for the statement of basis and purpose. So the motion that I suggest is that the commission direct staff to, or the commission moves to approve a statement of basis and purpose that is in conformity with the testimony, deliberations, and changes to the rules that were made here today, in addition to 4 bullet points to include in the statement of basis and purpose so that it addresses conflict between service owner and former service owner under service owner agreement, to explain the intent behind the language about that there be the most accurate data possible without using invasive message, meaning, i.e. that more accuracy is required for lines with tracers or made of metal, that the statement of basis and purpose clarify that both local government and COGCC can inspect abandonment in place, and finally, that the statement of basis and purpose clarify that a topic upon which local government can comment is current and future land use as part of their comments on the impacts of abandonment in place versus removal of flow lines or crude oil transfer lines.
That almost sounds like a motion.
So moved.
Okay, is there a second?
Second.
There's been a motion and there's a second. Any further discussion? Seeing none, all those in favor signify as aye.
Aye. Aye.
Any opposed? Say no. Seeing none, the ayes carry. Mr. Davenport.
Thank you. The next part of this document is to provide some direction to the staff to conduct certain activities. So this would be my suggested language for a motion is to direct staff to report back in 12 months about the status of removal versus abandonment in place, to review leak detection, emerging technology. I believe we've already taken care of the PUC rulemaking issue in Commissioner Putnam's motion, so I'm not including that in this motion. And to prepare guidance for review of abandonment notice, to prepare guidance in regard to the local government portal, how technology sharing of more detailed information will work, including confidentiality warning in the portal. And finally, what, in quotes, be the most accurate data possible without using invasive methods in the rules means, including specifying additional accuracy for metallic flow lines and post-1996 lines with tracers, and to break out into different types of flow lines and specify what the most accuracy possible for each category is at minimum.
So moved. There's a motion. Is there a second?
Second.
Moved and seconded. Any further discussion? Seeing none. All those in favor say aye.
Aye.
Any opposed? No. The ayes carry. And Mr. Davenport.
Thank you, Mr. Chair. I didn't put this into a motion, but just to make it clear on the record, what the commission has done here is to defer to the mission change rulemaking 3 specific things: the siting and permitting of flow lines, the review of leak detection methods and standards, including emerging technologies and requiring redundant leak inspection methods, and finally, pressure or integrity test when the transfer of assets or there's a change of ownership or change in custody occurs. I don't think that requires a motion, but the commission did have that discussion and deferred that to the mission change rulemaking, those topics.
Okay. No other votes. Before we have a motion to adjourn, I also want to take this opportunity to thank everyone in the room. Many of you have been here since Tuesday with us. It's been long days. We really appreciate, on behalf of the commissioners, all of your feedback, your participation. I want to thank staff, thank the community here, Weld County and Greeley, University of Northern Colorado. This has been a very respectful but challenging last few days. And I just want to say thank you. Staff has been amazing too, how quickly you've been able to turn around information and get that right in front of us. So we really appreciate that. So I believe we need a motion to adjourn.
So moved.
Okay. Is there a second?
Second.
Okay. Does anyone not want to adjourn? Okay. All those in favor say aye.
Aye.
Okay.
Aye.
Adjourn. Thanks, everyone.
Well done, Mr. Chairman.